The Judiciary Committee will please come to order, a quorum being present. Without objection, the Chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. Pursuant to notice, I now call up H.R. 2820, the DREAM Act of 2019, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2820, to authorize the cancellation of removal and adjustment of status of certain individuals who are long-term United States residents and entered the United States as children and for other purposes. Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2820, the DREAM Act of 2019, is vital legislation that would finally provide permanent protection for dreamers, the undocumented people who were brought to this country as children, many of whom have lived here for most of their lives. They are our neighbors and co-workers, they are classmates with our children, and they serve in our military with distinction. It is long past time that we make the same commitment to them that they have made to our country. Many dreamers do not even know that they are undocumented until they reach their mid-teens and seek to work, drive, or go to college. This is when they discover they are unable to work legally, to obtain driver's licenses in most states, or to obtain financial assistance for post-secondary education. Suddenly, the bright futures they imagined for themselves appear to come to a crashing end. In 2012, to encourage these young people to come out of the shadows and to enable them to contribute more fully to our country, then Secretary of Homeland Security Janet Napolitano announced the Deferred Action for Childhood Arrivals Initiative, or DACA. DACA is an exercise of prosecutorial discretion, providing temporary relief from deportation to dreamers who meet certain criteria. DACA has enabled almost 800,000 eligible young adults to work lawfully, to attend school, and to plan their lives without the constant threat of deportation. Sadly, in September 2017, their futures were once again thrown into uncertainty when the Trump administration decided to end DACA. Thankfully, multiple temporary injunctions have partially preserved the protection for DACA recipients for the time being. Just last week, the Fourth Circuit held that the Trump administration's attempted termination of DACA was unlawful. DACA, however, has never been the long-term answer for dreamers. It is a far cry from the permanent protections that they most deserve and need. That is why it is necessary that we pass the DREAM Act of 2019 today. This legislation creates a program to allow dreamers who came to the United States before the age of 18 and who meet other very specific eligibility requirements to earn permanent residence. It is undeniable that dreamers enrich our nation. They are an essential part of our communities, where they contribute to our thriving economy and make America a stronger, more united, and more diverse nation. Dreamers come from many different backgrounds and all walks of life, but they are connected by one common thread: their commitment to this country. If we do nothing to protect dreamers, hundreds of thousands of these young people will remain at risk of imminent removal from their homes and separation from their families. They will be sent to countries where they likely have minimal ties, and in many cases, no ties at all. Having grown up in America, many do not speak the language of their country of birth, and they are completely unfamiliar with that country's cultural norms and customs. It would be manifestly unfair to remove them from the only country they have ever really known and to send them to what is essentially a foreign land. It would also be decidedly foolish to deprive America of the economic and social contributions that dreamers make to their communities every day. For this reason, it is vital that we pass the DREAM Act, remembering that dreamers are our neighbors and our peers, and that more than 3/4 of Americans support congressional efforts to provide permanent protections for them. I would like to thank my colleagues, Lucille Roybal-Allard, Pramila Jayapal, and Zoe Lofgren, the distinguished chair of the Immigration Subcommittee, and I should add Nydia Velasquez, for their tireless efforts to craft this bill and to prepare it for markup. Their steadfast support for dreamers is to be commended. Members on both sides of the aisle, and even at times President Trump, have expressed sympathy for the Dreamers and a desire to do right by them. I say to my colleagues, today is our chance. We have legislation before us that would end the legal uncertainty that hangs over the Dreamers and would provide them the relief they so sorely need. I hope that all of my colleagues will stand up for them when it truly counts and will support the DREAM Act of 2019 today. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. Right now, our southern border is in a state of complete and utter disaster. Over the last several days, Customs and Border Protection has apprehended an average of 4,500 people per day. During the first 7 months of this fiscal year, the number of people apprehended has already surpassed any fiscal year total since 2009. And on one single day this month, 5,235 individuals were apprehended. In April, there were 58,474 family unit members and 8,897 unaccompanied alien minors apprehended, and those numbers will be surpassed in May. The number of single adult apprehensions has reached a 5-year high. Border Patrol has encountered more than 150 large groups, those with over 100 people so far this year. The largest group had upwards of 450 people in it. Border Patrol processing centers are far beyond capacity. ICE detention centers are full. Even the NGOs providing shelter and other aid to migrants are completely overwhelmed. Perhaps the worst part about the flood of aliens coming to the border is the toll on children brought on the journey. CBP has identified more than 3,000 potentially fraudulent family units, and the aliens are admitting that they have either borrowed, rented, or bought, yes, bought a child because they know that if they arrive at the border with a child, they're all but guaranteed to be admitted. Just last week, a 51-year-old Honduran national who had already been deported brought an unrelated 6-month-old with him to ensure that he would quickly be released by U.S. authorities. The crisis is real, and the crisis is substantial. Of course, you don't have to take my word for it. Jay Johnson, the former Obama administration DHS secretary, recently said, "We are truly in a crisis." In April, the Washington Post editorial board said the southern border has bloomed into a crisis that has overwhelmed existing infrastructure and bureaucracy. Even Speaker Pelosi has finally begun to admit there is a crisis on the border. I believe the flood of migrants can be greatly reduced and better protected by enacting legislation to fix the Flores Settlement Agreement, amending the Trafficking Victims Protection Act, and raising the credible fear standard. But I'm not the chairman, and I don't set the committee's agenda. So what have the majority done to address the situation? Absolutely nothing. My colleagues have the chance to help our overworked men and women of DHS, the overwhelmed NGOs, and the American people who believe in our country's sovereignty. Sadly, my colleagues are making us consider a bill to worsen the border crisis by incentivizing more people to cross our borders illegally in hopes of benefiting from the Democrats' mass legalization scheme. No doubt, at this very minute, the smuggling cartels are getting word out Congress is going to legalize people residing in America illegally. When this committee held a hearing on the Dreamers in March, I implored the chairman, give us a bill that legalizes some of the illegal immigrant population and that includes enforcement measures to secure our border and enforce the law inside our country. As I stated then, a bill that grants mass legalization and shuns any real enforcement measures will be opposed by Republicans for this political stunt that it is. Today, my Democratic colleagues are engaging in exactly that. They had a chance to show that they are serious about an immigration solution for DACA recipients and perhaps even the Dreamers they have talked about protecting for years. Instead, today, we are considering a piece of legislation that is simply a disingenuous political statement. H.R. 2820 provides a special path for citizenship for millions of illegal immigrants. In doing that, it places the interest of those who have violated our laws above the interest of the men and women who have waited patiently for their green cards to become available. Of course, the bill provides the same path to legal non-immigrants, so the number of potential beneficiaries is completely unknown. The bill also allows criminal aliens and those who have committed immigration fraud to receive green cards. It ultimately rewards parents who brought many of these individuals to the U.S. illegally with green cards and eventual citizenship of their own. It incentivizes fraud through lax documentation requirements and allows people to skirt the requirements. It even allows aliens no longer in the U.S. to apply for green cards. H.R. 2820 purports to prevent alien gang members from eligibility, but the prohibitions are so narrow it is virtually unworkable. But before anyone talks about us not wanting to solve a problem, that is simply not true. As evidenced by 2 floor votes last year, the vast majority of Republicans want to provide legal status for DACA recipients. but we want to do it the right way, to minimize fraud and to assure criminals cannot get the status so we don't find ourselves repeating this conversation in 5 or 10 or 15 years as we have been doing. H.R. 2820 accomplishes none of these goals, and I would therefore urge my colleagues to oppose this legislation. With that, I yield back.
Thank you, Mr. Collins. I now recognize the Chair of the Subcommittee on Immigration and Citizenship, the gentlelady from California, Ms. Lofgren, for her opening statement.
Thank you, Chairman Nadler. With today's markup, the Judiciary Committee is taking an important step towards the enactment of a law that would provide lawful permanent residence to Dreamers. H.R. 2820, the DREAM Act of 2019, is the latest version of vital legislation that would finally bring certainty to undocumented youth in this country who are American in every way except on paper. Many of us, both inside and outside this room, have been waiting for this day for a long time. 18 years ago, the first iteration of the DREAM Act was introduced. The term dreamer was coined. In 2010, the House passed the DREAM Act, but it stalled when the Senate came up 5 votes short in a cloture vote. Just a couple of months ago, we set the stage for consideration of this bill with a hearing to shine a spotlight on the plight of undocumented young people, as well as TPS and DED recipients. And today is the first time that we moved the DREAM Act through committee markup. At the hearing last month, we were inspired by the personal stories of several young dreamers, each of whom has chosen a different path in life, but all of whom have already achieved great success. One such witness, Jin Park, is a DACA recipient who grew up in New York City, graduated from Harvard University, and recently became the first DACA recipient to receive a Rhodes Scholarship. We also heard from Yasmin Ruiz, who graduated summa cum laude from the University of New Mexico. She's now in medical school, and she intends to specialize in women's health and ensure that all women have access to competent medical care. And we also heard from Hilario Yanez, a DACA recipient who lived in a homeless shelter as a child, but went on to graduate from the University of Houston and now works at a Fortune 500 company. Each of these witnesses is truly extraordinary, and yet they represent just a tiny fraction of all the dreamers who are out there, young adults who embrace this country as their own and chase their dreams despite the difficulties they faced with immigration status. We owe it all to all of them to get this done, but I would say it's not just about the dreamers, it's about our country. Why would we want to oust the medical student? Why would we want to remove the Rhodes Scholar from our country when they have so much to offer all of us? So this is not just about fairness to the de facto Americans who are the dreamers. It's about fairness to the United States, who need to fully benefit from the talent, the energy, the commitment, and the patriotism that the dreamers represent. As Chairman Nadler mentioned, approximately 800,000 dreamers have been granted a temporary reprieve from removal through the DACA program. Since 2012, when DACA was announced, bills have been introduced that would essentially extend DACA for limited periods. But DACA, or anything that resembles DACA, is not enough. If the Trump administration ultimately wins in court, DACA will become a thing of the past, and far too many young people will be plunged back into the shadows. Anything that provides less than lawful permanent residence is insufficient, and that's why today's markup is so important. We must pass the DREAM Act and eliminate this uncertainty by providing this group of people with the stability that they need. I want to thank Representative Lucille Roybal-Allard, Chairman Nadler, and Representative Jayapal for their tireless work on this legislation. Their commitment to this issue and thoughtful leadership has been essential to getting this bill to markup. Well, the bill may not be perfect. The bill before us provides a fair and reasonable opportunity for dreamers to apply for lawful permanent residence with tough eligibility standards and discretion to consider unique situations on a case-by-case basis. Applicants must pass security and background checks, meet specific education benchmarks, and are barred if they have serious criminal records. This legislation should not be controversial. The DREAM Act has enjoyed bipartisan support in the past with many of these same provisions. So let's set aside partisanship and support this important legislation so that dreamers can finally have the peace of mind that comes with lawful permanent residence, and so that America can finally benefit from all their energy, intelligence, hard work, and patriotism. With today's markup, we take the first steps towards solving this moral crisis once and for all, and I yield back.
Thank you, Ms. Lofgren. I now recognize the ranking member of the Immigration Subcommittee, the gentleman from Colorado, Mr. Buck, for his opening statement.
Thank you, Mr. Chairman. We're here to discuss an important issue that should cross political lines. We should be working together in this committee to craft a compassionate solution that addresses the no-win situation DACA recipients face, while also giving our country the tools we need to secure our border for good. But we wouldn't need to be here today if the Democrats were serious about solving this issue, serious about giving the approximately 800,000 DACA recipients in this country real hope, serious about not using these young immigrants as political pawns in their push for an open borders utopia. Unfortunately, my Democratic colleagues ignore the serious crisis at the border and how pushing amnesty, continuously rejecting border security measures, and calling for the dissolution of ICE act like a bright red neon sign inviting more immigrants to make the dangerous trek to our border. The Democrats are also ignoring the key fact that past amnesty measures have pushed more people to make the perilous journey in hopes of receiving similar treatment. Take Senator Feinstein's bill, the Unaccompanied Alien Child Protection Act, that provided unaccompanied children with pro bono legal counsel and family reunification instead of a promise to return these children home. When this legislation was signed into law in December 2008, it showed countless individuals in Central and South America how their children could cross the border and remain here if they played their cards right. The stats bear this out. In fiscal year 2008, 8,041 unaccompanied children were apprehended at the border. In fiscal year 2018 alone, 50,036 unaccompanied children were apprehended. Clearly, the message made its way south, that the U.S. wouldn't turn away unaccompanied children, which spawned a flood of children making the dangerous journey north through extreme weather conditions, often at the hands of brutal coyotes, because they've been told that if they come to America, they won't be sent home. This isn't compassion. It's reckless, misguided, and dangerous. Yet Democrats refuse to come to the table to find a real solution. Just last year, Republicans put forward a bill in good faith that provided that real solution for these young immigrants. We offered a pathway forward that effectively melded a compassionate answer for these young immigrants with immediate improvements to border security and robust screening and fraud prevention to deny status to criminals and gang members. More importantly, Republicans extended an open hand to Democrats to help us solve this problem once and for all. But holding strong to their positions, Democrats refused to budge. They chose to not take part in negotiations and voted in lockstep with then Minority Leader Pelosi to cast aside the dream of helping DACA recipients. You heard that right. Not one single Democrat voted to help DACA recipients. Instead, they chose to use these children as chips in a political poker game. Flash forward to today, and Democrats are still grasping at straws. The Chairman and Speaker Pelosi are offering a bill today that stands no chance of becoming law. And worst of all, they are still using DACA recipients as pawns. The DREAM Act of 2019 does nothing to address the systemic issues facing our immigration system. Instead, the Democrats had offered an amnesty-only bill that would apply to every dreamer, whether they applied for DACA or not, to apply for permanent legal residency and eventual citizenship. There are other problems with this bill. Administration officials have already said this bill would be operationally unworkable if it's signed into law. It includes impossible mandates and an unworkable cap on application fees. It will only serve to further flood the system with fraudulent applications and force DHS officials to reprioritize their adjudication caseloads, pushing individuals who are trying to enter the country legally to the back of the line. USCIS officials won't be able to access background check materials to see whether we are potentially allowing gang members and violent offenders to enter our country. As I said before this committee in March, the American people are compassionate. We are willing to help these young individuals who are here through no fault of their own. But they know that this bill does not provide a real solution. It's just another amnesty without any meaningful changes to enhance our nation's security. Mr. Chairman, my Republican colleagues and I are eagerly awaiting an opportunity to work with you to craft a real solution to protect DACA recipients and solve our crisis at the border, just as we did last year. But we can't pretend that this bill is the answer or that Democrats are doing anything but using DACA recipients as pawns to further their political agenda. I yield back.
Thank you, Mr. Buck. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2820, offered by Mr. Nadler. Strike all that follows after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. Most of the changes in this amendment are of a technical nature. For example, the underlying bill used two different terms for the same concept, termination and revocation of status. The amendment revises the measure so that it uniformly refers to revocation of status without changing the substance of the bill. Aside from these technical revisions, the amendment in the nature of a substitute makes three substantive changes. The first is the inclusion of a new paragraph that lists the factors the Secretary must consider when exercising his or her discretionary authority to provisionally deny applicants who pose a threat to public safety. The second corrects a drafting error in the underlying bill pertaining to the provision that allows dreamers with conditional status to remove those conditions based on employment. As amended, the text of this provision simply reverts back to how it appeared in H.R. 6, from which H.R. 2820 is derived. The third substantive change adds a new definition for, quote, appropriate United States District Court, close quote, to harmonize the bill's two judicial review provisions. All of these changes are relatively minor, and they improve an already good bill. Therefore, I urge my colleagues to support the amendment in the nature of a substitute, and I yield back the balance of my time. I will now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment.
Thank you, Mr. Chairman. We accept the changes that have been made. I do not believe these make an already good bill better because it's not an already good bill because of the things we had pointed out earlier. If there were, then we would love to be able to join this and make a solution here. But it is acceptable as far as the nature of substitute.
I thank the gentleman. For what purpose is the gentlelady from Washington seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and I want to start by thanking you and our Immigration Subcommittee Chairwoman Lofgren for your tremendous leadership over decades, honestly, on issues pertaining to the immigration system and the advocacy for comprehensive, humane immigration reform. Words can't express the immense pride that I feel today in bringing this bill forward for this historic markup of the DREAM Act. It has been 18 years since the original DREAM Act was introduced. We've organized in the streets and in the halls of Congress to get to this moment, and I just want to take a moment to thank the Dreamers, their moms and dads, their families and friends, and everyone who has put in their blood, sweat, and tears to get us to this moment. At the heart and the core of this bill are people who are American in every single way but paper. People who came to the United States at a young age, some as young as 1 month old, who are rooted in our communities, a part of our families and our schools and our workplaces. An estimated 2.1 million Dreamers would be eligible to apply for legal status under this bill. And I'd like to share the stories of two Dreamers who call my district home, Paul and Jose Quinones, who moved to the United States when Paul was 7 and Jose was just 2 years old. Both brothers grew up participating in highly capable programs at their schools. Their teachers would often talk about the high expectations that they had for them and that the brothers would be the next generation of leaders that the community needed. Paul and Jose were less certain about their future given their undocumented status, but then DACA was announced and that changed everything. Paul received DACA, and he enrolled at Gonzaga University, where he obtained a BA in economics and political science. Upon graduating, he went to work at the Washington State Legislature and then at the office of the mayor of Seattle. Seeing all that his brother was able to accomplish with DACA, Jose was getting ready to apply. Unfortunately, President Trump cruelly terminated the program right before he began his engineering studies at the University of Washington, and Jose's future, along with millions of others, is more uncertain than ever. Esther is another dreamer who interned in my office here in DC last year. She came to the United States with her parents and younger sister when she was just 3 years old from South Korea. When they arrived on a visa, Esther's parents sought help from an immigration lawyer to obtain more permanent legal status. They filled out their applications, they paid their dues, they gave the lawyer most of the money they had, and he ran away with all of it. He scammed them and left them with nothing. Esther's parents' visas expired, and they had little money. They pushed their kids around in a shopping cart because a stroller was too expensive. But they started over. They built their lives in the United States. They raised a smart, passionate daughter who went to Harvard, and the DACA status that Esther obtained in 2013 helped to give her the freedom to pursue her own American dream. Even when Esther's DACA status was secure, she said that typical, quote, safe spaces like hospitals and police stations and doctors' offices filled her with fear. Because DACA doesn't afford protections to her family, she often hides her status and wonders what would happen if somebody that she trusted outed them to the immigration authorities. Today we have this incredible opportunity for young people like Esther and Jose and Paul and so many of you who are in the audience to take this first step of reporting the bill favorably to the House floor, this first step to establish a roadmap to citizenship, not just for dreamers like Esther and Jose and Paul, but also for the 795,000 U.S.-born children who have parents who are dreamers. That's 795,000 children who won't have to worry about being separated from their moms and dads. So if Republicans care about family separation, this is a good interim step. But it isn't just about families, it's also about doing what's best for our workforce and our economy. We know that dreamers work in nearly every occupation: teachers, service providers, entrepreneurs, construction workers, innovators, doctors, researchers, you name it. And households that include dreamers make tremendous contributions to our economy, generating billions of dollars in state, local, and federal taxes. The benefits are immense. But most importantly, we have a chance to redefine, to reclaim the values that make us truly great as a nation by passing this DREAM Act. It is noteworthy that Sunday marks the 95th anniversary of enactment of the Immigration Act of 1924, which enacted racist quotas that limited the numbers of immigrants allowed entry and prohibiting the entry of Asian immigrants. And today, I sit in the House as the first South Asian American woman ever elected to the House and one of only 14 immigrants out of 535 in the House of Representatives. This is a first step, not a last, and I want to thank you, Mr. Chairman, and Subcommittee Chairwoman Zoe Lofgren for everything that you have done. Let's pass this bill and let's advance these common sense, humane solutions for our dreamers and upholding the rights of everyone.
I thank the gentlelady. For what purpose does the gentleman from Ohio seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
The gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr.
Chairman,
Shabbat
I'd
of
ask that the
Ohio.
amendment be considered as read.
The amendment will be without objection.
Thank you, Mr.
The gentleman is
Chairman.
recognized to speak on the amendment.
Thank you, Mr. Chairman. Thousands and thousands of Americans are injured and killed by drunk drivers in this country every year. Mothers Against Drunk Drivers estimates that for every time a person gets picked up for a DUI or DWI or whatever that particular state calls driving under the influence or drunk driving, for every time they get picked up and convicted, they've probably driven drunk 75 to 100 times when they didn't get picked up, and were still exactly the same danger to the motoring public and pedestrians as they were when they did get picked up. And I think on both sides of the aisle, we would all agree that as members of Congress, it's our responsibility to do everything that we can to keep the American people, to keep families safe, to keep drunk drivers off our highways and off our streets. One of the many problems that I have with this legislation is that, as written, it would have just the opposite effect with respect to drunk driving. Presently, our immigration laws make inadmissible into the country individuals involved in crimes of moral turpitude. And while H.R. 2820 adds exclusions for any felony offense or 3 or more misdemeanor offenses, I would argue that the exclusions currently in law and in H.R. 2820 do not go far enough to keep drivers on our nation's roadways and pedestrians safe. H.R. 2820 makes it ineligible for aliens to adjust their status if they have 3 or more misdemeanors. However, the applicability of up to 2 misdemeanor offenses can be waived if the alien has not been convicted of an offense in the previous 10-year period. As such, an alien could have 4 convictions and a pending arrest and still have his status adjusted under this bill. My amendment is simple. It ensures that individuals who have been convicted of a DUI offense, and I'm talking about a conviction here, not just that they drove, many, many times, but an actual conviction for a DUI offense that caused a serious injury to another, or a person that's been convicted of 2 or more DUIs. So if a person, again, just to repeat that, either a DUI that you've had a serious injury to an individual or 2 DUIs, that person would be ineligible to have their status adjusted. I would hope that my colleagues on both sides of the aisle would support this amendment, would help keep impaired drivers off our roads. We should not be passing laws which shield drunk drivers from removal or reward them for their dangerous conduct by fast-tracking them to get a green card. And if you vote against this amendment, in essence, that's what you're doing. I would also like to compliment my colleague on the other side of the aisle. I don't think he's here right now, but Steve Cohen of Tennessee for working with me on another piece of legislation that we've been trying to pass for some time now relative to DUI, and that would be that we actually have a way of determining if people have multiple offenses in different states. Right now, it's very hard to know, and I happen to be in Southwest Ohio, Cincinnati, and oftentimes, and I practiced law for almost 2 decades before coming here, and people oftentimes, they'll say they have no DUIs, and if this is a first-time offense, and it may be a first-time offense in Ohio, but it turns out they've got 1 in Indiana, which is very close, or 2 in Kentucky, so they're oftentimes treated, and they don't necessarily get caught for doing that. So this would actually, if a person, it would make it much easier for law enforcement to determine that a person has multiple DUI offenses and that it's not just a first-time offense when they would be treated much less severely. So, but that's not this bill. This bill would do what I said before. It would basically just say if you have a DUI and it's caused a serious injury to another person, that you would be ineligible, or if you have 2 DUIs, whether or not there was an injury involved or not. And with that, I yield back.
Mr. Shabbat, would you yield for a question?
Yes, I'd be happy to yield.
Chairman?
Thank you.
Yes.
I'm just wondering if if someone is convicted of driving under the influence with a cause of serious bodily injury or death, are you aware of any jurisdiction in which that is not a felony, and in which case they would already be barred under the existing language of the statute?
They're oftentimes only convicted of a misdemeanor DUI.
No, but I'm saying for your amendment says if someone is convicted of driving under the influence or impaired driving and it was the cause of serious bodily injury or death of another person, that already exists in the underlying bill because that would be a felony in every jurisdiction.
Yeah, it doesn't require the proof of a serious bodily injury in the conviction.
Gentleman's time has expired.
Mr. Chairman?
For what purpose does the gentlelady from California seek recognition?
I oppose the amendment, and I'll tell you why. DUI is a very serious issue, and no one wants to see individuals who are true threats to public safety obtain relief under this bill. The bill accomplishes that by barring applicants convicted of serious offense or repeat offenses. But here's the important thing. It authorizes the Secretary to deny those who pose a threat to public safety, even if they have a single misdemeanor. So let's break this down. As the gentleman from Rhode Island has mentioned, someone who is convicted of an offense driving while intoxicated that causes a serious bodily injury or death has committed a felony and is barred under the bill. Anyone who's convicted further of an offense that is punishable by a maximum term of imprisonment of 1 year is barred from relief. So that felony DUI conviction is already covered in the bill. If you have one conviction for DUI with a suspended license and you knew your license was suspended, you've committed a crime of moral turpitude, actually, and that bars you under another section of the bill if you're sentenced to more than 6 months in jail. And also, if you have more than 2 misdemeanor convictions, you're out. These are tough provisions, but as I've said, to ensure that no one who poses a threat to public safety slips through the crack, the bill gives the Secretary discretion to provisionally deny an applicant with even a single DUI conviction. Now, this was a provision that was not added lightly. Considering what the administration's attitude has been towards immigrants, it's difficult to provide the current Secretary with the authority to provisionally deny applicants based on a single misdemeanor conviction, not to mention juvenile delinquency adjudications, neither of which are disqualifying for other immigrants. But we do need to keep our country safe, so we must trust that the administration will exercise the generous discretion that this bill provides in a manner that places value on the safety of all Americans. And I think amendments that seek to further restrict eligibility requirements really are not well crafted. It's true that a single DUI conviction is a serious matter, but we could look to Congress. There are members of Congress, including, well, I don't want to mention names, who have been convicted of DUIs, and they serve with us, and they are not removed from the country. So people make mistakes, and laws and policy decisions should reflect that. And so for these reasons, and because we have protected the public safety in the underlying bill, the amendment, although I'm sure offered in good faith, should be.
Would the gentlelady yield for a second?
I would be happy to yield.
Thank you. And just in a moment, not on the substance, and as we're going to talk more about that, but just in reference to the membership, you just stated that they're not being removed from the country as members who have a DUI. That's exactly right. They're American citizens, and they're under a different standard here, and we're not talking about American citizens at this point, just to make that clear.
Would the gentlelady yield?
I would be happy to yield to
Yeah,
the
but
chairman.
we are talking about what poses a public safety threat. And someone who was brought here at a year or two old and has a DUI conviction, maybe from years ago, poses no more and no less of a public safety threat than a member of Congress who has a DUI conviction from several years ago. This legislation is intended to recognize reality, that these people are Americans. They are Americans in every sense except for the piece of paper, and to say that, to imply that we should have one standard for members of Congress who can have a DUI conviction and another where for Dreamers where a single DUI under whatever circumstances should automatically expel them from the country is simply wrong. I yield back.
Reclaiming my time, I will just say this, that we have built into this bill a fail-safe measure so that if the Secretary finds that an individual poses a public safety threat to our country, they are denied. And I think that that is the bottom line provision that protects our public safety. I'm sure that our friends across the aisle do not question the integrity, nor do we, of the Secretary of Homeland Security and his toughness in applying that standard. And with that, Mr. Chairman, I see that my time has expired.
The gentlelady's time has expired.
Mr. Chairman.
Gentlemen, for what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I just want to briefly comment on the statement that someone who is convicted of a DUI where someone has been seriously bodily injury or a death has occurred is always a felony. That's simply not accurate. I had an extensive legal practice in this area of law, and I can tell you that there are many times that in my county that the county attorney would turn these down and someone would get a DUI misdemeanor conviction though they had imposed serious physical injury or death. So it's simply inaccurate to say that this is not the case. But having said that, I'm sure that many of you have had the opportunity, as I have, to meet with DACA-eligible individuals. DACA, as implemented by the Obama administration, covered entrants who came illegally into the United States prior to 2012, effectively impacting those from 2007 to 2012. Those who came before 2007 or after 2012 were ineligible for deferred action, meaning that any action, including removal from the United States, was deferred for that population. There were approximately 800,000 individuals who registered as DACA applicants. 40,000 were found to be eligible to be in the country under some other statutory authority, and 70,000 were found to be ineligible at first blush. The remaining 690,000 have had their status under the law effectively stayed for these last years. Groups on both sides of this issue have guesstimated that there may be between 1 and 1.2 million people who were eligible to apply for DACA but failed to apply for whatever reason. So advocates for DACA amnesty have urged that we grant unconditional amnesty for the 690,000 who applied and the additional 1 to 1.2 million who failed to follow even the Obama administration's relatively simple DACA requirement of registration. If that occurs, we'll have nearly 2 million people given amnesty. I've only met one person, and it was actually in this hearing, some of you may recall this, who was ever in favor of limiting the DACA amnesty to DACA recipients. They all, with the exception of the one individual who testified in here, all want their parents, who were the ones who ostensibly brought the DACA person into the country illegally in the first place, to be granted an amnesty status as well. Most DACA recipients want amnesty for themselves and their illegal alien parents. The number of these illegal aliens is conservatively estimated at more than 2 million. Thus, if we add these figures together, we'll be granting amnesty to nearly 4 million people at the low end of the estimates that I've seen. Then, of course, we have the issue of moral imperatives. Was it morally acceptable for the Obama administration to set arbitrary brackets protecting individuals who were illegally brought into the country between 2007 and 2012 while excluding protection for all others similarly situated but were brought into the country outside of those brackets? What then is the moral justification for preventing DACA protection for those outside the brackets? And I'm asking that because we're talking today literally about additional millions of people who would seek similar amnesty, and this particular bill, 2820, goes well beyond even the DACA applicants. So the moral imperative has always been to treat all people the same, and what we see here is a distinction. And my colleagues on the other side wish to expand that population that they're going to give preferential treatment to. So it becomes an incentive to come and stay in this country illegally. The majority bill is not merely an amnesty bill for the DACA population who applied under the rules implemented by the Obama administration. It actually expands the number of people who will get amnesty. This is the reality of this vexing issue. To whom will the Democrats give amnesty, and to whom will Republicans give amnesty? And so we're here, we sit here, and I see expansion on the part of the Democrats in this bill, and it's going to keep going. And I view this as someone just said, a first step, and I think that's indeed what the intention is, to a universal amnesty. So, Mr. Chairman, I think Mr. Shabbat's amendment is correct. It's correct factually. It is imperative that you have this language in there. I would urge my colleagues to support Mr. Shabbat's
Would the
amendment.
gentleman yield?
For the 7 seconds? Yes, ma'am.
I just wanted to point out that the first provision in Mr. Shabbat's amendment would also be disqualifying because it's a crime of moral turpitude, which is already barred under the bill. So to some extent, the amendment is superfluous, and I thank the gentleman for yielding.
The gentleman's time has expired. The gentleman, for what purpose does the gentleman from Arizona, Mr. Stanton, seek recognition?
Chair, I move to strike the last word.
Gentleman is recognized.
Thank you very much, Mr. Chairman. I respect my colleague and friend from Arizona. I respectfully disagree with him on this important issue. I want to thank you, Mr. Chairman, and Chairwoman Lofgren, Chair of the important subcommittee, and Congresswoman, Jayapal. It's been a lot of fun working with you on this very, very important issue. Today is a historic day for our Judiciary Committee. We have the privilege of discussing immigration bills that will affect an estimated 2 million people in the United States. Dreamers, TPS, and DED holders have been woven into the fabric of our country for decades. We know that they are teachers in our schools, leaders in our community, the owners of local businesses back in our districts. They are Americans just like you and I. Dreamers are constantly reminded of their undocumented status when they are not legally able to work, travel abroad, obtain a driver's license, or receive federal financial aid. These everyday things that we as citizens don't give a second thought about will finally be obtainable for these individuals with the passage of this piece of legislation. My state, Arizona, is one of the states with the highest number of dreamers who stand to benefit from this legislation. There are 9,000 dreamers in my district alone, young people who have to confront the stressful factors associated with their undocumented status every single day. And I want to highlight one of them. Reina Montoya, a dreamer and educator who has caused ripples of positive change in my district. She graduated from Arizona State University with a Bachelor's of Arts, later earned a master's degree in secondary education from Grand Canyon University. She became a public high school teacher in Phoenix. She has grown into a remarkable young woman, despite the fear, anxiety, and stress associated with having undocumented status in our country. She used dance as her refuge for dealing with these emotions and the possibility of losing her dad to deportation. She founded Aliento, an organization located in Mesa, Arizona, that supports other undocumented youth, children, and mixed status families through art, leadership development, organizing, and education. Aliento has become a place where young people can go to process their feelings while simultaneously changing the policies and structures causing trauma in the first place. A place more communities in America need. Last year, Reina earned a spot on Forbes' 30 Under 30 Social Entrepreneurs list for finding a way to turn an impossible situation into a catalyst for positive change. If Reina, an individual deeply impacted by Congress's inaction, can inspire such change, we as members of this body have a moral responsibility to fix the system that is outdated, unjust, and broken. Today, we are taking that first step. We are marking up legislation that forces us to confront the responsibility that we have to dreamers, TPS, and DED holders in our communities to do everything in our power to pass legislation that finally recognizes their presence, their work, their dignity, their contributions, and ultimately their humanity. Mr. Chairman, I'd like to insert into the record 2 publications, one titled Undocumented Status, The Impact on Teens and Their Families Living in the United States, and one other, Turning Trauma into Hope for Arizona's DACA Recipients.
Without objection.
I yield back. Thank you.
Without objection. Gentleman yields back. The gentleman from Louisiana, for what purpose does the gentleman from Louisiana seek recognition?
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman is recognized.
Thank you, and I want to yield my time to Mr. Shabbat.
He's yielding it to me. Thank you very much for yielding. I greatly appreciate it. Just a couple of points. First of all, DUIs are almost never. Thought it wasn't. Yeah. DUIs are almost never crimes of moral turpitude, and case by case shows that. Secondly, also, the public safety option is so restrictive because the secretary himself or herself is the only one who can do this waiver. And what DHS secretary has the time to look at every single case. It specifically says in the legislation, the Secretary of Homeland Security may, as a matter of non-delegable discretion, meaning that he or she has to take that decision themselves. They can't have, one of their staff people or some underling take care. If they have to do that themselves, it's non-delegable. And then finally, our number one priority ought to be protecting the public. And this is an opportunity to actually step up and do that. We're talking about somebody here who not just had a DUI, but they had a DUI in which a person was either killed as a result of this person driving drunk. So a person was killed. We're talking about somebody that could be one of your family members, or a person that received a serious injury, a serious bodily injury. So we're not talking about a psychological injury. We're talking about a serious bodily injury. It could be the loss of an eye, for example, and there are cases in which these things are talked about. It could be the loss of a limb or the loss of use of a limb, permanent, generally. It could mean, for example, a serious disfigurement. So we're talking about the person has suffered some serious damage as a result of the person driving drunk. Or in the other case, we're talking about not only did they do it once, but they did it a second time or multiple times. And so these are folks who are not U.S. citizens who we're going to make an exception and allow them to stay here. If we're going to do it, we ought to be doing it for people that are going to act responsibly, that are going to be good citizens of this nation, that are going to work, support their families, keep their fellow citizens safe. But we're talking here about people that have driven drunk and seriously injured people already, or have done it twice. And as the Mothers Against Drunk Drivers organization will tell you, again, it's not, every time a person gets picked up, we're talking about multiple times that they've done this and not gotten picked up for it. So our priority ought to be protecting the American public, innocent people out there, and this amendment makes it very clear. If you vote for the amendment, that's what you're doing. If you're against this amendment, you're putting the American public at risk. And if my Democratic colleagues are so sure that under the bill these people would be denied, then they should have no problem accepting the amendment. And I thank the gentleman for yielding, and I yield back my time to him.
I thank the gentleman, and I would just urge support for the amendment and an abundance of caution. I yield back.
For what purpose does the gentlelady from Texas seek recognition?
I think Mr. I'll yield to him first, Mr. Chairman. I'll go after him. Thank you.
Mr. Chair.
The gentleman from California.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I'll move to strike the last word.
The gentleman is recognized.
Mr. Chairman, my district, I'm proud to say, is home to the largest number of dreamers in this country. And I want to correct the record about who dreamers really are. They're U.S. Marines. Jose Angel Garibay lived in my district in Santa Ana. He enlisted in the United States Marine Corps and was deployed to Iraq. In 2003, at the age of 21, he was killed. He made the ultimate sacrifice for the United States. He was the first service member out of Orange County to die in Iraq. And he was a dreamer, and he received his U.S. citizenship posthumously after he made the ultimate sacrifice. This is who the dreamers are. Mr. Chairman.
Gentleman yields back. Who seeks recognition? Gentleman from Georgia, for what purpose does he seek recognition?
I seek to strike last word.
Gentleman is recognized.
I'm just not going to take long. Again, I think the points been made by the gentleman from Ohio are valid points. I think as he has back pointed out, there is discussion here. This is why this bill, I think, as I've stated from the outset, should have been looked at a lot harder so that we could actually find the real solutions that actually could solve this problem. Instead of moving forward with this, I support the gentleman's amendment and yield back.
For what purpose does the gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady is recognized.
Mr. Chairman, I think you would admit that we have good friends on the other side of the aisle. For those of us who've been on this committee, we've had the opportunity to engage, and certainly I've done that with Mr. Chabot, so I respect his concerns. I think it is important to emphasize the pain and desperation of dreamers and individuals who would benefit under both the American Promise Act and, of course, the act dealing with the TPS and DREAM Act as well. I've interacted with all of them. We proudly boast in Houston as being one of the most diverse cities in the nation, speaking 98 languages plus. I think it has grown. I relish going to schools, speaking before audiences that remind me of the United Nations. And so, juxtaposed along that is my longstanding work with Mothers Against Drunk Driving and respecting the concerns. That is why this legislation didn't fool around. We already have a strict, stringent, absolutely airtight language because the members who wrote this legislation, as we have done over the years, I've introduced comprehensive immigration reform for 2 decades plus. We would not allow, if you will, the safety and security of the nation to be jeopardized. I just came out of Homeland Security, where people were complaining about those who are coming across the border. My friends, 189,000 plus of them are family units. They're 11-year-olds like Laura. Some of them have even lost their life as children. But what we have today dealing with is those who are here and who have been working extensively. So let me just share with you, first, in this legislation, anyone who is convicted of an offense that is punishable by a maximum term of imprisonment of more than 1 year is barred from relief. That means that whether you kill someone, harm someone, or they just bypassed your car and you were caught drunk or under the influence. So a person with a felony DUI conviction is absolutely barred, and the majority of states will charge a person with felony on their second or third DUI offense. Then secondly, if you have one conviction for DUI with a suspended license and you knew your license was suspended, shamefully, I'm saddened about that because some people say, I did not know. You're committed a crime involving a moral turpitude, and if you're sentenced to more than 6 months in jail, you're out. If you have 2 misdemeanor convictions, you're out. We already have this in the bill. I want Mr. Chabot to be comforted by the fact, injury or death, you're already out. I don't want it to get to that. You're out. And so I think we need to know the pain that people are suffering. I meet with dreamers all the time. They intern in my district office and in my Washington office. I work with an organization called FIAL with Cesar Espinoza. We're like the frontline team in our community. He's a young man who had to watch his brother struggle to become a citizen. We met him in Houston. He himself is a dreamer, but he never stops working. He takes cases no matter who you are, and most of the time you have no resources. He finds pro bono attorneys for desperate little ones like Laura, who was wrongly deported while she was in the courtroom 10 different times, and the last time the clerk said, oh, you're not supposed to be here. You're not on the docket. And that very act and word of that burdened clerk, overwhelmed, overworked, trying to do their job, put into motion a deportation order for an 11-year-old, the most joyous little 11-year-old Laura, who sits in a classroom today, thank God, learning and loving America. So I would simply say that I know the gentleman is well-intentioned, but I am confident that we have legislation that would not have made a misstep to leave out that important element of protecting all of us. And I join my friend from California, Mr. Correa. We know a lot of military personnel. In fact, Congresswoman Loughran, in her being chair and ranking member back and forth, she knows that we worked on this issue with military personnel, posthumous and alive. We worked on it with their family members. We had desperate situations where people were fighting in Iraq, and were almost deported, or their family members were deported. We've seen this, and all we're trying to do is to bring relief to people who want to do nothing more than serve this nation and contribute to the greatest experiment in the world, and that is the United States of America. And so I respectfully have to oppose the amendment because I believe it is well stated in the legislation, and I would not stand for anything less, nor would my colleagues, and I'm very grateful for the fact that we take very seriously that responsibility, but we also take seriously, Mr. Chairman, the wonderful people that are in need today. I yield back.
I thank the gentlelady. For what purpose does the gentleman from Texas seek recognition?
Move strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I appreciate the assurances from people across the aisle that multiple driving while intoxicated or DUIs are crimes of moral turpitude. Hitting someone, causing bodily injury is while intoxicated and driving is moral turpitude. But normally those are crimes according to a state. And in the state of Texas, I know before I became Chief Justice of the Tyler Court of Appeals, they had just ruled that it was not a crime of moral turpitude to even be involved in a criminally negligent homicide where someone was killed. So I appreciate the assurances across the aisle that, oh no, they would not be eligible, they would be eliminated because that involves moral turpitude. Well, apparently it depends on the state, and the states of which I'm familiar with the law, including Texas, that's not necessarily so, and in most cases it would not be so. And having had to sentence a man who was in the United States illegally, he should have been charged with a felony before his 9th DWI, but that's his 9th one. He was in a wreck and caused serious bodily injury. He ends up in my court. And anyway, I was surprised he was back in my court 6 months later because he was deported. Within 6 months, he was deported. I said, how'd you get back? He said, well, they took me to the border, watched me walk across, and when they drove away, I walked back across and was drunk again and had another accident and hurt some people, and so here I am again. He was deported 90 days later, regardless of the sentence, but came right back. Look, until the border is secured, these kind of actions are not, I mean, the main purpose they accomplish is creating a massive lure to people to come into this country illegally. And some people say, oh, well, you're hateful, you're hard-hearted. Look, when I look at the Hispanic culture, some people, well, you must hate Hispanics. They don't know my heart. I know we don't like to generalize, but the huge majority of the Hispanics I know, they have a love of devotion to God, a devotion to family, hard work ethic, which I think are the three things that contributed to make us the greatest country ever. I want more of that in my country, a lot more. But it needs to be legal, and I was just sent a picture by one of our Border Patrolmen yesterday, 6 and 8 year olds standing right in front of you. They were sent unaccompanied. Why? Because they were told, if you will just get in, they're legalizing people like you. Get in there, and then maybe we can come be legal parents for you down the road. But just as the Border Patrol tell me all over our southern border, when you guys talk about legalization, any type of amnesty whatsoever, we get a huge surge. And we also know every time there are more children that come, there are children that don't make it. There are women raped. We know Doctors Without Borders report an unusually large percentage of women that were raped multiple times en route here. Why don't we get the border secured as a joint effort? And then you may be surprised what I will agree to. But until the border's secured, all that we are doing by having this markup is drawing more people in, more women will be raped, more people will be harmed. Let's get the border secured together, and then we can have an overall agreement on what we do about the people that are here. This amendment is important because many states, including Texas, which now has the sector that is most traveled by people coming into the country illegally, it's not, most of the time, not a crime of moral turpitude. So let's just approve the amendment, and then that will take care of it. It won't be an issue, and I yield back.
Gentleman yields back. For what purposes? Gentleman from Maryland seek recognition.
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Today's a very exciting day for more than 1 million dreamers around the country who have the opportunity through the legislative action of this committee to get on with their lives, to dispel the uncertainty, to dispel the anxiety, and to go ahead and to become full-blown members of our community who can work and go to school here without the constant fear of being deported. Thousands of them live in my district, and these are young people who went to our schools in Montgomery, Frederick, or Carroll County. They've grown up here because the Supreme Court said it is their constitutional right. They've graduated from our high schools. A lot of them have gone on to college. A lot of them are serving in the armed forces. And all of them are trying to help their families, support their families under very trying circumstances. And I'm delighted we're moving forward. So I want to speak strongly for the bill, Mr. Chairman. I also want to speak about the gentleman's amendment, which I know is very sincerely and well-intentioned. We lose thousands of people a year to drunk drivers in America. Florida is a state where hundreds of people die because of the recklessness of people who get into a car drunk, go out and drive recklessly. I lost my cousin that way, and I became a huge enemy of drunk driving in the liquor industry, which supports lax laws. And when I went to the Maryland State Senate, I fought the liquor industry every year until we passed legislation to compel the use of ignition interlock devices in the cars of anyone who's been convicted of a drunk driving offense. If we're serious about cracking down on drunk driving, if we're serious about making our roads safe for our people, let's take up that legislation, Mr. Chairman, and I would love to work with my friend from Ohio and anyone from across the aisle or on my side of the aisle in doing that. Let's create laws that cause the states to impose the ignition interlock device. What this is a breathalyzer that you put on your steering wheel, and the car won't start if you fail the breathalyzer. That's the way we're really going to save lives here. Now, as for the gentleman's amendment, I don't think we can do much better than to give the answer of Ms. Lofgren, who says, we've built into our legislation the idea that anybody with a felony drunk driving conviction is out, and then we give the secretary the opportunity to exercise exclusive discretion to say we're going to find that there is a public safety threat provided by somebody who even has just one DUI conviction, and we're going to exclude them from the benefits of this program. And I know a lot of people think that's too harsh. I don't think it's too harsh. I think the secretary should have that authority, and I do think that that authority is properly reposed in the secretary himself or herself. I don't think it should be delegated to other people. I think the secretary should have to make that call about whether there is a public safety threat that is caused by someone, obviously someone who's actually killed someone or seriously injured someone. They're likely to be out anyway, but any other kind of public safety threat, it goes beyond what the gentleman's amendment is saying. Any public safety threat can be decided upon by the secretary. So as a champion of the dreamers who live in my district and a supporter of the dreamers across the country, and as a fierce opponent of drunk driving and someone who wants Congress to act more strongly, I am in opposition of that amendment, and I am in support of our legislation. I yield back to you, Mr. Chairman.
Who seeks recognition? Gentleman from Georgia.
Thank you, Mr. Chairman.
For what purposes, gentlemen, seek
I
recognition?
move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. We'll be here for quite some time today dealing with amendments from my friends on the other side of the aisle whose sole purpose is to remain loyal members of the Trump Republican Party, and they will oppose all efforts to come to a reasonable accord on comprehensive immigration reform, and they will oppose relief for DACA recipients. And they will do that by saying that they support, laws that would help, but they will oppose every single measure that Democrats put forward. Why? Because they're loyal members of the Trump Republican Party. I can't help but to think back to June or July of 2015 when Trump and his lovely wife got on the elevator and descended Trump Tower and held a press conference and immediately lit into all Latinos as being Mexicans who are rapists and murderers and drug dealers coming across the border to kill, rape, and maim Americans. And that is where we are today. Those who support that idea and oppose immigration, and those who are trying to put forth legislation that is humane, reasonable, and well overdue, and that protects innocent young people, among others. And so this whole issue of, anyone who has a single conviction for driving while intoxicated, when such impaired driving was the cause of serious bodily injury or death to another person, they know that in every state in the Union, all 50 states, such conduct would be a felony. They also know that under the legislation that's being proposed, that individuals will not be let in if they have a felony conviction. And so what this amendment does is enables my friends to scare people who are watching and frighten them into being opposed to this very reasonable legislation. And we're going to sit through this for the rest of the day today. So buckle your seatbelts, grab your popcorn if you're out there watching C-SPAN, and enjoy my prediction, which I'm afraid is going to be an accurate one. And another prediction I will make is not one member of the other side will oppose any measure that Democrats put forth today. They will all be in lockstep opposition as loyal members of the Trump Republican Party brigade. And with that,
will the gentleman yield?
Yes, I will.
For a question?
I will.
And I really appreciate your point that people that are disqualified by these type of offenses will not be getting in already. So my question is, if you believe that people with convictions like mentioned in the amendment are not going to be getting in, then why the opposition?
And they won't be granted relief under this
So it shouldn't matter that the amendment were adopted.
Well, because it's just simply submitted to frighten the people, and that's the point that I'm trying to make. We're going to entertain these kinds of amendments all day today, perhaps on into the night. And if you look closely at them, the sole purpose is to frighten and inflame passions of Americans against the people that we're trying to help.
Mr. Chairman, point of parliamentary inquiry.
Gentleman will state his point of parliamentary inquiry.
Aren't we supposed to not talk about motives of amendments? And he's saying that this is, the purpose of this is to frighten people. It's not the case, first of all, but I don't think you're allowed to say what he's saying.
The gentleman,
The gentleman is correct. I would remind all our committee members that House rules and precedents require us to refrain from making inappropriate personal references or accusations as to motive, and I'll leave it at that.
And so in light of that, Mr. Chairman, I will say that I apologize to the gentleman for being offensive, and I don't mean to impugn motives, but the effect of what's happening is to inflame passions. And with that, I'll yield back.
Gentleman yields back his time. The question occurs on the amendment. Those in favor say aye. Opposed, no? No. In the opinion of the chair, the nays have it, and the amendment is not agreed to. Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. McCarcel-Powell?
No.
Ms. McCarcel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes. Mr. Cicilline votes no. Mr. Chairman, there are 10 ayes and 20 noes.
The amendment is not agreed to. Before we go on to the next, let me announce that we often do not break for lunch because there are usually votes at 1 or 1:30 and you can get a sandwich in the cloakroom. However, votes are not scheduled today till after 4 o'clock. So I'm just serving notice now that the committee will stand in recess at 12:15 or hopefully shortly thereafter if we're in the middle of an amendment, but for an hour and a quarter until 1:30, more or less. I'll announce the exact time when we come to it. For what purpose does the gentleman from Texas seek recognition?
Mr. Chairman, I have an amendment at the desk.
I reserve a point of order.
Clerk will report the amendment. The gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. Gomert of Texas.
Waive the.
Gentleman is recognized.
Seek to waive the reading of the.
Without objection, the amendment is considered as read. I'm sorry.
Thank you, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. There is no impure motive, no intent to scare anyone. It is an attempt to deal with facts. Having been a prosecutor in Texas, having been a felony judge in Texas and a chief justice, I've seen these situations, and I'm very concerned about the way the bill is drafted. And I know my friend across the aisle from Maryland mentioned a moment ago that it would be good and it's appropriate to have only the Secretary of Homeland Security be able to make a call on an individual. That's a real problem. What it means is that call's not going to be made 99.999% of the time. The Secretary simply cannot make those calls individually when there's so much else involved in her or his job. My amendment would ensure that gang members are not put on the fast track to a green card through this bill, the DREAM Act. Proponents of this bill say, that it prohibits gang members from receiving green cards already. Well, through a legislative sleight of hand, this bill cannot stop gang members getting a green card. As written, the bill prohibits the Secretary of Homeland Security from delegating authority to deny any applications from gang members. So she or he, as Secretary, can't delegate that. It's specifically in the bill, and I would submit by putting it in there, whoever actually drafted that language knew that this will mean that the huge majority of gang members will not be prohibited from getting a green card, because the Secretary is the only person that can actually deny an application due to gang affiliation. In addition, the bill explicitly states that the DHS Secretary cannot consider any evidence from state or federal databases in determining if an alien is affiliated with a gang, no matter how detailed or substantive that database is with facts. So here again, it's another provision added to the bill to prevent a brutal gang member from being prevented from coming in. And who is normally the victims of foreign gang members? It's normally other immigrants, whether legal or illegally entering the country. It's normally immigrants around them that get killed. It's a dangerous situation, and this protection of people who are gang members, the way this is drafted, is really absurd. The Secretary of Homeland Security should be able to consider all information from all credible sources. Now, under this bill, a gang member would have to basically tell the Secretary that he or she was a gang member and then provide evidence to back that up that was not hearsay for the Secretary to be able to deny an application for a green card. So my amendment fixes both of these problems. It replaces the overly restricted definition of gang involvement as well with the definition that is already in federal statutes. This bill, the way it's drafted now, requires, quote, knowing, willful, voluntary participation, unquote, in addition to the federal definition, which renders the gang provisions useless. All gang members would have to do is say that his or her participation was not voluntary, but because of some fear of retaliation. And then they'd get the green card. That's all it'd take. And I would ask unanimous consent an article be added to the record from May 17, 2019 from the Baltimore Sun in the record, as well as the article from U.S. Immigration and Customs Enforcement from yesterday. ICE seeks custody of teen murder suspects for a second time. This just went on. This 14-year-old immigrant Hispanic girl was killed by other minor illegal immigrant
Without
gang
objection,
members.
the document will be entered into the record, and
My time's expired.
Time
But
is-
I would ask we vote this through. Thank you.
time of the gentleman has expired. I will now recognize myself in opposition to the amendment. This amendment is completely unnecessary, as the bill already provides all the authority the Secretary needs to deny relief to real gang members. Section 101C3C of the bill expressly authorizes the Secretary to deny an application if a person has directly participated in criminal gang activities. The authority is so broad that the Secretary can even deny an applicant on these grounds when there is no underlying conviction. Considering how broad this authority is, the bill includes strong due process protections to ensure applicants are not deported based on mere allegations or unreliable evidence. For example, the bill requires the Secretary to demonstrate that the applicant actually participates in some illegal gang activity and is not just stereotyped based on clothing, tattoos, or the communities in which they live. This is critical because ICE and other law enforcement agencies often classify young individuals as gang members based on little more than a hunch. For example, Mark Morgan, President Trump's nominee to serve as head of ICE, said in a recent interview on Fox News concerning migrant children that he can tell a future gang member by looking into his or her eyes. Quote, "I've looked at them and I've looked at their eyes, and I've said that as a soon-to-be MS-13 gang member. It's unequivocal." Close quote. Like that ridiculous rhetoric, this empty amendment is nothing but a headline grabber. It's another attempt by Republicans to paint immigrants as dangerous and has nothing to do with keeping our communities safe. No one here is interested in handing out green cards to dangerous individuals. But we're also not going to legislate racial profiling into our immigration laws. This amendment would do just that by allowing DHS to deny relief based on little more than a hunch, with no due process at all. The Secretary has reason to believe. What the heck does that mean? Since when do we deprive people of substantive rights in this country because somebody has reason to believe? As noted above, the bill allows the Secretary to deny relief even when there's no conviction, but only so long as the Secretary can show real participation by clear and convincing evidence in illegal gang activities. That is tough but fair. And the gentleman refers to gang databases. Gang databases are notoriously unreliable. They are filled with errors and biased subjective intelligence. Given those fundamental problems, there is no justification whatsoever for denying relief to a dreamer based on a hit in a gang database. Law enforcement agencies often utilize arbitrary or overly broad criteria to flag people as gang members or associates, including wearing certain clothing or colors, living in certain neighborhoods, talking to suspected gang members, or appearing in a photo with a suspected gang member. These kinds of actions result in the disproportionate targeting of individuals who live in areas with gang activity, often lower socioeconomic neighborhoods with high numbers of immigrants. In some jurisdictions, youth can be placed in a gang database by school police, school security, or school staff based on mere suspicion of gang involvement, such as having a particular hairstyle or wearing certain kinds of jewelry. This results in law enforcement mistakenly labeling individuals as gang members or associates, even if they are not in a gang and have never been convicted of a crime. Most individuals don't even know they're in a database, but once they discover that they are mentioned in one, it's incredibly difficult to challenge the determination. The bill, as written, gives the Secretary the ability to exclude anyone based on actual conduct in criminal gang activity. That should be the standard in the law. Actual conduct, not association with people that somebody thinks are gang members. We have due process in this country, and we're not going to tear it up in this instance. I yield to the gentlelady
And
from...
I thank the gentleman for yielding. I agree with your comments, but I would like to make one further clarification. If you look at the underlying bill, it says that the databases shall not establish the participation. That doesn't mean it cannot be considered. It means that that alone cannot establish the underlying offense, number one. And number two, to Mr. Nadler's point, these databases can be terribly erroneous. There was an audit of California's database, CalGangs, and they found that many of the law enforcement agencies couldn't substantiate a significant proportion of the entries in the database. So we have a clear and convincing evidentiary standard that could include the databases, but has to have other evidence. And the idea that someone would claim that it was involuntary, this is not an arbitrary proceeding. This is a proceeding that relates to evidence, not just allegations. So I'm sure the gentleman means well with this amendment, but I think this issue of gangs is very competently covered in the underlying bill, and I thank the gentleman for yielding.
Thank the gentlelady. Reclaiming my time for a few seconds, I just want to say also in summary, we do not in this country deny people substantive rights because of a reason to believe that they have done something wrong. That is not our standard in criminal justice. It's not our standard in anything. We do not deprive people of rights for a reason to believe. Totalitarian countries do that, not the United States, and that by itself is a reason to defeat this amendment. I yield back. Gentleman from Colorado, for what purpose does the gentleman from Colorado seek recognition?
Move to strike the last word.
Gentleman is recognized.
Mr. Chairman, there are times when I disagree with you. I have to tell you, I disagree with you very strongly on this issue. I worked in law enforcement for 25 years. I worked with local police departments for 10 years as an elected district attorney. And I could not be more proud of how the gang units in local police departments took their responsibility to identify gang members seriously. They did not act on little more than a hunch. They identified gang members oftentimes by confession, by interviewing gang members and recording that on a tape. They identified gang members by tattoos. Gang members don't put tattoos on themselves arbitrarily. If you are identified, if you put a 13 on you, you're identified with a particular gang, and if that gang identifies you with that 13 and you're not a member of that gang, you pay a heavy price for that. So there are a number of things. If you wear red in the wrong part of town, you're going to pay a heavy price. The identification of an individual by tattoos, by the colors they wear, by their associations, by their confessions. Most police departments have a very strict standard where you have to have 6 or 7 different identifiers before you can make it onto a gang database. You can only stay on that gang database for 2 years before you are removed from the gang database unless you have an identifier that is that refreshes, for lack of a better term, your position on that gang database. I know you did not intend to impugn the integrity of police departments around this country, but I think that to suggest that they put individuals on gang databases with little more than a hunch is unfortunate. Yes, I yield.
The gentleman yield?
I will yield to the chairman.
Oh, thank you. Most police departments may behave responsibly. Most police officers may behave responsibly. Not everyone does. We had a situation in the New York Times Magazine a few months ago where some 15-year-old kid in a high school was deported because he was doodling and wrote MS, or I don't remember what he wrote, but he wrote something that the school security officer thought to be gang-related, whereas in fact it had to do with his hometown in El Salvador. Under the bill, being in a gang database is one of several identifiers which can be used, but it's not sufficient by itself. And I think American standards of justice always require that there be, now in this bill, we're not saying beyond a reasonable doubt, we're saying clear and convincing evidence, which is a lesser standard, but it's more of a standard than the secretary having reason to believe. You can't do that. At least I don't think you can do that in the United States.
And I just wanted to clarify, as I said, I don't believe the chairman intended to impugn the integrity of police departments. Having worked with gang units, they are incredibly careful on who they identify. And I will yield, reclaiming my time, I will yield to the gentleman from Florida.
Thank the gentleman for yielding. Significant distinction here is that we're not dealing with people who have a long history in every circumstance in the United States of their activity. And so I can understand the chairman's point as it would relate to people upon whom we would have a greater basket of information. But when you're dealing with people who have crossed the border illegally and may not have been in the country for a long period of time, you have to have a lower standard because you don't necessarily have a ton of evidence. If somebody shows up wearing a Zetas necklace, I feel like that ought to be sufficient. If someone shows up with a Sinaloa tattoo, that ought to be sufficient. And by hamstringing our law enforcement and not giving them the ability to reject any type of amnesty for gang members, you invite more of this illegal immigration. It is so clear to me, after having been on the border with colleagues from the committee, that the decisions we make here inform on what the human traffickers and drug traffickers and cartels do. And so if we take the position that you're allowed entry despite some evidence of gang activity, we are going to see more criminal gang members in the United States. And though it's a little odd to me that the majority is pursuing any amnesty bill at a time when we have such a crisis on the border, it would seemingly be even more unwise to extend that amnesty to people who are the most likely to do harm to American citizens. I yield back to the gentleman from Colorado.
For what purpose does the gentlelady from California seek recognition?
He's got more time.
I yield back.
Oh, I'm sorry.
And I forgot to say I withdrew my point of order. But
Point of order is well withdrawn.
it is withdrawn. I just want to clarify a couple of things. First, we're talking about individuals who are already living in the United States, people who've come as children to the United States. This is not an issue as to people entering the United States. So I think it's important to clarify that. As to the provisions in the underlying bill, it's pretty tough. An alien described in this subparagraph within the 5 years immediately preceding the date of application has knowingly, willfully, and voluntarily participated in offenses committed by a criminal street gang with the intent to promote or further the commission of some offense, and it relates to Title 18 of the U.S. Code. This is the criminal code that we adopted as a Congress, and we directly incorporate the U.S. Code, the criminal code, into this provision. So the idea is that the Secretary, even if there's no criminal offense, if there is a gang person who has violated Title 18, then that person can be precluded from participating in this program. And there are many people who are honestly immigration advocacy groups that were very anxious about the lack of a criminal conviction in this case, but I do think it's important that the Secretary have the opportunity to keep us safe and to deny someone who has violated Title 18 from participating, 521, the criminal street gang provision, from participating in this program. I think it's also important to note, as is mentioned, the database issue can be considered, but it can't be definitive. There has to be evidence. If you don't have a criminal conviction, you have to have some evidence for eliminating this person's application, and that's because they're not just entering the U.S., they've been living here among us. They're our neighbors. They're going to school with our kids. They are de facto Americans except for the paperwork, and that's why these due process provisions are enormously important for this to be a reasonable bill, which I think—
The gentlewoman yield.
I would be happy to yield.
Thank you so much. I want to thank my Republican colleagues for praising law enforcement today. I've been waiting on that since several weeks. We have argued now to protect the rule of law. that has been clearly violated over the last 2 years. Let me just say this as a law enforcement officer, someone who co-chaired the Regional Gang Task Force in the state of Florida. Police officers who investigate gangs never use one indicator to determine who is a gang member and who is not. There are a series of indicators that we review. And let me also remind my colleagues on the other side of the aisle, while racial profiling has unfortunately been used in this country to determine who were criminals and who were not, thank you, Mr. Chairman, for saying the overwhelming number of law enforcement do it right. They do. But racial profiling is not an acceptable indicator. If this discussion is about public safety, the arguments that have been put forth by my Republican colleagues are totally unjustified. Thank you, gentlelady, and I yield back.
Thank you. And it's great to have the former police chief here who can talk about her experience. I'll just note that the 2016 audit of CalGang's database, called CalGangs, identified 42 individuals who were under the age of 1 year old in the gang database. Now, that obviously is wrong. Now, that doesn't mean that the police officers are bad people or that they aren't doing their best or that we don't respect their efforts. It's just that there can be errors in this, and you can't just say this is the answer, this is the definitive solution without more evidence. So I just wanted to make sure that we clarified that, and I, with that, would yield back the balance of my time.
Question occurs on the amendment. Gentlelady from Arizona. Oh, gentlelady, for what purpose is gentlelady? For what purpose does the gentlelady from Arizona seek recognition?
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady's recognized.
Yes, I think it's unclear, this language in the bill is unclear what it says. On page 11, D, evidentiary limitation, for purposes of subparagraph C, allegations of gang membership obtained from a state or federal in-house or local database or a network of databases used for the purpose of recording and sharing activities of alleged gang members across law enforcement agencies shall not establish the participation described in such paragraph, meaning.
Correct.
So what some of the lawyers over here that I talked to, all of them that I talked to, said what that means is you can't use it.
No.
You can't use what's in the database at all. So I think it's really quite unclear, because if I know what you're saying is that you could use it, but what we're hearing I'm hearing on my side is lawyers saying, no, that's really unclear. From their description of this.
The gentlelady yields an
means,
answer to your question.
As soon as I can finish, please. Sure. That it says you can't even use it. And so I do support my colleague's amendment so that it's clear, because I think we all have the same goal. We don't want gang members to be given green cards. So yes, I will yield.
I thank the gentlelady for yielding. I don't think there's any ambiguity. The provision says the shall not establish the participation. Shall not establish doesn't mean that it cannot be used as an evidentiary matter. It is not conclusive, it does not establish the point, but it can be, as the secretary compiles evidence to make a clear and convincing case, this could be part of it. If all he's got is the database, it's insufficient. To meet that clear and convincing evidence.
And thank you.
standard.
I'd like to just reclaim my
I
time
yield back.
for a minute. I think it could be clearer if it said it shall not solely establish or something to that effect. But I'm telling you, I've asked several people, lawyers on our side, and they believe that it would prevent the use of the database that law enforcement has worked on. And so, again, I support my colleague's amendment.
Will the gentlelady yield for?
Yes, I will yield.
Yeah. Yes, it's not just attorneys on this side, but in the memorandum from it says the Honorable Gerald Nadler, Chairman, to members of the House Judiciary Committee on page 5, it says Section 101C3D prohibits the use of gang databases to establish gang participation. It doesn't say that it cannot be the sole determinative factor. It says you cannot use them.
No. Would the
And
gentleman
so,
yield?
I'm just using your own words, Mr. Chairman.
the gentleman
Yeah,
yield?
and it's my friend Ms. Lesko's time.
Would the gentlelady yield? Thank you. Establish is used as a legal term meaning determine definitively. So when it says shall not establish, when the memo says shall not establish, it means that by itself, it cannot determine it definitively. It does not mean it cannot be a factor or one of several data points, one of several pieces of information. The word establish has a very definite meaning. Establish means you've proved it. It doesn't prove it. It's one point of evidence. And that's what the bill means, and that's what the memo means.
Can I reclaim my time?
Sure.
Do you believe it's the Chairman, I just have a question then. Do you believe then that the information in the database from state or federal, in-house or local databases, the network, can be used by the Secretary then to help establish that there is a gang?
Yes, that's the whole point. It can be used to help establish. It cannot be used by itself to establish.
Should have said that.
Mr. Chairman,
For what?
can I move to?
Yeah. For what purpose does the gentlelady from Washington seek recognition?
Thank you, Mr. Chairman. Move to strike the last word.
Gentlelady's recognized.
Thank you. Mr. Chairman, we have established that the gang databases can be used as one factor, but I want to just say the problems that we see with the gang databases and why they cannot be the only factor. Gang databases sound like a really helpful technological answer to a scary problem, but the reality is they are full of inaccurate information and they are racially biased in who they do and don't include. And specifically, young men of color are often entered into these databases for non-criminal activities, and once they're in the database, it is virtually impossible to get out of them. So what is a gang database? A gang database can be operated by law enforcement, city, state, or region. There is no uniform criteria for who is a gang member or even what a gang is. So who is in the database really varies widely. They are also a vehicle for racial profiling. While white gang-affiliated youth are under-policed, while youth of color are over-policed, which means that the gang databases rely primarily, they contain primarily information about people of color. And I just want to give you a couple of stunning statistics. 99% of the people in New York City's gang database are people of color. 70% of the people in Chicago's gang database are Black, 25% are Latinx, and less than 5% are white. 95.3% of people added to the Chicago gang database before they turned 18 are Black or Latinx. In Portland, Oregon, the police stopped using gang designations in their database after a report revealed that 81% of the people flagged as gang members were people of color. So there are no clear uniform set of criteria for adding a person, and most people are added to the California gang database, even though they have never been arrested or accused of criminal activity. And I'll have a couple of reports to ask for unanimous consent to enter into the record. The Cook County, Illinois Sheriff's Office has a 25,000-person gang database that includes hundreds of people whose gang affiliations are not known and hundreds of others who are dead. State gang databases are riddled with inaccuracies. A California state auditor report revealed that the Cal Gang database contained, quote, questionable information that may violate individual privacy rights. A group of 4 men in Illinois sued the Chicago Police Department, arguing the gang database was racially biased and full of mistakes, which led to false arrests, lost job opportunities, and deportation proceedings. People, mostly young Black and Latino men, have been entered into gang databases for giving a friend a ride, liking posts on Facebook, or possessing a single unopened beer can. In New York City, the New York Police Department places people in their gang database merely based on who they appear with in their social media postings. A 31-year-old dance instructor in California was entered into a gang database because he lives in a working-class neighborhood in South Los Angeles and was pulled over, not even arrested, but just pulled over while giving an old friend from high school a ride home. A young man in Chicago was arrested for being in possession of a single unopened Bud Light can. And although he was never prosecuted, he was entered into the Chicago gang database, which later prevented him from being able to get immigration relief through the DACA program. So I think these gang databases are a constitutional gray area with little to no due process. And unlike criminal trials where defendants may see the evidence against them and defend themselves, people may be placed into a gang database without ever being told. They often have no way of appealing that decision. There may be no clear decision maker, in fact. And the mostly young people who are placed in these databases have no counsel assisting them to appeal being placed into those databases. I have two reports that I'd like to ask unanimous consent.
Without objection.
Thank you, Mr. Chairman. And so I just want to say we have included the ability for these gang databases to be one part of what the Secretary considers, but they cannot be the sole thing that is relied on because they are shown to be riddled with inaccuracies and fallacies. And just yesterday in Ed and Labor, we talked about this in terms of barriers to employment for everybody. This doesn't just affect immigrants, of course, it affects everybody. And so this is something that the chairman, Bobby Scott, has a bill on, and I think it is really something we need to continue to look at and refine so that these databases are actually useful. I will.
I thank you. I just want to remind people that this amendment does not deal only with gang databases. It says, which is a problematic by itself, but it says the Secretary, you can exclude someone because the Secretary has reason to believe the alien is a member of a gang. We don't deprive people of rights in this country because someone has reason to believe without any standard of proof.
I yield back.
Gentleman from Arizona, for what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I support the amendment, and I yield to my friend, the ranking member, Mr. Collins.
Thank you. I appreciate it. And look, we've just established this, and I think the interesting thing is, and it's been very well documented from the majority, that it's still not established, in other words, be the only thing. But however, by wording it in the way you have done, if someone does a due diligence check, they have nothing in front of them except the individual who is there, and they run a database check, and that is their indicator that this person, rightly or wrongly, or probably in most cases, mostly right, owned to be on the database, then by this language right here, the Secretary has to let them in. They cannot, no, Mr. Chairman, it says shall not establish. And this is, you might want to check this from not just my side, but your side. If it is the only thing you're using.
It's the only thing, yes.
Which now you have bound the Secretary's hand on the vast majority of good policy and police work that has been done. So if it's on the database and that's the only thing after doing due diligence that they have to go on, the Secretary's hands are bound and cannot, even if they're on the database, even with good reason, even with everything there, they cannot. This amendment fixes that, but the wording of the bill itself ties the Secretary's hands. It does if that is the only thing. And you can deny it, but you can read it. It's not my time.
Reclaiming my time, and I yield to the gentleman from Texas, Mr. Gomer.
I thank my friend, and I appreciate the concern of the chairman about the reason to believe standard, and I would direct him to the Immigration Naturalization Act because he will find that those terms, reason to believe, offered and made part of the law by Democrats over the years, it's throughout. In fact, if you look at Section 20 or 212, it says, any alien who the consular office or the attorney general knows or has reason to believe. This kind of stuff is throughout the law, so I appreciate the newfound concern. And also, I want to say I appreciate my friend from California acknowledging there is no evil intent in offering this, and I greatly appreciate that, unlike the chairman. And I didn't ask his words be taken down because then he'd have to find himself having made inappropriate comments. But to state earlier, as you did, that the intent of this amendment is to scare, basically fearmonger, is totally inappropriate. And it's not true There are problems in the law, and you are going to leave, if this becomes law as you have unamended here, it becomes law. Gang members will be left in this country to kill and create mayhem. These were 14-year-olds just this week in Maryland that I referenced and are part of the record now. And this killing goes on. But if you look at the amendment, in addition to using the same standard that Democrats put into this law about reason to believe that now they're so offended by, it says that the person making the determination, it can be delegated because of the end of the amendment, but that you can look at all of these pieces of evidence. And I'm not familiar with the California database, and I certainly take my friend from California at her word when she says it's not trustworthy. Fine, but it should not be, or other states who have very good databases, like my friend Mr. Buck pointed out, where the names are eliminated every 2 years. You have to have new information, new evidence of gang activity and affiliation. But when you're identifying gang members, all of these things come into play, and there is no racial profiling here. It's about, is this person a member of a gang? And if we're going to decide as a matter of fact that this committee thinks it's just fine to have lots of deadly, violent gang members here, and it's fine to leave most of them here, well, you can be assured the amendment in the nature of a substitute will allow that without this amendment, and you will continue to have the kind of murders you did. Machete, baseball bat, this kind of stuff.
Mr. Chairman,
I move to
can I
strike the
please
last word.
respond? This is really getting a little out of hand here.
Well, thank you for using my time, but it is my time, and it's not getting out of hand. We're talking about trying to save lives. That's the intent of this amendment, and it will help the overall bill, and I ask people to vote for it.
The gentleman's time has expired. For what purpose does the gentlelady from Florida seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized.
Mr. Gohmert, I didn't see this much excitement when we were here for hours trying to save lives, trying to pass the gun reform bill, universal background checks. I did not see that much interest in protecting lives.
We have
lose
different
more
ways
lives
of
to
trying
gun
to do
violence in this
Gentlelady
country
has
than
the
we
time.
do to immigrants committing crimes. Now, first of all, welcome to all of you for being here. This is your house. You have entered the people's house. You are Americans, except in paper, and we will make sure that by the end of this hearing, we pass the Dreamer, TPS, and Venezuelan TPS bill through committee. So thank you for being here with us, and I apologize for any insulting comments, because I just want to also remind my colleagues across the aisle, when you use language like illegal aliens, I would like for you to just take one moment and see how everyone reacts to that language. I am an immigrant. I am not an extraterrestrial. No one here is an alien. We are immigrants that have come here to work and to contribute. Like Mr. Gohmert
Would the lady yield? Would the gentlelady?
No, not yet. I'm taking my time here. We have millions of dreamers that have been waiting for this moment. And I just want to bring up a fact as it relates to this amendment. In 2017, Customs and Border Patrol showed that it apprehended over 310,000 undocumented persons. Of those, only 228 were identified as affiliated with any gang. That represents 0.0007% of the individuals apprehended. Now, let me make something very clear. None of us want to give green cards or citizenship to dangerous criminals or gangsters. I want to make that very sure that everyone understands. But the bill accomplishes that by barring applicants convicted of a serious or repeat offenses and by giving the Secretary the discretion to deny anyone who poses a significant threat to public safety. Now, to my Republican colleagues, you either trust the Secretary of the Department of Homeland Security that was appointed by your president, or you don't. So the bill before us makes a smart, targeted, and effective approach to the criminal and other bars of eligibility. What I am very concerned about is that comments like the one from my colleague across the aisle, Matt Getz from Florida, saying that one tattoo should be enough to make the decision that someone belongs to a gang is extremely dangerous and extreme. It's racial profiling. And let me remind Mr. Getz that in Florida alone, we have close to 200,000 dreamers that are waiting and watching to see what we're going to do today in this committee. Now, one last thing that I would like to point out. In 2013, the United Nations High Commission for Refugees interviewed over 400 refugees from across the world, and most of them who are being displaced to the United States, 63% from El Salvador, they've reported that they've experienced or been threatened with gang-related violence. So most of the people coming here, they're escaping gang violence themselves. They're not coming to commit crimes. Now I would like to yield to my colleague here, Veronica.
Thank you so much to my colleague. You've articulated so beautifully many of the points that I wanted to make. I want to just say one last thing, and I want to acknowledge the work that my colleague Zoe Lofgren did on this bill. And I want to assure the public of a couple of things. Number one, Ms. Lofgren and the folks on this committee who want to see progress on this thought long and hard about all of the ways to make sure that we propose a bill that we can be proud of, and that does two things, that keeps communities safe, but number two, keeps our promise to dreamers and to their families. What saddens me about today, and we're about to engage in many hours of this, is that brown people, you will see, will be demonized over and over and over again. And they're being demonized in this way to fuel a belief about us that we don't belong here, or that we are unworthy of citizenship. We are, you are, and we are going to work through the night, if we have to make sure we get this bill passed.
We're not.
All right, say your name.
We're not.
Mr. Chairman?
Does the gentlelady yield back? Does the gentlelady yield back? Gentlelady, the time of the gentlelady has
I
expired.
yield back.
Mr. Chairman, you promised to recess for lunch.
The committee will now stand in recess. As I announced before, we're 8 minutes late. The committee will stand in recess until 1:30. The committee is in recess. Hello, 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 hello. Does it work? Can you hear it? Can you hear it? Committee will come to order following our generous lunch recess. Before anything else, I want to ask unanimous consent to put into the record statements in support of the bill by 2, 4, 6, 8, by about 15 different groups from the American Immigrant Lawyers Association, America's Voice, New York Immigration Coalition, National Council of Jewish Women, and a few others. Without objection, these are entered into the record. Before we proceed, I want to remind members of the following. The critical issues we are addressing today, which go to the very core of our constitutional democracy, understandably bring out strong passions in us as they do in the American people. Nonetheless, I must again remind all our committee members that House rules and precedents require us to refrain from impugning the personal motives of another member, accusing a member of bigotry or racism, claiming that the member is hypocritical or lacks decency, questioning a member's sincerity, or accusing a member of making a falsehood. These admonitions apply as well to remarks impugning the motives behind legislation. Members are certainly permitted to voice critical opinions of Congress, of the House, and of political parties. So I hope that what should be a spirited discussion of these issues today will stay focused on the issues, not on the motives of the people addressing the issues, and we'll take care to keep our comments in compliance with House rules for decorum. When we recessed, we were discussing the amendment by the gentleman from Texas, Mr. Gomert, and I now recognize the gentlelady from Texas who was seeking recognition. For what purpose does the gentlelady seek recognition? The last word is duly struck, and the lady is recognized.
Let me, as my colleague has indicated, express appreciation to those who have come to see the civic process who are in the audience, and some of them, their lives are being impacted by our discussion, and we want to be upholding the standards, Mr. Chairman, that you have offered, and we want to do this in keeping with the desperate needs of so many. So Mr. Gomert and I certainly have worked together, and I can appreciate his concern. But I must bring my life experience to the table, and I also will indicate that the language has reason to believe he's correct. It's in other legislation that has not been negated. And so our legislation has a particular focus, and those of us who live in communities where we understand the unfortunate circumstances of racial profiling and the idea that someone may think you are something, there is no doubt that no one will stand against the dastardly acts of MS-13. We've seen them. If you live in this area during the week, you've heard, when I say live in this area, those of us who are not from this region, but we can hear news reports, and we know that there are certain dastardly acts going on under the leadership of MS-13, and we want nothing to do with them. But we also know that young people, those who are impacted, who have a future in life, may be subjected to reason to believe with maybe good intentions, but it may be defined by who you are. And I think that's troublesome, and I think we've written this language in a way that protects the American people, but gives the right balance to make a fair assessment of those who are seeking relief. Section 101C3C of the bill expressly authorizes the Secretary to deny an application if a person has directly participated in criminal gang activities, not passed by the gang, or someone believes they saw something that looked like you. The authority is so broad that the Secretary can even deny an applicant on these grounds when there is no underlying conviction. We wanted to be sure and safe. But for those of us who've interacted with Dreamers and others who we've seen interact in our communities, who we've listened to the desperate pleas of their family members, we understand, or in the instance of those of us who are African Americans who've been fighting against racial profiling for such a long time, it is readily well known, and let me juxtapose this against the good law enforcement and other professionals in and out of the immigration system, there are good people. But we know that the cases of racial profiling are not lacking, and some have even lost their life because of unfortunate circumstances. And so I want to put into the record this particular comment. For example, the gentleman who was nominated to serve as head of ICE by this administration said in a recent interview on Fox News concerning migrant children, maybe little Laura, who's 11 years old, who was unfairly deported because she was in the courtroom and someone overworked, as I said in my earlier statement, told her she didn't need to be in the courtroom, and lo and behold, after coming for 10 times, she got a deportation order, an 11-year-old girl back to El Salvador where they had fled violence. But this is his statement. Nominated to serve as head of ICE, said in a recent interview on Fox News concerning migrant children that he can tell a future gang member by looking into his or her eyes. I've looked at them and I've looked at their eyes and I've said, that is a soon-to-be MS-13 gang member. It's unequivocal. Maybe if you're an African migrant, you are a soon-to-be black identity terrorist. Look into your eyes of 10-month-old Roger that I held in my arms, or look into the eyes of a toddler. Mr. Chairman, let me just say that I appreciate the intent, but I am comfortable with years of experience dealing with these issues on this Judiciary Committee, this august committee, that we have framed it in a way that we will protect the American people, but we will do justice to those who seek justice. I yield back.
Mr. Chairman. Gentleman from Virginia. From California is recognized.
Thank you, Mr.
For what purpose does the gentleman seek
To
recognition?
strike the last word, and I'd
Gentleman is
like to
recognized.
yield my time to Mr. Biggs.
I thank the gentleman for yielding time. And I raise this not to be facetious or to bring jocularity into this hearing. I am serious about this because prior to our recess, someone had mentioned that they had taken a great offense to the term alien or illegal alien. And so a couple of things came to my mind as I looked at that legal term of art, alien, which is actually on page 1, line 13 of the bill itself, and on page 2 is 4 times. If you read the bill, the term alien is repeatedly used. And the reason that it's used is because it's a legal term of art. And so to help the person who is offended so they will know that there's no need to be offended, that we're speaking strictly whatever side, whether you support the bill or don't support the bill, we're talking about in terms of legal language. I was reminded of a song by Sting, which actually explains this term. It's called An Englishman in New York. And in that song, the refrain goes very simply, as he explains through the chorus and the verse that all of the British habits that he retains, that make him British and an Englishman. But he is legally visiting New York. And so the chorus says, I'm an alien. I'm a legal alien. I'm an Englishman in New York. There's a distinction, you see, because an alien means that you're a person who is not a citizen of the country in which you live. You may be legal, you may be illegal. If you're legal, you have obtained the requisite authorization to be in the country as an alien, though you're not a citizen. If you are illegal, it means you have not obtained the requisite authority to be here, though you are an alien. So it's not meant to offend, it is merely meant to convey a legal term and a legal meaning. So again, I'm not trying to be facetious or jocular in any way. I'm just trying to explain it because it seemed like there might have been some confusion on the part of that. And I would just, again, say, if one were to look at the bill that the person was propounding, you cannot find too many pages without apparently the offending language in there. And I'll yield back to the gentleman from California.
Reclaiming my time, I yield the balance to Mr. Goldberg.
Thank you. I appreciate my friend from California. So I was criticized for using the word alien that's repeatedly used by the chairman in his amendment in the nature of a substitute. I'm sure the chairman didn't mean anything offensive by use of that term alien, just as I did not. And then, a little tongue-in-cheek, I was commended for finally joining the joining the Democrats in fighting violence. And obviously, people on this panel ought to know something about the background of the people they are belittling. I've spent a great deal of my adult life fighting violence and fighting it successfully. We have different ways. The ways I used as a prosecutor and as a felony judge for general deterrence, specific deterrence, it was part of my job. I helped diminish violence. So I'm glad to have some of my Democratic friends coming late to the game to join me in that fight. We see that MALDEF, and I'm not sure what that stands for, but apparently they've sent out word to my colleagues across the aisle that they are opposed to the Gohmert Amendment. And I'm sure they didn't do it intentionally, but mischaracterized the amendment. They said that this amendment would expand the definition of criminal gang participation to define gang membership to include being listed on a federal, state, or local gang database. And that's simply not the case, so they don't have to worry. They're wrong about that. What it does is allow the secretary to consider all credible evidence of membership, participation in a street gang, including evidence that may be obtained through a database. But there has to be sufficient evidence in the database that would be appropriate to be considered and used. And the article, I know someone was offended when it said I was getting out of control when I mentioned being beat by a baseball bat and stabbed repeatedly with a machete. That's from what just happened by an alien who was in the country illegally, and multiple aliens, and part of a gang, and that's what they did to this 14-year-old girl. I yield back.
Gentleman yields back. The question occurs on the amendment. All in favor of the amendment say aye. Aye. All opposed say no. No. The noes have it. The amendment is not agreed to. Roll call is requested. The clerk will call the roll.
Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon? No. Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton? Ms. Dean?
No.
Ms. Dean votes no. Ms. Mucarsel-Powell?
No.
Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gohmert? Mr. Gohmert votes yes. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe, Ms. Roby, Mr. Gates, Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stube? Mr. Stube votes yes. Mr. Cohen votes no. Mr. Deutsch votes no. Mr. Neguse votes no. Mr. Chairman, there are 10 ayes and 17 noes.
The gentleman from Colorado.
I have an amendment to the desk, Mr. Chairman.
I reserve a point of order.
Clerk will report the amendment. The gentlelady reserves a point of order.
Buck number 1 to ANS for HR 2820 description. Provides that the Secretary shall have access to the Interstate Identification Index System, 3 system, which is accessible by way of the National Crime Information Center, NCIC, portal when conducting any of the background checks required by this legislation. This access will allow the USCIS to adjudicate applications more efficiently and accurately.
Without objection, the amendment is considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, I have looked high and low for common ground with the chair of this committee, and I think I have found it with this amendment. My amendment is very simple. What it does is it allows the United States Customs and Immigration Service access to the very best and most comprehensive background check database the government has in order to assess whether an applicant has a criminal history. According to USCIS, the right database is the full Interstate Identification Index, or III, Interstate Identification Index, III database. USCIS needs access to this database to conduct background checks. Without access, the agency will not be able to tell us whether an applicant poses a public safety or national security risk. In addition to the benefit of denial, certain information may establish grounds for administrative investigation, criminal referral, and initiation of removal proceedings. USCIS has needed access to III for some time. Since 2013, they have adjudicated nearly 50 million benefit requests without full access to criminal history records of the applicants. My amendment will give USCIS access to the III database so that they can use that in processing applications filed in response to this bill. This is the right thing to do. We should not tie DHS's hands by denying them access to critical information. We should let DHS fully vet applicants using the best information we have available. 9/11 happened because Congress allowed a wall to remain in place. That wall denied access to critical intelligence information to domestic law enforcement agencies. Today, a similar wall is in place that denies USCIS access to the best information available about a foreign national's criminal history. We need to tear down that wall. We need to give USCIS the right tools to do the job that Congress is directing them to do. Mr. Chairman, I have heard on the last amendment a number of my colleagues on the other side of the aisle talk about the need for and how this bill includes public safety safeguards. This amendment just gives the government access to information that it needs to make that evaluation. And I would ask for the full committee's support, and I yield back. Yes.
Pardon the ignorance, but exactly what is the Interstate Identification Index 3 system that you reference here?
So, Mr. Chairman, there is a national, an NCIC, National Information System.
Right.
Criminal information, and then there is a state. So in Colorado, we have the CCIC. Not all states allow criminal information to go into the NCIC. And not all states allow criminal information, I'm sorry, not all states allow criminal index information to be used by non-law enforcement agencies. USCIS is a non-law enforcement agency. It is not like the FBI or other law enforcement agencies. So this would give the...
Reclaiming my time, if it's my time.
You can have it.
The bill says, the sentence that you want to amend, says the Secretary shall use biometric, biographic, and other data that the Secretary determines appropriate to conduct security and law enforcement background checks and to determine blah, blah. You would add, the Secretary shall use all this data that he deems appropriate, including checks in this system. So my first question is, if he deems it appropriate, can't he do it under the terms of this bill without your amendment?
No, because he doesn't have access to criminal information. This is not a criminal agency and doesn't have access to criminal databases. So they need Congress to authorize.
So what kind of information would there be here that he wouldn't have access to?
So an individual who is convicted in one of the states, and I can list those states for you if you'd like.
Don't list the states, just go ahead.
Oh, there's 11 of them, and they include California and Texas,
Okay, all right.
relevant states for our purposes of
For those states, what would this do?
Those states prohibit non-law enforcement agencies having access to the data that they put into NCIC.
So this would override the state prohibition?
This would allow Congress, this would designate USCIS for this purpose to have access to that information.
Despite the state prohibition?
Well, the states are prohibiting it from being used for a criminal database check.
Okay, I think I understand what you're talking about now.
Okay.
Mr. Chairman?
Let me just say, before I recognize anyone else, I am inclined to say that this amendment may be okay. I'm not prepared to accept it now, because we really have to look at the implications of it, and based just on the very spare information we just got, it's not enough. But I'm prepared to work, if you withdraw the amendment, we'll work with you toward seeing if it makes sense to put it in before the bill, gets to the floor. I'm not making a commitment to do it or not to do it, except to explore it, because I really don't know at this point.
Would it be possible to re-offer it at the end of the markup?
I'd have to oppose it because we don't have nearly enough information. Before the floor, we'll consider it, we'll talk with you, and maybe we'll say yes and maybe we'll say no, I don't know. But let me just say this. We're not going to know I don't know that we'll know a heck of a lot more before the end of the market. Maybe we will, I don't know. So I won't make a commitment on that.
Well, I will withdraw it now. I'll ask the chair at the end of the markup whether the chair would be willing to consider my amendment at that time.
Sure. Could we ask for postpone? This is just
Yes,
postponing
yes.
consideration of this
Certainly,
amendment, then
certainly.
because this is gonna be a long markup, they can do that.
Certainly.
Great. I will do
You
that.
can withdraw the amendment without prejudice. You can offer it again later. I may have the same answer, we may have a different answer, we'll see.
I will withdraw the amendment, Mr.
The
Chairman.
amendment is withdrawn temporarily. Are there any other amendments? The gentleman for what purpose does the gentleman from Arizona seek recognition?
I have an amendment at the desk.
Gentleman,
I re-
clerk will report the
I
amendment.
reserve a point of order.
And the gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. Biggs of Arizona.
The amendment is considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. My amendment deals with confidentiality, and H.R. 2820 contains an expansive confidentiality provision that prevents information contained in an application from being used for certain law enforcement purposes, including immigration enforcement. The bill specifically states, and I quote, "The Secretary may not disclose or use information, including information provided during administrative or judicial review, provided in applications filed under this act or in requests for DACA for the purpose of immigration enforcement, close quote. Instead, the information can only be shared with law enforcement authorities for considering the application, national security purposes, or investigation and prosecuting felony offenses not related to immigration status. This would allow aliens who submit fraudulent applications that prove they are illegally in the United States to escape prosecution or deportation. Similar confidentiality provisions in the 1986 amnesty incentivized widespread fraud in the program and have hampered law enforcement efforts. My amendment would strike the confidentiality provisions in the bill and replace them with the regulations that are currently in place for aliens applying for temporary protected status. This would allow for information in the applications to be used by Department of Homeland Security or any federal or state law enforcement agency for enforcement of the act or in any criminal proceeding. Given that currently there are more than 400,000 people who have temporary protected status, these privacy regulations clearly are not serving as a deterrent to filing honest applications. It's disappointing that efforts weren't made to prevent fraud in the system, but I believe this amendment is a step towards rooting out fraud, and so I would encourage everyone to support my amendment, and with that, I yield back.
The gentleman yields.
Mr. Chairman.
Gentlelady from California. For what purpose does the gentlelady seek recognition?
I move to strike the last word, and I withdraw my reservation.
Gentlelady is recognized.
I oppose the amendment, although I am sure it is well-intentioned. We do have some fraud prevention provisions in the bill, but the confidentiality provisions in the bill are very important. Confidentiality has been recognized as critical to the success of a variety of immigration benefits and initiatives, including VAWA, U-Visa, special immigrant programs, as well as previous legalization efforts. Confidentiality provisions are critical to gaining the trust of qualified individuals and to yield maximum participation, and this bill is no different. What is different in this bill is the narrowness of the confidentiality provisions. Past bills have prohibited the use of information provided by applicants for any reason other than to make a decision on an application, but this bill actually provides for much more. It allows such information to be shared to identify and prevent fraudulent claims for national security purposes or for the investigation or prosecution of any felony offense not related to immigration status. All applicants under this bill, those who've never been in removal proceedings and those with final removal orders, will be asked to come forward and disclose sensitive information related to their immigration status, their immigration history, their lack of current status, and they will likely need to disclose sensitive information about their family members as well. The President and his immigration and his administration have been hostile to immigrants in their rhetoric from the beginning, and the immigrant community is understandably fearful, and I would say justified in their concern about what might happen with this information if there are not clear limitations set forth in the bill. And for this reason, the confidentiality provisions in the bill prohibit the use of information disclosed in applications for immigration enforcement purposes. Now, if this prohibition is watered down or even removed, information disclosed in any application could be used for any purpose, including targeting family members for enforcement, and that would defeat the very purpose of this bill. I think the bill takes a very smart, balanced approach to confidentiality by giving assurances to applicants that their information will not be used for immigration enforcement while giving more than enough leeway to DHS and other federal law enforcement agencies to carry out their mission. So I think this amendment is unnecessary and also destructive of the confidentiality provisions included in the bill. I would point out further, as I said earlier, the bill's limits are narrow. Information could be used for fraud, national security purposes, or prosecution of non-immigration felony offenses. And with that, Mr. Chairman, I would yield back.
Mr. Chairman.
Gentlelady yields back. For what purpose does the gentleman from Georgia seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Look, I'm in support of the amendment. I think it's really interesting, and I appreciate the gentlelady from California. We've had some great conversations about this over time, and especially some of the best conversations we've had about the coming forward and giving information has come from your side, especially our former member, our gentleman from Chicago, Mr. Gutierrez, who was very critical of the DACA program because of the very things that you just cited. And I think that is something that's really interesting here, because the very program that President Obama actually put forward was causing people to actually have to do some of the similar things. So it's an interesting point to make now in opposition to, as the very program itself caused this to happen. So with that, I yield to the gentleman from Arizona.
I thank the gentleman from Georgia, and I just want to point out something that I think is important for clarification. I see people in our audience that are wearing T-shirts that say Save TPS, and I get that, because we're going to consider two bills dealing with TPS later in this markup session, whether it's today or tomorrow or whenever it may be. But I am a little bit baffled, because I look at the ANS to HR 549, and this is for the TPS for Venezuelans. And that's an interesting thing, because my amendment provides the same confidentiality that the majority's 549 is going to apply to all those TPS applicants. And I'm trying to understand why you're comfortable with that kind of confidentiality requirement for the Venezuelans seeking TPS, but you're not comfortable with it for DACA and in this particular bill. I do think that my proposed amendment provides adequate confidentiality, but it also helps prevent fraud. And that's really, we're trying to find that sweet spot. Apparently we found it in TPS, but that's not quite good enough for this. I would urge everyone to reconsider and vote for my amendment. With that, I yield
Would
back
the gentleman
to
yield?
Georgia.
Gentleman yielded back. Who seeks recognition? Gentlelady from Texas, Ms. Escobar.
Thank you, Mr. Chairman.
Sorry. I had mine up too. Never mind.
Ms. Escobar is recognized.
Thank you. Move to strike the last word.
Last word is duly struck.
Mr. Chairman, I oppose this amendment. And as Ms. Lofgren mentioned, the confidentiality that's been crafted so far is something that has gone through significant vetting and debate and discussion internally between many of us who are all along the spectrum on this particular bill. But I want us to remember that dreamers were promised something. And that promise was made years ago. And even when our current president ran for office as a candidate, he promised dreamers that he would protect them. That promise, we saw, was broken. And it was broken even after these vulnerable young people provided the government with all of their information because they believed that the promise was going to be kept. After that promise was broken, we then witnessed, in my community firsthand, El Paso, through the Tornillo Child Detention Facility, we witnessed firsthand how children were used as a lure for their families, and it was a trap in order to try to create more of a deportation mechanism for family members. And so why would we believe at this point that this administration can be trusted with the most vulnerable information for a population who was promised relief over and over and over again, only to see that promise broken over and over and over again? Ms. Garcia, I'm happy to yield to you if you like.
I thank the gentlelady from Texas. And Mr. Chairman, I too I want to speak against this amendment. As Ms. Lawford has already stated, if this is about preventing fraud, that is covered under the current bill as amended. And if this is as broad to mean any reason, I think it would have a very negative, chilling effect on many of the folks that we represent. I know in my district, where we have many thousands and thousands of dreamers and is a heavily Latino population district in Houston, if people knew that information was going to be shared and confidentiality would be breached, people probably wouldn't apply, and they would ask people not to apply because they would be in fear of what retaliation or what else may happen, not just to them, but everyone in their household. They wouldn't feel safe to go to school. They wouldn't feel safe to go to church, to go to a hospital, to go to a courthouse. There would be no safe place in our communities. So I strenuously rise to oppose this amendment. I think that the approach that's been used in the bill is very balanced and covers all the critical needs for any of the agencies that he is discussing.
Would the gentlelady yield?
Sure.
I reclaim my time.
You reclaim your time.
Yes,
Would
yes.
the gentlelady yield?
The
For a
gentlelady
quick
from
question,
Texas,
if you have a
Escobar,
quick
has
question.
I do have a question.
Okay, I yield.
Thank you. My question is the concern that you have is that this will it'll provide a chilling effect if my amendment were in place. I guess my question is, you don't see the same chilling effect on the TPS bill, HR 549 that we're going to consider? Why is this uniquely different? And then as well, can we deport somebody if we determine from their application that the individual is ineligible? The provisions under the current bill doesn't seem to indicate that that would be possible. So that's the kind of question I'm trying to get at.
Mr. Biggs, thank you. If we could have made those amendments and offered more confidentiality to TPS recipients, I would have liked to have done that. This population, again, very vulnerable, we've made a promise to them, promises that were made by a prior administration, promises that were made by a candidate who then became president of the United States, promises that have been not kept. And vulnerable communities are living in fear. And so if we want folks to come forward and to provide all that information, we have to protect them. And so I think the protections that already exist against fraud in the current bill are sufficient, and I yield back.
Who seeks time? All right, the gentleman from Louisiana.
Mr. Chairman, I would oppose the amendment for all the same reasons, but I'd like to yield a few minutes, 2 minutes to Zoe Lofgren.
Thank you. I just thought it would be important to put into the discussion here the actual language in the underlying bill of what can be shared. For assistance in the consideration of the application for justice of status under this act, to identify or prevent fraudulent claims, for national security purposes, or for the investigation or prosecution of any felony offense that's not related to immigration status. So I think anything that is a concern raised by this amendment is covered in the underlying bill, but the threat that immigrants feel is palpable. And I know that as a Californian, that, I've got constituents who are U.S. citizens with legal permanent resident spouses who are afraid to get an official document. So the level of fear is very high, and if we don't have confidentiality in this process other than for these exceptions, we will really chill participation. And I thank the gentleman very much for allowing me to speak, and I yield back to Mr. The gentleman has the time.
Would my friend from Louisiana yield to me?
Sure.
Thank you. And I just real quickly, and I understand the argument here of chilling, and that was actually argued, as I said just a few minutes ago, by Mr. Gutierrez when he was here. That was one of his biggest arguments against the DACA program itself, is that it forced this problem. But I don't think the chilling effect, and we can argue about how and not, but there's been 400,000 folks apply for TPS. It's not seemed to be a chilling effect in that regard. And I think, applying the same standards, is something that could be valid here. And I appreciate the gentleman from Louisiana yielding.
I still disagree with you, and I yield back.
The gentleman yields back. The question occurs on the amendment. All in favor of the amendment say aye. Aye. Opposed, no? No. The amendment is not adopted, is not agreed to. Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Steen?
No.
Ms. Steen votes no. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes. Mr. Deutsch votes no.
Are there any other members who wish to vote who haven't voted? The clerk will report.
Mr. Chairman, there are 10 ayes and 18 noes.
The amendment is not agreed to. Are there any further amendments? For what purpose does the gentleman from California seek recognition?
I have an amendment at the desk.
I reserve a
Clerk will-
point of order.
The clerk will report the amendment. The gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. McClintock of California.
The amendment will be considered as read. The gentleman from California is recognized to explain his amendment.
Thank you, Mr. Chairman. One of my many objections to this bill is that it sets a lower threshold for illegal immigrants to obtain green cards than we have for legal immigrants. My amendment simply applies to illegal immigrants in this bill the longstanding discretion that the DHS Secretary has had when determining eligibility for immigration benefits, including adjustment of immigration status. I offer this amendment to test whether the majority really believes that illegal aliens should be treated better than legal immigrants who have respected our laws and done everything our country's asked of them. As it's written, H.R. 2820 strips the Secretary of his current authority to consider discretionary factors when determining whether an illegal immigrant is eligible to receive permanent lawful residence in our country. The special path to citizenship that H.R. 2820 offers is a significant benefit, essentially the keys to our country. Under our law, the vast majority of other immigration benefits provided through the Immigration and Nationality Act, including adjustment of status, are discretionary, and the legal immigrants must demonstrate that they merit the status in the exercise of that discretion. But this bill states that the Secretary shall adjust the status of an alien, so the Secretary cannot consider discretionary factors that weigh in favor or against granting such status. Under the bill as written, illegal aliens arrested for heinous crimes but not yet convicted would get green cards. Aliens who commit heinous acts but who are not convicted for technical reasons would get green cards. The alien is technically eligible. The Secretary must grant the benefit and is powerless under the law to deny it. The illegal aliens given green cards under H.R. 2820 should be no different than any other alien who tries to adjust status. The Secretary should be able to consider discretionary factors that weigh in favor of or against granting such a status. Of course, the change from shall to may in my amendment is consistent with other parts of the Immigration and Naturalization Act and does not mean unfettered discretion. The Secretary cannot abuse the discretion, but a mandatory benefit will constrict determinations that are best left to the agency experts who know all the facts about a specific case as they carry out the truly serious responsibility of providing benefits under H.R. 2820, which includes a green card and a path to U.S. citizenship. I'd urge my colleagues to support the amendment.
I recognize the gentleman yields back. I recognize myself in opposition to the amendment. This amendment basically cancels the entire bill. What the bill says is that if you meet certain requirements, you are entitled to certain benefits, namely to a path to citizenship and so forth, to stay here and to have a path to citizenship and so forth, if you meet the requirements established in the bill. And I don't have to go through what those are, we all know them. What the amendment says is, if you meet the requirements of the bill, the Secretary may cancel the removal instead of shall cancel. In other words, the Secretary could abolish the entire program with a stroke of his pen. Or he could cancel half the program with a stroke of his pen. Or he could say, the program continues except for Joe. I don't like Joe. So Joe doesn't get admitted under the Dreamer, as a Dreamer, even though he meets all the requirements of a Dreamer. This makes the program entirely discretionary as opposed to a mandatory program. The whole idea of the bill is we are establishing a program. Congress is deciding that people who meet certain requirements, they were brought here under the age of 18, before a certain date, they haven't misbehaved, they haven't committed crimes, they're not whatever, are entitled to a path, are entitled to stay here, are entitled to work permits, are entitled to a path to citizenship. That's the purpose of the bill. What this amendment very innocently says in 4 places is the word shall be replaced with the word may. It makes the entire bill discretionary with, not only with the Secretary, but with any Secretary. The current one is good and says okay, and the next one is bad and says no. And the guy who comes in afterwards says, anybody still remaining in the country, it'll be okay again. Or on an individual basis. It's absurd unless you're opposed to the bill. If you're opposed to the bill, then vote against the bill. But don't make the bill entirely discretionary on an absolutely arbitrary basis, and period. So we have to oppose the amendment. The amendment basically says, never mind the whole bill. I oppose the amendment. I yield back.
Mr. Chairman. Move to strike the last word. Move to strike the last word. And I yield my time to Mr. McClintock from California.
I thank the gentleman for yielding. I simply wanted to point out that the chairman has just very accurately described the discretion that the DHS Secretary already has for every other alien who applies for a green card. That's already in the law. If you're a legal alien who has obeyed all of our laws, who has waited patiently in line, who's done everything our country's asked of them, the Secretary's discretion applies. Under this bill, though, if you have entered the country illegally, then you are automatically granted these meeting certain requirements without any ability of the DHS Secretary to exercise discretionary judgment. The Secretary cannot abolish the program, cannot abuse the discretion. There's a long line of case law on that. And what this essentially does is place the interests of those who broke the law above the interests of those who've waited patiently for a green card. It's a double standard, and I'm testing whether the Democrats on this committee actually intend to impose that double standard and elevate illegal immigrants to a higher level of recognition than we accord to the legal immigrants who have obeyed our laws.
Mr. Chairman.
Mr. Chairman,
Gentlelady from California.
I move to strike the last word.
Gentlelady is recognized.
I appreciate my colleague from California's amendment, and I'd like to note that we have built into the rest of the act the discretion that he urges. The Secretary has the discretion to prevent the application of people who he feels are a threat to public safety, who are a threat to national security, and the like. I understand that the point being made, but these individuals are de facto Americans. These are individuals who've grown up here, who, I can't tell you the number of people I've met who they found out when they went to apply for a loan to college for the first time that they weren't an American citizen, much to their shock. So I understand the point being made, but this is a category of individuals that is in a rather unusual situation. We have discretion for the Secretary built into other parts of the bill, and I would yield to the chairman for comments he may
I
wish.
thank the gentlelady, and I would point out that there is discretion in the bill with reference to what the bill deems should have discretion. People who may have committed crimes, people who may be dangerous to public safety, and so forth. It's in the bill. But the basic purpose of the bill is to say that this category of citizens, not people who did anything illegal, they were brought here as children. It's not their discretion generally. 1-year-olds don't make decisions, nor do 7-year-olds for that matter, as to where they're going. People who are brought into this country as children, who have grown up here, who are de facto Americans. The whole point of the bill is to say there should be no discretion unless they've misbehaved in some way and forfeited the protection of the bill by some act or series of acts which the bill lists. But other than that, there should be no discretion because Congress is deciding that this class of people are in fact Americans and should be given a path to become American citizens. Yes, there's normally discretion in the immigration law. The whole point of this bill is to say, but not for people who were brought here as children. If you don't agree with that, you should vote against the bill. The amendment simply cancels the bill. So if you support the bill, you vote against the amendment. If you want to vote for the amendment, you're really voting against the entire bill. And there's nothing else to say about it. And therefore, I oppose the amendment, and the gentlelady yields to the gentleman.
I would yield to Mr. Correa.
Thank you. I just want to remind my colleague from the state of California that California is the home to the greatest number of dreamers in the state of California. Want to remind folks who dreamers are. They've been vetted, they work hard, pay taxes, they're law-abiding, and they're also police officers. Germán Martinez Garcia grew up in Southern Illinois, and in the words of his police chief, he is part of this community. He's a good citizen. He's a good person. We need him on the force, and he is a dreamer. And here's a picture of him. A dreamer who is a police officer. I yield, Mr. Chairman.
Mr. Chairman, unless there are other... Mr. Cicilline, I would yield to Mr. Cicilline.
I thank the gentlelady for yielding. I want to just underscore the point of the chairman. The notion that children who came here, some in the arms of their parents as infants, broke the law is a ludicrous claim. A child, an infant, a 3-year-old doesn't have the capacity to break the law. In fact, they have no capacity to resist their parents if they came to America. So this notion of they're the same as others who are in this country undocumented, and this treats them in a preferential way, as the chairman said, I don't know if people forgot our hearing. We had Jin Park, a Korean national who's a Harvard graduate and a Rhodes Scholar. We had people who are finishing their studies and PhD, becoming physicians, becoming community activists. This is These individuals have contributed enormously to the story of this country, the story of America. They've made us a stronger, more vibrant, more dynamic country. And these are individuals who came with their parents, often fleeing unspeakable violence and difficult circumstances, and who know no other country but America. This is their home. And the chairman is right. If you vote for this amendment, you are voting to end the DREAM Act, because it ought not be a discussion. We've decided as a matter of policy, these individuals are every bit as American as everyone else, but for a piece of paper. And that's what this bill is designed to correct. So I urge a no vote on this amendment. And thank the
Question
gentlelady for
occurs
your-
on the amendment. All in favor of the amendment will say aye. Aye. Opposed, no? No. The noes have it. The amendment is not agreed to. Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Liu? Mr. Liu votes no. Mr. Swalwell? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Steen?
No.
Ms. Steen votes no. Ms. Mucarsel-Powell? Ms. Escobar? Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes yes. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes.
Are there any members who wish to vote who haven't voted yet? Gentleman from Texas.
Yes.
Mr. Gomert votes yes.
Gentleman from Florida.
Mr. Deutsch votes no.
I'll inquire. Gentlelady from Florida.
Ms. Mucarsel-Powell votes no.
Are we okay? Is there anyone else who hasn't voted who wishes to vote? The clerk will report. Have you voted? Val, have you voted? Val. Madam Clerk, is the gentlelady from Florida recorded? Is Ms. Demings recorded?
Ms. Demings, you are recorded as no.
Okay. Thank you.
Mr. Chairman, there are 12 ayes and 16 noes.
The amendment is not agreed to. Are there any further amendments?
Mr. Chairman.
For what purpose does the gentlelady from Arizona seek recognition?
Thank you, Mr. Chairman. I have an amendment at the desk.
I reserve a point of order.
The clerk will report the amendment, and the gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Ms. Lesko of Arizona.
I withdraw my point of order.
Point of order is withdrawn. The gentlelady will explain her amendment.
Thank you, Mr. Chairman. This amendment makes 212A6C, fraud, material misrepresentation, a ground of ineligibility. 212A6C applies to anyone applying for a green card or visa. Basically, what it says is that an alien who by fraud or willfully misrepresenting a material fact seeks to procure or has sought to procure or has procured a visa, other documentation, or admission into the United States or other benefit provided under this chapter is inadmissible. It also says under C, 2 I's, and any alien who falsely represents or who has falsely represented himself or herself to be a citizen of the United States for any purpose or benefit under this chapter, including Section 1324A, unlawful employment of aliens or any other federal or state law, is inadmissible. Basically, Mr. Chairman and members, my amendment ensures that DACA applicants under this bill who have committed fraud, material misrepresentation, or who have made a false claim to the U.S. citizenship to obtain benefits for which they are not entitled should not be rewarded for their action. All other aliens who apply for permanent residence are subject to 212A6C and are excluded if they have committed fraud or material misrepresentations or made false claims to U.S. citizenship. And why should DACA recipients under this bill get a benefit that anyone else applying for a visa or green card has to go through? I don't think they should. And that's why I'm doing this amendment. And before I close, Mr. Chairman, I want to remind the members that last year, and the audience, that last year we had a bill that would have given DACA recipients legal status. It was combined with other provisions, including reforms for asylum to make sure those that were credibly in fear of their lives would get asylum, but cut down on frivolous claims. It also would have secured the border, and none of my Democratic colleagues voted for that. So with that, I yield back my time.
Gentlelady, yield back her time. The gentlelady from California, for what purposes gentlelady seek recognition?
To strike the last word.
Strike last word? Gentlelady is recognized.
I oppose this amendment. This is a provision that is generally forgiven in legalization bills, and the reason is there can be many instances where, although it's willful, it's not malicious, if that's the right word. I mean, I'm not talking legal words. And I'll give you an example. If you take a look at the Immigration and Nationality Act that the gentlelady refers to, an alien who by fraud or willfully misrepresenting a material fact secures other documentation. You could, in fact, have a child who was brought to the United States say to their school that they are a U.S. citizen, and they would be, which happens from time to time, and they would be barred under the gentlelady's amendment from having the benefit of the DREAM Act. I don't know if that's what was intended, but that could be the effect, and I think that would be contrary to what we're trying to do with the bill. There is an exception for individuals prior to attaining the age of 16, but certainly there are plenty of young teens, I've met them, who at age 17 have made such representations who would be covered by this amendment. I think that we should not approve this, and I therefore oppose it and yield back, Mr. Chairman.
Do you please yield me some time to respond?
I'm sorry, I yielded back.
Mr. Chairman? Mr. Chairman?
Lady.
Thank you. In response to what was just said, I want to remind everyone that there is an exception, and I'm just going to read it. In the case of an alien making a representation described above in I, if each natural parent of the alien, or in the case of an adopted alien, each adopted parent of the alien, or is or was a citizen, whether by birth or naturalization, the alien permanently resided in the United States prior to attaining the age of 16, and the alien reasonably believed at the time of making such representation that he or she was a citizen, and the alien shall not be considered to be inadmissible under any provision of this subsection based on such representation. So I believe that there is an exception which I was proposing to include.
The gentlelady, or the gentleman, whoever has it, the gentlelady yield for a question?
Yes, I will.
So under what you just read, a 16 or 17-year-old whose parents are not citizens, who misrepresents that he is a citizen and actually thinks he is, would be barred, correct?
I'm not sure if that's correct, sir.
Well, given what you've just read, the exception that you read does not cover that because it says one or both, I don't have it in front of me, but you just read one or both parents are citizens. And what it's saying is that if he made a material misrepresentation, namely he said he was a citizen or she, and one or both of his parents were citizens, then he's not barred. But if neither of his parents are citizens, the clear implication, even if he thought he was a citizen, he didn't know that he was making a misrepresentation, he would be barred. And that's why this amendment is frankly dangerous in unforeseen circumstances, unnecessary, and I would urge people to oppose it.
Would the gentleman yield?
And do I still have time? I believe I have time.
Yes, you do.
I've got the time. The gentlelady can continue to have the time. I yield to the gentlelady.
Thank you, Mr. Shabbat. Well, you know, clearly, this is already law, and to me, it is unfair to put illegal aliens in front of people that are trying to enter our country legally, especially when they have committed fraud or willfully misrepresented material facts. I don't understand the objection, and so I yield back my time.
I'll
reclaim my time.
Gentleman from
That's my
Ohio.
time. Yeah. I guess before my time runs out, I just want to, again, just make the point, without the gentlelady's amendment passing, just as without the gentleman from California, Mr. McClintock's amendment being passed, essentially what we're doing is we're treating people that broke the law, people that came here illegally, better than people who tried to do it the right way. And to me, that makes absolutely no sense. I would also make the point that when you say that these children didn't come here of their own volition, they were brought here by their parents, if we give them favors that other people wouldn't get, essentially you're inviting more people to see what those parents did, and their children got to be legal. You're inviting a whole lot more people to do the same thing, to break the law, to come here illegally, and that's why we haven't solved this problem for literally decades now, and this passage, without this amendment, just makes it even worse. And I yield back.
I recognize myself in opposition to the amendment. Ms. Lesko just pinpointed, and Mr. Shabbat too, really the heart of the bill. We are granting, by this bill, a right to people who didn't break the law. They're kids, or they were kids at the time. They didn't break the law. They were brought here, period. Not by their own volition. And yes, we are saying that people who were brought here as minors who may have been a year old or 8 years old or whatever, for all practical purpose, and may not even have known that they weren't born in the United States, that they weren't American citizens, and maybe their younger siblings were born in the United States and don't even find out about it until they apply to college or for a work permit when they're 16. Yes, the point of this bill is to say we are going to treat them, we're going to establish a path to legalization for them, and we're not going to nitpick because we recognize that for all practical purposes, they're Americans and we want them to be Americans, and period. To say that someone who inadvertently, and this is the amendment, I mean, that argument is really on the bill, to say that someone who materially misrepresents by saying he's a citizen when he thought he was, and his parents aren't citizens, therefore he can be excluded, goes against the whole point of the bill. And yes, people who come here, our whole system of immigration and the preferences is a whole separate debate, and we're not going to get into that now. But people who were brought here as kids, we are establishing, in effect, a preferential system because we recognize them as Americans. That's the point of the bill. If you don't like that, you're against the bill.
With the gentleman.
Fine. But we shouldn't put in gutting amendments which will find, this isn't the gutting amendment, I'm sorry, amendments which every so often will find an unwitting victim for no particular reason and say to this 15-year-old kid, you're out. That doesn't make sense, and I oppose the amendment. I'll yield to the gentlelady from California.
I thank the gentleman for yielding. False claim to citizenship does not require intent. And I remember a case that we were working on, just an individual case of a baby whose parents had filed a false birth certificate who was barred from entry under false claim to citizenship. I remember, Mr. Gomert, if you'll permit me to recall, you had a constituent who ran a small business. Remember this? We tried to work on this, where he filled out his A number, but also filled out that he was a U.S. citizen. He was deported because there's no excuse for false claim to citizenship. So this is really not, I don't question the motives, but I think this is not a good amendment if we're trying to incorporate individuals who've been here as children into the country, and I thank the gentleman for yielding and yield back.
I'll simply say this amendment exacerbates an unfortunate situation, and I'll yield back. The vote occurs on the amendment. All in favor say aye. Aye. Opposed, no? No. The amendment is not agreed to. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? No. Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? No. Mr. Liu votes no. Mr. Raskin? No. Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? No. Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? No. Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton? Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. McCarcel-Powell?
No.
Ms. McCarcel-Powell votes no. Ms. Escobar? Mr. Collins? Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes.
Are there any members who wish to vote who haven't voted yet? Are there any members running down the hall who can respond? We'll wait a moment. Gentleman from Tennessee.
Mr. Cohen votes no.
Gentleman from Florida.
Mr. Deutsch votes no.
Are there any other members running down the hall? The clerk will report.
Mr. Chairman, there are 11 ayes and 16 noes.
The amendment is not agreed to. Are there any further amendments?
Mr. Chairman.
The gentleman from Florida. For what purpose does the gentleman from Florida seek recognition?
I have an amendment at the desk.
Gentleman has an amendment at the desk.
I reserve a point of order.
Gentlelady reserves a point of order. The clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. Gates of Florida.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain his amendment.
Well, thank you, Mr. Chairman. Earlier, I heard one of my colleagues on the Democratic side say that we want to keep communities safe and we want to keep our promises to dreamers. And it is in that spirit that I offer this amendment, because I don't believe anyone has made a promise to dreamers that they can wave guns around. And so I would seek to enhance the legislation by ensuring that anyone who comes to the country and is convicted of a misdemeanor offense that is gun-related not be given the amnesty that is laid forth in the bill. There are certain circumstances in the bill where felonies related to firearms would make someone ineligible to achieve amnesty, but if they commit a misdemeanor firearm offense, they would be able to access amnesty. There are a few reasons why this is unsafe. There are misdemeanor offenses that involve the brandishing of weapons, the unlawful exhibition of firearms, the keeping of a firearm in a way that is unsafe in a household with someone who could potentially use that firearm to harm themselves. What we've already seen in this hearing is that it doesn't seem to concern my Democratic colleagues if people with just one criminal gang tattoo come into the United States and achieve amnesty. And so my hope is that if we've got people that they're okay with being here, that our criminal have, because who doesn't just get one criminal gang tattoo? I mean, heck, that's just that could happen to anybody. Wrong place, wrong time, all of a sudden you end up with a Zeta tattoo on your forehead or a MS-13 marking on your arm. But be that as it may, could we at least say that we're sincere about the efforts to reduce gun violence? I know that in the Judiciary Committee we've had multiple hearings and heard legislation regarding gun violence, and so I would hope that in the effort to reduce the instances of those occurrences, we wouldn't want people in the country who break our gun laws. Now, it's my expectation that my colleagues on the left will say, well, there's a blanket provision that says that the Secretary of Homeland Security, under any condition for public safety, can deny someone this specific brand of amnesty. There are a few reasons why that is insufficient. First, I know of no circumstance where any secretary is going to be combing through individual offenses on misdemeanors. Second, I'm not entirely certain that these misdemeanor offenses are aggregated and collected in one centralized repository such to allow the effective location of those for the secretary, his or herself. Finally, the provision as written is functionally useless. Under the bill, the secretary has the ability to deny a green card based on a public safety concern, but it is so curtailed that it is practically unsustainable. And so if my Democratic colleagues are sincere about reducing gun violence, then presumably they wouldn't want people in the country who have come here illegally, who have committed a gun-based offense, who were convicted of that offense, and who then seek the amnesty of the United States. Join with us. Help us reduce gun violence, and please approve my amendment. I yield back, Mr. Chairman.
Mr. Chairman?
For what purpose does the gentlelady from California seek recognition?
First, to withdraw my point of order, and then to strike the last word.
Gentlelady is recognized.
I think this is a solution, really, in search of a problem. No one wants to give benefits to dangerous criminals, and this bill accomplishes that by barring applicants convicted of a serious or repeat offenses, and by authorizing the Secretary to deny those who pose a threat to public safety, even if they have a single misdemeanor. Now, most serious gun offenses are felonies. The bill categorically bars an individual for any conviction that can result in a sentence of more than 1 year. Under federal law and in most states, serious gun offenses are punishable as felonies or aggravated misdemeanors, which generally support sentences of up to 2 years in prison. And in many states, mere possession of a firearm, either without a permit or as a prohibited possessor, is a felony or aggravated misdemeanor. These people are already ineligible under the bill. As noted above, anyone who is convicted of any offense that is punishable by a maximum term of imprisonment of more than 1 year is barred, even if the individual receives no sentence at all. Now, it's worth pointing out that crimes involving moral turpitude are also bars to participation in this program. The bill, one such conviction, a gun conviction, can be disqualifying if it involves a sentence of more than 6 months, and any 2 such convictions are disqualifying regardless of conviction. And I'll just note that the use of a firearm in the course of other crimes, firearms discharged at an occupied building or vehicle, carrying a concealed weapon with intent to use are all crimes of moral turpitude, and there is case law supporting that finding. Lesser offenses should not be disqualifying without more. As noted above, the egregious gun offenses are already disqualifying. But there are places, probably not my district, but there are places in the United States where the gun culture is such that people have a lot of guns. There are people who believe that they need to have a firearm in their home for protection purposes. The reality is there are so many variables in state law and so many situations that to bar a permanent residence due to a single firearms conviction would unfairly punish people who should instead be protected. And as we've noted, we have the fail-safe that if the Secretary makes a finding that the person is currently a threat to public safety, even if it's a single misdemeanor offense, he has the authority to deny that application. So I don't believe there is any need for this amendment, and I would oppose the amendment and hope that we can move to the next one. And with that, I would yield back.
Mr. Chairman? Mr. Chairman?
Gentleman from Rhode Island.
I move to strike the last word.
I'm sorry. There's a
Yes.
gentlelady from
Mr. Chairman,
Arizona.
thank you. I move to strike the last word. You know, this is quite amusing to me because first we had an amendment that said you would be ineligible if you committed a DUI offense, and the Democrats voted that down. Then we had an amendment that said if there's evidence that you're a gang member, then you wouldn't be eligible, and the Democrats voted that down. Then we had my amendment that said, hey, if you commit fraud or material misrepresentation when you're applying, you wouldn't be eligible, and the Democrats voted that one down. And now I guess you're going to vote this one down, too, that says if you committed a misdemeanor firearms offense, you know, then you're still, you know, why not? Why not be a gang member, you know, fraud, commit fraud, misrepresentation, DUI, why not? Come on in. So with that, I yield my time to my colleague from Florida, Mr. Gates.
Thank the gentlelady for yielding, and I guess we found the first gun control that Democrats can't support. I mean, you know, we heard a long explanation about moral turpitude and generalities about some states, but I find it really remarkable that you guys want to give amnesty to gun criminals. To gun criminals that could have at least one criminal gang tattoo. And while the gentlelady from Washington spoke in these generalities, well, she says, there's a lot of states where, you know, these things would be considered felonies anyway. Well, I'll give specifics to counter those generalities. In the state of Virginia, brandishing a firearm is not a felony. It's a misdemeanor. In the state of Florida, improper exhibition of a firearm is a misdemeanor, not a felony. In California, improperly storing a firearm while sharing a residence with a person that is prohibited from keeping a gun is a misdemeanor. So if someone is not allowed to have a gun and you harbor them in your home and you're the reason they have access to a gun, that's a misdemeanor. And it's a crime that should result in the deprivation of the amnesty that Democrats seek to provide in this committee. So I would hope that if you guys want to give guns to criminal illegal aliens, that you would at least have the ability to comb through some specific statutes and cases where that was occurring. I also wanted to respond to the blanket assertion that, well, there are crimes of moral turpitude that could result in these gun offenses leading to a deprivation of amnesty. But that does not account for the vast majority of gun offenses that are regulatory in nature, where people have a gun who shouldn't. So honestly, you guys accepted one of my amendments in the last markup because you thought it was okay and didn't hurt your bill. I was hoping that you would be in favor of depriving people who break gun laws from amnesty. But if the way this is going to roll is that Democrats in the committee are going to vote to give amnesty to gun criminals, I really think that pollutes your message and pollutes the work that you've tried to do in the
Would the gentleman yield?
Gladly.
Thank you. I just wanted to note that on page 10 of the bill, we have some guidance for the Secretary as he makes public safety determinations. And one of the things that's in that guidance is that he should determine whether the elements of the offense include the unlawful possession or use of a deadly weapon to commit an offense or other conduct intended to cause serious bodily harm. So we're directing the Secretary.
I appreciate that. I'm going to reclaim my time.
And the time is yours.
Yeah, I'm going to reclaim my time because there's a few notations that the gentlelady may want to reference in the bill. The Secretary is barred from delegating these duties. So it's not as if some undersecretary or some other person can engage in these reviews for gun crimes. It is a non-delegable duty that the Secretary maintains. And what's even more egregious is that if that were to occur, if the process the gentlelady laid out were to happen, the U.S. taxpayer has to hire a lawyer for the person to be able to appeal that deprivation of amnesty.
If the gentleman will yield,
Gladly.
that is not correct. In fact, we've made sure that there would be no taxpayer funds. The funding for counsel is provided by an additional fee on the Dreamer applications, so there would be no taxpayer funding.
Very well. It is a fee paid, but it is a lawyer that is hired to take this to the Supreme Court if necessary. And so we would literally be ensuring that lawyers existed to be able to litigate the rights of people who broke gun laws to get amnesty. So again, the very first gun control that Democrats in the Judiciary Committee oppose, how rich is that? I yield back.
Mr. Chairman.
I yield to the gentlelady from Georgia.
Thank you, Mr. Chair. I move to strike the last.
Excuse me, she's recognized. I'm not yielding. I recognize the gentlelady from Georgia.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized.
Thank you so much. Everyone in this room, if you know my history, you know that I have been adversely affected by gun violence. And everyone in this room knows that I take gun violence very, very seriously. But this amendment is absolutely not necessary. It just is not necessary. Most gun offenses are felonies, so even a single offense will be disqualifying. And the public safety provisions that we've talked about earlier today, they will address all of these concerns. So I would hope that my colleagues would not listen to this fodder. I hope that my colleagues would understand that we have gone to great lengths to make sure that provisions are put in place so that no one who has committed gun offenses will be able to come to the United States and become effectively an American citizen. We have gone to great lengths to make sure that we are putting in every caveat that prevents that.
Will the gentlelady yield?
No, I will not. And I just want to say, I hope that my colleagues will not listen to this fodder, and this legislation is sound, and I hope that you will listen to the truth and not be swayed by untruths that would continue to disregard what's really happening in this room. And I hope that we're making sure that we're really paying attention to allowing people that have the ability to come here for a better way not be used as scapegoats. And I yield back.
Will the gentlelady yield? The gentlelady yielded back. Who seeks recognition?
Mr. Chairman.
The gentleman from Rhode Island.
Thank you, Mr. I move to strike the last word. While I appreciate the effort of my colleague from Florida to try to add or make some improvement on this bill, unfortunately, he does not, and this is actually very much a problem, a solution in search of a problem. First of all, it is already a felony for a person to be in possession of a firearm who is not a citizen of the United States. It is a felony under federal law, and it is a felony under state law. So it is already, by the very language of this statute, barred. That it makes a person ineligible to be made available for the DREAM Act. There is no waiver in the bill for that, so it's a statutory ineligibility already. So this is.
Will the gentleman yield for a question?
No, I'm not quite done yet. So, and the statute, just as an example, possession of a firearm by a non-citizen in the Virginia Code, section 18.2-308.201, makes it a felony. That's just an illustration. So it's already a felony, which is barred, which means the person is ineligible for the benefits of the DREAM Act. What I find so sad and disappointing is I can say that the hearing we had with the Dreamers before this committee was one of the most moving, extraordinary hearings in all of my time in Congress, where we had individuals who were graduates of Harvard University and Rhodes Scholars, and students at medical university at UNM, and a PhD student at the UCLA. These are the stories of this country, immigrants who came here as young children who are making extraordinary contributions to this country. I thought we were going to have amendments that said things like, let's accelerate consideration of your application if you're a medical doctor serving a community in need, or accelerate consideration of your application if you're a scientist doing life-saving research, or accelerate their application's consideration if you're leading a nonprofit agency that's doing important social justice work, or maybe another amendment to accelerate consideration of an application if you're an entrepreneur building a business, hiring citizens of this country to work. Those are the experiences that I have with Dreamers. And so rather than that, every amendment we've had, it seems, imagines all of these young children who came here to live the American dream and who have made America their home are criminals and dishonest and dangerous. And we're even making up amendments that make no sense because these individuals who are in possession of firearms are already statutorily barred. So you can play a game and say, ooh, we tricked the Democrats. You're better than that. I urge you to withdraw the amendment.
Will the gentleman yield?
And I won't ask for an apology, just simply withdraw the amendment.
Well, how about yielding?
I'll yield to Mr. Cray and then to you, Mr. Gates.
Thank you very much. I just want to say maybe you ought to have an amendment that accelerates this process for those Dreamers that are in the armed forces. I have with me a picture of John, U.S. Army, American soldier. He grew up in Southern California, joined the U.S. Army March the 18th, shipped out a few months ago. He's a warrior, he's a patriot, and he's also a dreamer. Thank you very much.
And I'm happy to yield to Mr. Gates.
I'll thank the gentleman for yielding. And in the circumstances the gentleman describes, where all these individuals are already felons, would the gentleman concede that that presupposes that there's a conviction reflecting that felony, whereas in other circumstances there might be a misdemeanor conviction?
Well, reclaiming my time, it doesn't presuppose it, but it makes it clear, certainly, that those individuals have committed a felony. Much of this relies on, of course, law enforcement enforcing the criminal law. There's also a provision in the bill that authorizes the Secretary to take that into account, and I'll yield the balance of my time to Mr. Raskin.
Thank you, Mr. Cicilline, and thank you for pointing out the obvious, which is it is a felony for an alien to possess a firearm in the first place. So they already qualify under the statute. It seems like our friends are doing double and triple backflips in order to find something wrong here, in order to completely mischaracterize the legislation. This is about allowing more than 1 million people who are here, who are in college, like at the University of Maryland or Montgomery College, people in the armed services, people who are out in the workforce, to get on with their lives. And so our friend from Florida taunts us by saying this is the first gun control bill that he can find that the Democrats oppose. Well, then this is the first gun safety bill that we've been able to find that you support. We voted for a bill to close the internet loophole, to close the private gun show loophole, which is supported by 97% of the American people, the vast majority of Republicans, Democrats, Independents. We voted to close that, and you opposed it. And now you come here today pretending like you're some kind of big gun safety champion. I'm speaking broadly out there, and I just think that argument is beneath the committee. I yield back to the gentleman from Rhode Island.
And
I yield back, Mr. Chairman.
Gentleman's time has expired. Gentleman from Arizona, for what purposes? Has he spoken to this amendment yet?
No, I haven't spoken.
Gentleman from Arizona, for what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
The last word is duly struck. The gentleman is recognized.
Thank you, Mr. Chairman, and I will yield to the gentleman from Florida, Mr. Gates.
Thank the gentleman for yielding. I mean, we're watching words that don't match the reality of the language that's before us in the bill. I heard the gentlelady from Georgia say, we have approved every caveat to protect people from gun violence. If that were true, you would approve this amendment. I mean, if this amendment does no harm, if you're saying it's already covered, why wouldn't you vote for it? The approval of this amendment would reflect caring to the extent that you have accepted every caveat. But instead, there is this talk of generalities. So I also want to reflect on the gentleman from Rhode Island, Mr. Cicilline, saying how moving these hearings were with dreamers with exceptional experiences and inspiring life stories. Well, of course, you guys are trying to do amnesty. You didn't bring in the people that are guilty of gun crimes to sit before us. You didn't bring before us the people that have just that one gang tattoo to sit before us. Instead, you brought forward great folks, and there's
Will the gentleman yield? You had a witness you could have brought in. You had one seat.
Just as you yielded at the conclusion of your remarks, I'll yield to you at the conclusion of mine. And so the nature of your hearings cherry picks circumstances, and we have to make laws not for the best among us, but for the potential risks that could occur. There are dreamers who have committed crimes. There are dreamers who have committed gun crimes. There are dreamers who have committed homicides. Now, that doesn't mean that we can't work together to find a policy that advances the interests of our nation, but it most certainly does not do so when we allow people who are gun criminals to access amnesty. That is what this is. You guys can call it whatever you want. You can make reference to other provisions in the bill, but if you were really serious about protecting the American people from all gun crimes in every circumstance, whether they are regulatory or not in nature, you would approve this amendment. But just because it's offered by a Republican, you won't, which is the sad thing, because frankly, we do have a crisis on the border right now, and if the message you send in the midst of that crisis is that our highest priority, the first thing we got to deal with, it's not the kids dying who are baking on the concrete under tarps. It's not the fact that we invite now upwards of 4,000 or 5,000 people a day here through our policies. It's not the fact that our broken asylum system is actually what's leading to more of these newborns and infants and toddlers being brought here with no agency over that decision. These are the policies we've created, and we could actually work together to fix them. But Democrats in this committee are so motivated to extend the most egregious forms of amnesty. Your base is already worried that you've excluded too many people from the bill, that you can't accept a simple amendment that says if someone's a gun criminal, that you wouldn't give them amnesty. I'll yield to the gentleman from Rhode Island.
Well, thank you. Just to be clear,
reclaiming my time. Reclaiming my time.
I think it's
Yes.
It's my Arizona control.
Oh, okay, sorry.
Yeah. But I will yield to you, Mr. Cicilline, the gentleman from Rhode Island. I just want to make sure that I got
Absolutely. Thank you. I appreciate you yielding. I just want to say that when we had the hearing with the Dreamers, as you well know, of course, the Republicans have an opportunity to bring witnesses too. And of course, there were no witnesses you brought forth that made the claim that there were all these gun crimes being committed by Dreamers. In fact, your own witness was testifying in support of the DREAM Act. So it was a wonderful example of the wonder of immigrants who have come to this country and made such extraordinary contributions. Your own witness confirmed that. If this were a real issue, you would have had a witness that made a claim that, oh my goodness, all kinds of gun misdemeanors are coming in. This is a make-believe issue.
Okay,
I urge my colleague to withdraw the amendment, and I yield back.
I'm going to yield to the gentleman from Georgia for about 45 seconds.
I appreciate that, and I appreciate the gentleman talking about that, because our witness did support Dreaming, which on our side, we have supported DACA in that fix. But he also said that there had to be security, there had to be border security, there had to be a process in which this doesn't become a revolving door process. So our witness did do that. I would support this amendment, but also this is something that we want to fix. We just don't want to fix it to where there's an open end, as we have seen in this bill, with problems in it. I yield back to the gentleman from Arizona.
Thank you, and I yield to the gentleman from Florida, Mr. Gates.
The number of DACA requesters who were approved with an arrest, is 59,786. I know we get to bring witnesses to the committee, but I think the committee room would have been a little full if we'd have brought all of them. And so, again, I cannot believe that this is even a source of dispute or disagreement. Why wouldn't you just approve an amendment that says if you committed a gun crime, we don't give you a special form of amnesty? It's so basic. And you know, I think you guys will own this one. I'll yield back.
Gentleman
I
from,
yield back.
For what purpose does the gentleman from Georgia seek recognition?
To strike the last word.
Gentleman is recognized.
Mr. Chairman, I think it's unfortunate when we talk about illegal aliens and we talk about amnesty. We're talking about DACA recipients here, people who have not committed an offense or violated the law. That's what amnesty means, giving somebody a break from violating the law. These folks, though there may be in technical violation, they've committed no breach of the law. And to refer to them as illegal aliens, I mean, when I close my eyes and think about an illegal alien, I do think about somebody from out of the world, some out of the world individual teeming with tentacles and just a frightening entity. And then when I put guns in the hands of a frightening monster, it really raises, it heightens my sensitivities and makes me afraid. I think the effect on the people watching on C-SPAN is to generate fear and passion and just alienation of these illegal aliens, these monsters who are seeking to invade our country, and they're just going to do harm to us either through firearms or through fraud or through DUI, one way or the other. However we can get folks to act with passion against our fellow human beings. That's what the effect of what we are doing is, and that's the effect that it's having on people, and it's wrong for us to do that. We're trying to get relief for people who are suffering and live in fear in this country, trying to make a positive contribution to the lives of us all. And it's unfortunate that we're going to go through this for the next few hours and on into the night. Now I yield to the gentleman from Maryland.
Thank you very much, Mr. Johnson. Thanks for that eloquent and important statement that amnesty is a misnomer in this context. And I just want to echo that sentiment by reminding everybody about the Supreme Court's great decision in 1982 called Plyler versus Doe, where there was an effort to exclude the children of undocumented parents from public schools in Texas. And the Supreme Court said that that's a violation of equal protection because they're here through no fault of their own. They were not the ones who violated the law, and it would simply be unthinkable under our constitutional system of government and the recognition of the equal protection rights and the dignitary rights of the people and the educational rights of the people, that we would deny them the opportunity to go to school. So what we're doing follows through on that constitutional commitment. I yield back to you, Mr. Johnson.
Mr. Johnson?
I'll yield to the gentlelady from Washington.
Thank you so much for yielding. I just think this is somewhat amusing that my good colleague from Florida suddenly cares about guns. My colleague said we make laws based on the worst of us. Well, if that were true, then you would have voted for the 2 gun bills that we passed through this committee and passed on the floor. But I didn't see any support for that. And as my colleague from Maryland said, those are bills that had 97% support across the country because they were legislating towards the worst of us. And I think that if you're really concerned about public safety, then here are a couple things to work on. Here's an article from the New York Times. Trump's immigration crackdown has blunted police efforts to be tough on crime. And it goes on to say that Trump's hardline campaign to limit immigration has undercut his own tough on crime agenda, law enforcement officials said, by worsening major delays in a visa program intended to help the police pursue violent criminals. I mean, it goes on, and I would just say that it feels like every time there's an opportunity to bring up undocumented immigrants in the context of something bad, there are too many of my colleagues on the other side of the aisle who I believe are good people who do that. And I would just urge you to please not do that. And I wanted to say something earlier about the term alien. I know it's a legal term, but I will tell you that when I came here, when I was 16 years old by myself, and I'm standing in the line at the airport, and somebody says, somebody go take care of those aliens, I understood exactly what that meant to me. I have thought about that term. I wish we could change that term in the law because I don't think it's an appropriate way to deal with things. I understand there's no misintent potentially intended, but then when it is combined with the word illegal alien, no human being is illegal. And I would just urge that we continue to use the word undocumented when we're talking about people who do not have papers, and certainly in this context, people who are American in every way except for that piece of paper. I yield back.
I yield back.
Thank you, Mr. Chairman. And I just want to make sure that the gentlewoman from Washington and the gentleman from Georgia are aware that the word alien appears in the bill before us. Okay, you said it was a legal term. I want to make sure.
If the gentleman would just yield, I just want to clarify. I acknowledge that. I said it is the legal term that is in use in our immigration laws. It is something I have never appreciated, and I said that's why I understand there's no misintent necessarily meant when that term is used by my colleagues on the other side of the aisle. When it is combined with illegal, which I don't think is a term that is consistently been used in law, it undermines the basic humanity. And we can have another discussion about this, and I would love to tell you exactly why that term is so dehumanizing for people. And then you put both of those terms in the context of arguments that somehow immigrants are committing all these crimes, when all of the statistics show that immigrants commit crimes at much lower rates than than U.S.-born citizens do. So that's my only point. I understand it's in the law. I was actually acknowledging that point, but saying that we need to start having a discussion about how we dehumanize immigrants in our conversations, and this was my contribution to that, having been called an alien many times because it is in the law. I hope we change that.
And I want to go one step further, if the gentlelady, I will reclaim my time, but I think it is legitimate and not illegitimate in this case to say that we want to promote public safety across the board. And if we can do that in this situation by reducing the number of individuals that have misdemeanor gun crimes in this country, we should try to do it. There are additional tools that we have, and I still consider myself a prosecutor impersonating a congressman, but we have in law enforcement that in one of those tools, when someone is in this country illegally or doesn't have proper documentation, whatever the word is, the term is you want to use, we can deport that person. So someone that commits a crime here can be subject to incarceration, or they can be deported. And if we have jails that are, or prisons that are overcrowded, the tool of deporting someone is available. And I think in this situation, Mr. Gates is offering a good faith amendment to attempt to reduce. Now, it may just be that there are 2,000 out of a million individuals who have, and in Colorado, one of the misdemeanor gun crimes is possessing a certain type of weapon. Some call it an assault rifle or something. It would be possessing a magazine that has a capacity over 10 rounds, 12 rounds, whatever it is in some states. Those are misdemeanor gun crimes. And if there are a number of people that have committed misdemeanor gun crimes and have not been convicted of a felony under federal law, it promotes public safety to make sure that those individuals don't receive the benefits, I'm not calling it amnesty, but the benefits of this legislation. And I think that it would be appropriate, and we can certainly try to examine each other's motives in terms of why we didn't vote for a gun control bill that was in committee earlier, but this is a fair attempt, and it doesn't affect a lot of individuals, clearly. I can tell you from my experience in eastern Colorado, the vast majority of people that are in the country illegally or without proper documentation are good, hardworking people. I absolutely acknowledge that. But for those that aren't in this country in that capacity, we should do our very best to make sure that they don't stay in this country. And I think that's
the
what
gentleman yield?
I will yield.
Thank you so much, and I agree with you. I think no one wants to give legal status to dangerous criminals, and I think what we have said over and over again, what Ms. Lofgren and others have said over and over again, is built into this bill are many protections against that, and I can go through that again. Most serious gun offenses are felonies. Other gun offenses are crimes involving moral turpitude. Lesser offenses should not be disqualifying without more. We have actually taken into account, I think, something that we agree on, which is that we don't want to give legal status to dangerous criminals. The bill accomplishes that, and it bars applicants convicted of a serious or repeat offenses, and it authorizes the secretary to deny those who pose a threat to public safety, even if they only have a single misdemeanor. So I think my point is, this is already contained, protections are already contained in the bill, and that is exactly why it seems...
I'm going to reclaim my time because I'm
Yes.
running out of time. I
Go ahead.
apologize. But I just want to make the last point, and that is that there are protections in this bill, but they're not enough. And all we're asking for is to close a loophole, and we'd appreciate the support of the majority in that regard. I yield back.
Gentleman yields back. The gentlelady from Pennsylvania, Ms. Dean, is for what purpose does she seek recognition?
To strike the last word.
Gentlelady's recognized.
Thank you, Mr. Chairman. You know, I'm listening to this conversation, and it's quite clear that this language of the proposed amendment from the gentleman from Florida is unnecessary. The behaviors described in this amendment are already disqualifying, and this very well-crafted piece of legislation, very thoughtfully crafted piece of legislation, accounts for this. But I want to say something. Mr. Chair, ultimately, this whole discussion and this bill is about basic decency and making us a safer, more whole United States of America. This is about whether we are people who kick young, hopeful strivers out of America, people who, through no fault of their own, were brought here, or whether we treat them in the way we would want our own children to be treated. It's about who we are as a people. And so I want to say that by offering this amendment, I'm a glass half full kind of a girl. And I believe that this reveals to me, I hope, a willingness on the other side to talk openly and honestly about solutions to the very grave problem of gun violence in this country. When 40,000 people die a year in this country of gun violence, when another 135,000 are wounded, literally caught in the crossfire, you bet we ought to be sure that this kind of possession, illegal gun possession, or gun crimes are addressed so as to save lives, to save injury, torturous injury to people and to communities. This also reiterates the efficacy of background checks. And so, as I said, I'm a glass half full kind of a girl. I hope that this reveals that the people on the other side of the aisle are very eager to support what we have in earnest passed out of this House, and speak with the senators and say, please take up H.R. 8 immediately to save lives. Please take up H.R. 1112 immediately to save lives. This is a serious issue. This is a serious conversation. It's not fodder. Thank you. Mr. Chair, may I yield my time? to the gentlelady from Florida. Thank you.
Thank you. Thank you, Mr. Chairman. I want to be very honest with you and speak to my colleagues across the aisle from my heart. I had some questions about this when I read the bill, because for me, gun violence prevention is such a personal issue, not only because I lost my father to gun violence, but because in my community we lose too many lives because of illegal gun holders. And after doing my research, I can tell you honestly that after I saw that the Title 18 U.S. Code Section 922G considers a felony the possession of a firearm by an undocumented person. And we also have included in the bill, because believe me when I tell you that I wanted to make sure that we weren't just having a bill with holes on this, because it's such an important issue for me, that it allows the Secretary of the Department of Homeland Security to consider anyone who's a threat to the public safety to not be allowed to get citizenship or legal status. So I want to tell you that I'm excited to hear that my friends across the aisle are concerned about gun safety, and I hope that we can ask the Senate to take on H.R. 8, but also to support me as we hopefully at some point soon introduce Ethan's Law, which will make sure that we have safeguards for those possessing firearms. So that's it. I yield the remainder of my time.
The question occurs on the amendment. All in favor of the amendment say aye. Aye. Opposed, no. No. The noes have it. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? Ms. Steen?
No.
Ms. Steen votes no. Ms. Mucarsel-Powell?
No.
Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Aye. Mr. Johnson of Louisiana votes aye. Mr. Biggs? Aye. Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes.
The gentleman from Louisiana? The gentleman from Louisiana voted no.
Oh, Mr. Richmond votes no.
Gentleman from California?
Mr. Liu votes no.
Has everyone voted who wishes to vote? The clerk will report.
Mr. Chairman, there are 13 ayes and 16 noes.
The amendment is not agreed to. Are there further amendments?
Mr. Chairman.
The gentleman from Virginia, for what purpose does the gentleman from Virginia seek recognition?
I have an amendment at the desk.
I reserve a point of order.
The clerk will report the amendment. The gentlelady reserves a point of order.
Mr. Chairman, without objection, I move that the reading be waived.
He's got to read it a little bit first.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered
Without
by...
objection, the amendment will be considered as read. Gentleman is recognized.
Thank you, Mr. Chairman. We have heard a lot about the work that was done on the other side on this bill and all of the protections that have been put in. I think that's news to this side of the aisle. I don't know of many on this side who were consulted about the bill as it was developed. But I think, as evidenced by the number of amendments that have been offered, that the bill does have quite a few holes in it, and those have been pointed out. One that I would point out has to do with Section 207 of the bill, dealing with the documentation that is eligible for the application for permanent resident status under the Act. There's a range of reliability over the 10 pages or so in this bill dealing with documentation, beginning with very reliable birth certificates, national identity documents from the country of origin, very reliable, going to birth certificates, deeds, mortgages, all the way down to utility bills, all the way down to affidavits from friends, which the reliability of which does not seem to be very high. We do not want documents that are generally unreliable. And if it's proven to the Secretary that certain documents or certain classifications of documents are not reliable, the Secretary should not be able to rely on those documents. And they spoke to the discretion of the Secretary, but it should not be up to the Secretary if those documents are proven to be unreliable. So this amendment simply changes may to shall. It says that the Secretary shall prohibit or restrict the use of such documents that are deemed not to be reliable. And I would hope that it would be the support of the committee to approve it. And with that, I would yield to gentleman from Georgia, Mr. Collins.
Thank you for yielding. I support the gentleman's amendment. I appreciate what has been brought forward, and with that, I yield back to the gentleman.
Mr. Chairman, I'll keep it brief because we have a vote, so I'll yield back.
Well, we'll pause for a moment. We're trying to review your amendment, which we haven't seen till a minute ago.
We have a vote. Why don't we read it over the vote?
Is the vote started already?
Yeah.
How much? No, I think we can do it right now. We'll start. I'll recognize myself in opposition to the amendment. The amendment, or rather the bill, gives the Secretary discretion to rely on certain documents or not. The amendment says he may not use certain documents, and frankly, those documents may be very useful. I don't know why you would take discretion away from the Secretary with respect to documents that can be used to establish eligibility for adjustment of status.
The chairman would yield.
I don't see the point of this.
If the chairman would yield.
The Secretary is in a position to know which documents are more reliable. I'll yield to the gentleman.
Mr. Chairman, I'd just say it's only those documents that have been proven to be unreliable that he cannot rely on. It's just ensuring that...
Claiming my time, if the documents are proven to be unreliable, one can assume the Secretary will exercise his discretion not to use them.
Big assumption, Mr. Chairman.
Would the chairman yield to me as well?
I will.
Okay, this has become a little bit, and I understand what the chairman's trying to say here, and I'm glad you're working through this, but we've gotten to where in this committee we assume a lot of things and intent on things that are not written into actual language. And I think that's the only part that we're concerned about sometimes. I don't mind, difference in policies is actually written down into the law, black and white. But when we say they could assume not to use something instead of it actually being what the law actually, or the bill actually says, that's when I think the concerning part and what the gentleman from Virginia is trying to express is it's not there, and you would assume that the secretary might, but what if you assume the secretary would not? So I think we got to go beyond the ephemeral here of saying this is what might happen.
Reclaiming my time, the paragraph in question says, if the secretary determines after public, et cetera, if the secretary determines that any document or class of documents does not reliably establish identity, or that permanent resident status under this act is being obtained fraudulently to an unacceptable degree, the secretary may prohibit or restrict the use of such document or class of documents. If he determines that a class of documents is fraudulent, he would exercise this discretion. The reason to oppose a mandate is maybe the evidence is mixed on whether that class of documents is reliable. And there's no point tying the secretary's hands, so I would oppose this amendment.
Mr. Chairman.
For what purpose does the
Move to strike last
gentleman?
word.
I yield back. To what purpose does the gentleman seek?
Move to strike the last word.
Gentleman is recognized.
Again, I think your argument right then actually made the point. It says is being obtained fraudulently to an unacceptable degree, the secretary may prohibit. Why would we consider it may prohibit? If it's determined to be fraudulent, it should be shall prohibit. It shouldn't be may prohibit, because may then says, well, I don't like it, it may not look good, it may be, I will.
Because it doesn't say only fraudulent. It says does not reliably establish identity or is fraudulent.
Okay,
So
reclaiming my
reliably
time, but reclaiming my time, the same thing's still true. If they're making this determination reliably or not, again, this is a part I think that you just look at it. It's just this is more of a rule of construction than anything else. Is to say the secretary, shall here, because if not, you're leaving it open till they could ignore any of this.
Would the gentleman yield
I'll
for
yield
a
to the
question?
gentleman from Virginia, and I'll come back. Gentleman from Virginia.
Mr. Chairman, I'd say the gentleman is exactly right. It's simply saying that fraudulent documents or documents that don't establish residency can't be used, and will only use those that are reliable or that establish residency. And I would yield back.
All right, now I'll yield to the gentleman.
I just saw this amendment for the first time 30 seconds ago, so honestly, I would like to recommend that we recess for our votes and think about the impact, because one of the questions I have is whether, for example, you take a look at the documents listed on page 41 and 42. You could have a business record on line 2240, page 41, that was fraudulent, and you could have some that were valid. Would the finding that a business record was fraudulent in some cases mix up with the shall language? I'd like to think about that. I'm not saying yes or no,
Right.
but I'd like to
Reclaiming-
give some thought to that before we vote on it, since I've just seen
And I
it.
appreciate it. Reclaiming my time, and I think you just again made the point for the amendment. And I think there is plenty of leeway here at the sense of what the secretary can do. But however, if found fraudulent, not the ones that, again, when it's found proper. And I think it's a good idea for the gentlelady, if you want to take this through the break, that's fine. I think it is something to look forward to. But again, this is why we have markups. I appreciate the chairman's, and both sides' ability to go through this. This is why we have markups.
Right.
Because this is a certain time to look at this, because I think the gentleman's point is very well taken, especially if you look at fraud. This is not a surprise gotcha amendment. This is just one simply to say, if you want to tighten this bill up, this is a way to tighten it up.
If the gentleman would yield, I did not mean to imply that you were trying to
No, I know.
spring something on us. It's just, I just saw this for the first time
Outstanding.
a few minutes ago. I'd like to think through the implications. Maybe we can agree, maybe we can't, but I think if we can have more than 60 seconds to think about it, that would be productive.
Reclaiming my time. I think that's exactly where we're at. We're going to a vote anyway. I think this is the discussion. I think the gentleman's points are well made here, and I think if you read it in context, it does leave an ambiguity there that if there are fraudulent documents, why would you give a secretary the ability to take fraudulent documents in? And by may is one of those that does that. So we'll continue this discussion, and I appreciate it, and I yield back.
The gentleman yields back. We are in the middle of a vote. It's on the floor. So we will recess the committee until immediately after the votes. So as soon as the votes are over, I hope everybody returns quickly so we can speed up the markup. And with that, the committee stands in recess. The committee will reconvene after our vote recess. When we when we recessed, we were considering the amendment by the gentleman from Virginia, Mr. Klein. I don't remember if I spoke on the amendment or not, but I'm going to recognize myself for, I have not spoken on the amendment. I have. So we'll,
I unanimously consent to let you have 5 minutes.
thank you. I won't use 5 minutes. The amendment, I thank the gentleman for the unanimous consent. The amendment changes the following paragraph. It says, if the Secretary determines after, if the Secretary determines after publication in the Federal Register and an opportunity for public comment that any document, et cetera, is being obtained fraudulently to an unacceptable degree, the Secretary may prohibit or restrict the use of such fraudulent document. That's what it says essentially. And the amendment would say, shall not use this fraudulent document. I would simply say that no secretary is going to go through the entire Federal Register rulemaking process, determine that a document is misleading or fraudulent, declare it to be misleading or fraudulent, and then use it. So this amendment, in effect, does not change the bill. The practical effect of this amendment, as far as I can tell, is zero. And I'm going to oppose it simply because I don't like amending bills with amendments that don't do anything at all. So I have no substantive problem, except I don't think we clutter up a bill with amendments that, in fact, don't do anything. That's my personal feeling, and therefore I recommend opposing the amendment. Who seeks recognition?
I do.
Gentleman from
Georgia.
Georgia.
Well, Mr. Chairman, I appreciate that, but I think you're quoting off page 42, and we're actually amending page 11. And that's where, I understand you going through the federal rulemaking for documents and other things which may or may not actually apply back to 11, but at that point, I'm going to yield to the gentleman from Virginia.
Thank you, Mr. Chairman.
I think we're comparing apples to apples. It actually does apply here, so I give it to the gentleman from Virginia.
I appreciate the gentleman yielding, and Mr. Chairman, I understand where you're coming from on this. I think we're just applying belt and suspenders here, where if, I'm glad you have faith in the secretaries to come, that they would not seek to approve the use of documents that are unreliable or fraudulently obtained to an unacceptable degree. But we can't foresee the future, and this would ensure that fraudulent documents are not allowed to be used in this process. So,
Would the gentleman yield for a moment?
I yield back to the gentleman.
I'm simply,
I yield to the chairman.
Thank you. I'm simply saying that if the secretary made a formal finding that a document is fraudulent, he's not then going to use it. That doesn't, if a document is fraudulent and he didn't look at it, that's a different problem. But pursuant to this paragraph, he is determined, after publication of the Federal Register and an opportunity for public comment, he's gone through a whole comment period, determines it's fraudulent, he's not going to use it. I yield back.
I yield back.
Okay, the question,
I thought I had withdrawn the point of order.
point of order is withdrawn. The question occurs on the amendment. All in favor, say aye. Aye. Opposed, no? No. The noes have it. On a roll call. The roll call is requested. Clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton? Mr. Stanton votes no. Ms. Dean? No. Ms. Dean votes no. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Jordan? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes. Mr. Jeffries are not recorded. Mr. Jeffries votes no. Mr. Chairman, there are 6 ayes and 15 noes.
The amendment is not agreed to. Are there any further amendments? No. Gentleman from Arizona. For what purpose does the gentleman from Arizona seek recognition?
Desk.
Clerk will report the amendment.
I reserve a point of order.
Is the amendment not at the desk?
This is the right one.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. Biggs of Arizona.
Without objection, the amendment is considered as read. Gentleman from Arizona is recognized for his amendment.
Thank you, Madam Chair. Just want to make sure this is Biggs number 4. Okay, very good. So H.R. 2820 does not merely legalize the DACA population, but would extend green cards to millions of illegal and legal aliens. And the purpose of this bill is really to try to get at protecting and legalizing the DACA population in some way, I suppose. That's the way I understand it anyway. But any individual who entered the United States under age 18 legally or illegally and who is present for 4 years prior to the date of enactment is eligible for a green card under the bill. This would permit anyone who came to the United States legally in a non-immigrant status as a child to obtain a green card if they have been present for 4 years, which seems almost cattywampus to the purpose of this bill, or at least the stated purpose. My colleagues across the aisle have preached about the need to provide relief to individuals who were brought here illegally by their parents through no fault of their own and were raised without familiarity with their home country. So why are we not focusing on that population? Why is it being extended? In fact, I heard the chairman's opening statement today. He spoke almost exclusively to the point of providing relief to individuals who are brought here illegally by their parents. That's what we've heard as a constant refrain today. My amendment would require that aliens applying for this new green card have had no lawful status on the date of enactment of this act. Doing so would limit eligibility to DACA recipients and other qualifying legal aliens. So it seems to me that my amendment is going to get back at the heart of why we are here today and the very purpose for, at least the stated purpose for this bill. And so with that, Madam Chair, I yield back.
Gentleman yields back. Well, I understand what the gentleman is getting at, but I don't think it is necessary, because if you look at, and I yield myself such time as I may consume on this, look at page 2, if I'm understanding you correctly, line 6, 7, and 8, it does limit who is eligible for this to undocumented status. So you don't need to make the proviso. I'm really not understanding what you're trying to accomplish by this amendment, and I would yield it for an answer.
Thank you, Madam Chair. I would have to respectfully disagree with what page 2, the general provision that's there, because it talks about lawfully admitted people, and yet the heart of what we are trying to get at, if I understand correctly, based on the chairman's opening statement, is to provide DACA population with relief, and they would get relief under this bill, but so would those who are legally present in the country otherwise. In other words, they have a chance to change their status at the same rate, same levels, with the same preference and priorities as those who are otherwise DACA. And that's the way I read Section 2 of this bill. And so, additionally, I would say that the provisions that we have cited in our amendment itself also gets at the point I'm trying to make.
Reclaiming my time, with great respect, I think that's a misreading of the bill. Honestly, in some ways, I would prefer that the gentleman's reading of the bill was correct, because there are, in fact, young people who are in an H4 status or E2 status who've aged out of their status because of their parents couldn't get, in the case of H1Bs, they were in a backlog, or in the case of Es, there was no pathway to residence. But in fact, the bill does not deal with them. It only provides for those who are in an undocumented status. So this amendment should be opposed because it's already in the bill. Do others wish to be recognized?
Madam Chair.
What purposes the gentleman from Georgia wish to be recognized?
Thank you, Madam Chair. I think this is, again, I think it's an issue that Mr. Biggs is bringing out, and I think it is valid. I don't think it's a misreading, and I think I support the gentleman's amendment, because as we look at this, if they overstate a visa, there's other issues here, and I wanted to yield back to the gentleman from Arizona.
Certainly.
Thank you.
Gentleman is recognized.
Thank you. I appreciate you yielding back. So I get what the chairman is saying, chairwoman is saying, is when she starts talking about that her reading is that this limits to DACA. But I would suggest that children of H-1B visa holders, for instance, would be eligible under this bill to get a green card. I would also suggest diversity lottery, visa overstays. I would suggest that they would also be able to get relief under this bill, and I think that is antithetical to what I understand the purpose of the bill to be. And so that's what I think to be the case.
Well, if I may, I think you and I understand the purpose of the bill to be the same, and accordingly, I don't think this amendment is necessary. And I would note that there is a difference in your amendment as compared to the underlying bill, because it relates to the status as of the date of enactment of this act. Presumably, if someone became in an undocumented status subsequent to this, but they wouldn't be eligible in any case, because there's a 4-year look back. So I think this amendment is unnecessary and actually confuses the situation, and I would recommend that it be rejected but understanding that the gentleman's goal is already met by the underlying bill. Do other members wish to be heard on this amendment?
Chair, the time is still mine. And,
Oh, I'm so sorry.
no problem.
I apologize.
And the gentleman from Arizona, I think, again, the gentleman from Arizona, you still need the time?
Yes, if I can I just want to respond briefly with regard to what has been estimated that half or somewhere near that, maybe 40 to 50% of those who are in the country illegally are visa overstays. This bill actually is going to provide them relief. That's the way I read the language of this bill, and that's the problem with it. That's why I'm trying to limit the language to the DACA population. And with that, I go back to you, Mr. Gentleman from Georgia.
Yeah, the gentleman like to respond? Because I think this is a valid point, and I think it's the reason, again, we're looking at this, because a visa overstay would, present at least an issue here that needs discussing.
If the gentleman would yield.
I yield.
I would note that visa overstay individuals who are in undocumented status are eligible for DACA. In fact, there are many overstay people who are brought lawfully and then overstayed and then became in an undocumented status because their visa expired as children were eligible for DACA, and they'd be eligible for relief under this act.
Reclaiming my time, and gentleman from Arizona.
Thank you. Well, and that gets to the point I guess I'm trying to make. DACA itself required somebody be here unlawfully.
Correct.
And did not necessarily include people who were here on a visa who since overstayed their visa. But this is going to provide them
And
relief.
reclaiming the time altogether, and I think this brings up an interesting point, is the fact that they came here legally, they were here legally in status, and the ones that we talked about, and it's been talked about very much, and why the sympathy is there for many of us on both sides of the aisle, that the population dealt with here had no choice in how they came. These individuals had a choice in how they came. And I think this is an issue, because they overstayed a visa in which they had. And I think their parent, anybody else, so.
If the gentleman would
generally
yield,
California.
if, and I run into many of these individuals, your parents come in on a visa with you, a 2-month-old baby, the visa expires, and you're here, 20 years later, thinking you're a U.S. citizen. Those people are eligible for DACA, and they're eligible under this bill.
Exactly, reclaiming my time, and I understand the gentlelady, and I think the points are made both sides. I think this is going to the scope that is getting way beyond the scope, and which has been the concern for many of us on this is, where we already started with a DACA population, and we go to a dreamer population, and then we go to an unlimited population, and I guess that's just where we're at. With that, we have now successfully burned 5 minutes. I yield back.
Do others wish to be heard on the amendment? If not, then the question is on the amendment. All those in favor will say aye. All those opposed will say no. In the opinion of the chair, the noes have it. We'll find out if a quorum is present when we call the roll. The clerk will call the roll.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse, Ms. Macbeth, Mr. Stanton. Mr. Stanton votes no. Ms. Dean. Ms. Dean votes no. Ms. Mucarsel-Powell. Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Gomert votes yes. Mr. Jordan? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes.
Has any member, the gentleman from New York?
Mr. Nadler votes no.
Gentlelady from Washington?
Ms. Jayapal votes no.
Gentleman from New York?
Mr. Jeffries votes no.
Gentleman from Rhode Island?
Mr. Cicilline votes no.
Gentleman from California?
Mr. Liu votes no.
Are there any other, gentleman from Colorado?
Mr. Buck votes yes.
Are there any other members wishing to vote? If not, the clerk will report.
Ms. Chair, there are 8 ayes and 16 noes.
And the amendment fails. Are there any additional amendments
Madam
to
Chair,
be offered? Yes, the gentleman is recognized.
I have an amendment at the desk.
I reserve a point of order. Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. Stubbe of Florida.
Gentleman is recognized for 5 minutes.
Thank you, Madam Chair. This amendment states that the natural parents of an alien granted permanent resident status under this act shall not, by virtue of such relationship, be accorded any right, privilege, or status under the Immigration Nationality Act. For years, proponents of the DREAM Act have described the bill as an opportunity to provide legal immigration status to children who are brought to the United States through no fault of their own. Of course, given the actual text of this bill, the description is misleading, and my amendment would help to ensure its accuracy. H.R. 2820 provides a special pathway to citizenship to aliens who are illegally in the United States, many of whom came with their parents who made the conscious choice to illegally enter the United States. The bill we are considering today rewards those parents by ultimately allowing the parents to get a green card and eventually U.S. citizenship based on the green card provided to their child under this legislation. The process is also known as chain migration. It is one thing to support legal status for children who had no choice in their coming here illegally, but it's something completely different to hand a pathway to citizenship to the criminals who did make that choice to come to this country illegally with their children. This idea is not something new to Congress. It is included in other immigration proposals considered by this committee. In fact, the language of my amendment is included in H.R. 1548, the only bill that the Immigration Subcommittee has acted on so far this year, a bill by Speaker Pelosi. This amendment also echoes my Break the Chain Act, which would put an end to chain migration altogether by limiting family-based immigration visas to only spouses and minor children of U.S. citizens and legal permanent residents only. I don't think it's fair that individuals get preferential treatment in immigration because they are distantly related to a citizen, so my bill creates an even playing field for all applicants. In the same spirit, this amendment will ensure that criminals who entered this country illegally don't get to jump the line and receive citizenship before those that are waiting patiently to enter our country through legal pathways. I urge my colleagues to support this amendment and yield back the balance of my time.
I recognize myself for 5 minutes. I would, and I withdraw my point of order. I would urge that we oppose this amendment. This amendment would limit the ability of Dreamers to sponsor their parents once they become U.S. citizens, really creating a form, in my view, of second-class U.S. citizenship, which I believe we should oppose on principle. All individuals granted permanent residence under the Immigration and Nationality Act and those who go on to obtain U.S. citizens must have the same rights and privileges as all other lawful permanent residents and citizens, including the ability to sponsor relatives for permanent residence in the future. Not only is second-class citizenship wrong, I believe that status would most definitely violate the Equal Protection Clause by distinguishing among citizens based solely on how they earn their immigration status. When it comes to sponsoring family members, we have never arbitrarily excluded a subset of LPRs or citizens from the process, and I don't believe we should start now. I know that there are differences of opinion about how our legal immigration system should be structured, but I think that is a different debate for a different time. Family-based immigration has long been and remains a cornerstone of our immigration system and really is the foundation of America's rich and diverse culture. Strong family units are fundamental to the development of safe and vibrant communities and a robust economy, and we should not lose sight of that reality by accepting that this amendment would not protect families. You know, people have used the term chain migration, and it sounds scary, but the fact is there's really just the family, the nuclear family primarily, that can be petitioned for. U.S. citizens can petition for their spouses, their sons and daughters, and their siblings, but the sibling category is so backlogged that if you file now, the sibling who's been filed for won't live long enough for their priority date to be reached. So essentially, it's sons and daughters, spouses, parents, hardly an extended, remote family group. Really, as of May of 2019, some of the people, sons and daughters of LPRs that filed in 1996 are still waiting in line, which is something I hope we can deal with when someday we get to top-to-bottom immigration reform. But that is not this day. This provision would limit the ability of Dreamers to sponsor their parents at some point in the future, and I think reinforces a message that we should not have, which is that despite growing up in America, embracing this country as their own and becoming U.S. citizens, they're somehow different, somehow less than their fellow citizens, something I think we should not do. And for those reasons, I would yield to the gentleman from California, Mr. Correa.
Thank you, Madam. I just wanted to, again, remind folks who Dreamers really are. I have a picture here of James, an American soldier. He grew up in Southern California. He just enlisted in the U.S. Army. His goal, to protect America. He is an American warrior. And my question to all of you is, why would you deny James the ability to bring his family, bring them with an adjustment of status? Why would you not deny an American warrior the ability to be with his family legally in the United States? Madam Chair, I yield.
The gentleman yields back. I would just note also that the drafting of the amendment, we have two parents, and you might have a parent who brought a baby to the U.S., and then a parent who resides in the country where they're originally from, who did not bring the baby into the country. This prohibition would apply equally to the person who brought the child to the United States or to the parent who remained in the host country. So the expressed rationale for it, that someone who's violated the law should not benefit, would certainly not apply, because if the non-custodial parent was still in France, they committed no immigration violation and presumably would then not be subject to punishment. So with that, my time has expired. Are others seeking to? Mr. Gomer is recognized for 5 minutes.
Exactly. Last word. Thank you very much. I would yield to my friend from Florida, Mr. Stubbe.
Thank you. I appreciate the gentleman from yielding. You state, Madam Chair, that this isn't something that this Congress has done except in private relief bills, H.R. 1548, that Speaker Pelosi is the sponsor of, and that you, as the chair, Madam Chair, supported that bill. And Speaker Pelosi's bill actually goes a step further and bans siblings as well. So we're gonna allow individuals to illegally enter this country with their children, and now through this bill, grant those children who, to no fault of their own, were able to come into this country. We're gonna grant them amnesty, and then allow them through the chain migration process to then bring in their parents ahead of their siblings, to then bring in their parents through the chain migration statutes that we have. And I just don't think that's the direction that this country should be going, and I would ask for the support of this amendment.
Does the gentleman yield back? Gentleman,
Yield back to Mr. Gomer.
Mr. Gomer? The gentleman yields back. Are there additional members who wish to be heard on the amendment? If not, then we will call the amendment. All those who are in favor of the amendment will indicate by saying aye. Those who are opposed will say no. In the opinion of the chair, the noes have it.
Madam Chair?
Yes, sir.
I demand a recorded vote, and pending that, I make a point of order that a quorum is not present.
The recorded vote has been requested, and we will discover whether a quorum is present when the vote is called.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Steen?
No.
Ms. Steen votes no. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Gomert votes yes. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stube? Mr. Stube votes yes.
Are there members who wish to cast their votes? Gentleman from Maryland.
Mr. Raskin, you are not recorded. Mr. Raskin votes no.
Gentleman from New York.
Mr. Nadler votes no.
Are there other members who wish to be recorded? Mr. Cohen votes.
Mr. Cohen votes no.
Clerk will report. Oh, I'm sorry, the gentleman, suspend, the gentleman from Ohio.
Mr. Shabbat votes aye. Madam Chair, there are 8 ayes and 17 noes.
And the amendment is not agreed to. Are there additional amendments? Gentleman from Arizona is recognized.
Thank you, Madam Chair. I have an amendment at the desk.
I reserve a point of order, and the amendment will be distributed. Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. Biggs of Arizona.
Without objection, the amendment is considered as read. Mr. Biggs, you're recognized for 5 minutes on your amendment.
Thank you, Madam Chair. In order to be eligible for DACA, an individual had to meet certain requirements. They had to, 1, prove they had entered the United States on or before June 15, 2007. 2, that they were physically present in the United States from that date until June 15, 2012. 3, had no lawful immigration status on that date. And 4, were under the age of 31 years of age as of June 15, 2012. This bill, H.R. 2820, does not merely legalize the DACA population, but also extends green cards to millions of illegal aliens. My colleagues have, on the other side, have repeatedly discussed this. I've mentioned this in the last time I had an amendment up, that they're trying to provide relief to individuals who were brought here illegally by their parents through no fault of their own and were raised without familiarity with their home country. And yet this bill does not limit it to that population. It's not the focus solely on that population. This bill would also allow for the thousands and thousands of U.S. unaccompanied children and other aliens who illegally entered the United States after DACA was implemented. And you might recall that there was a surge under President Obama and the administration in 2014. As a result, probably, some would say, that it certainly was correlative to the implementation of DACA. But that surge hoped that they too would one day be granted relief to receive that same reward. And thus we provided continued incentivization and rewarded illegal behavior. To be eligible for DACA, you had to meet those criterion, as I said. And that also would require aliens seeking relief under this bill to have entered the United States before the age of 16, to have entered before June 15, 2007, which is the cutoff date for DACA eligibility. That's what my amendment takes this back to, and to have remained present in the United States since June 15, 2007. And so what I'm suggesting is, once again, this bill, 2820, expands what most people think of when they think of the DACA population. By changing the date in the bill to age 18, you're not in compliance with the underlying rationale of the DACA process, which was 16-year-olds, and that determined that population set. So we're, once again, the underlying bill expands that. My amendment is to merely try to limit us back to the DACA population as intended by the Obama administration. And with that, Madam Chair, I yield back.
Gentleman yields back. I recognize myself for 5 minutes to oppose the amendment. In the last Congress, the DREAM Act of 2017, which was introduced with bipartisan support in the House and Senate, the bill required Dreamers to have entered before age 18. And I don't think it makes good sense to limit this to 16 rather than 17-year-olds. As I've noted, there has been strong bipartisan support for covering those who entered the country up to the age of 17. Such a requirement has been endorsed by dozens of House Republicans in the last Congress, and it is the standard in the bill recently introduced by the Senate Judiciary Committee Chairman Lindsey Graham with Senator Dick Durbin. Second, the fact that DACA and some early versions of the DREAM Act used the age of 16 as the limit for obtaining status really isn't relevant to the bill we're considering today. The bill is about providing protection to those who entered the United States as children, and the 18th birthday is widely recognized in our country, including through our laws, as the age of majority. There's no question that our country recognizes childhood to extend through the age of 17. Children under the age of 18 can't vote, they can't join the military, they can't enter into contracts or make independent legal decisions. They can't marry without parental consent in most states. The criminal justice system also recognizes the age of 18 as the age of majority. Individuals 18 and older are treated as adults for all crimes, but children younger than that are understood to be minors and less morally culpable, as they are generally unable to form the same kinds of judgments. Given that the bill is about protecting those who entered as minors, the bill should adopt the legal standard that the country has adopted for almost everything else, and an additional restriction would not be wise. Imposing arbitrary restrictions like lowering the age at entry will not actually solve the issue before us, which is to help young people who were brought here as minors to resolve their legal status first through conditional status and then letting them earn their permanent residence status. Let's remember that these young people came here with different backgrounds, all walks of life. We are the beneficiaries, if this bill passes, of allowing these young people who have so much to offer our country to become fully American, not just American in their person, but also in their paperwork. I do believe that we should stick with the age 17 rather than the age 16 proposal that's in the amendment, and so would urge the opposition, and I would yield time to the gentleman from Georgia.
Thank you, Madam Chair. What we're trying to do here is squeeze as many people out of the protective arms of this legislation as we can. And all of those people that you're trying to squeeze out of it are in the same class of folks that we're trying to help with the legislation. They have been brought to the country as young people, children, and they didn't have a choice in it. And they're not lawbreakers. They're not aliens. They are not drug dealers and gun runners and gang bangers and thieves and rapists and murderers. These are people who are studying. They're good citizens. They're working. Some of them are serving in the military, police officers, teachers. These are people who need our help. They are under threat of being deported to a country that they don't know. And this is their country. They are Americans, but they just don't have the status. And so how many of these attempts to squeeze people out of our protective care are we going to face tonight? How many of these amendments? This is the second one now, and that comes after a series of demonizing amendments to try to scare people away from those who we're trying to protect. How many of these narrowing amendments will we face now, trying to nickel and dime this legislation? We'll be here as long as it takes to defeat each and every one of them. So I thank the folks out there for your tenacity in staying put. We're going to stay here with you. We're in solidarity. So with that, I will yield back.
The gentleman yields back, and my time has expired. Do members wish to? Yes, the gentleman from Texas is recognized.
Thank you.
Strike
Strike
the
last word. I would yield my time to my friend from Arizona, Mr. Biggs.
Thank you, Mr. Gomert. Appreciate that. I just, the gentleman who just spoke talked about demonizing and scaring again. I mean, I'm not trying to demonize or scare anyone. I find it offensive, quite frankly, that you continue to resort as your primary argument. You say they're not aliens. Well, then why in the world did you not move to amend the document, the amendment in nature of a substitute, to delete the term alien? I heard one of your members indicate that she would like to do that very thing. And so I find myself, no, I won't yield. I will not yield.
The gentleman has.
Why not?
Mr. Johnson, the gentleman has the time.
I won't yield because you continue to refer to anybody who attempts to do anything on this bill as demonizing and using scare tactics. That is, in my opinion, a salacious argument. It's not moving the ball forward. And so I'm going to address now some of the issues that were raised, I think, by some thoughtful arguments raised by the chair. She said this is not good sense and that this is arbitrary to move to 16. Well, but I'm not doing anything other than taking to the original DACA population. That's what this amendment does. It goes to the original definitions of the Obama administration. Secretary Napolitano and her staff put that together. I don't know why, but she did. And what the underlying bill does is actually expands the population. And in so doing, I would suggest that it may recognize that the surge was a byproduct of the original DACA policy implemented by the Obama administration. And so when we start talking about whether we're going to squeeze, no, we're not trying to squeeze it. We're trying to say, look, if this is what you're trying to get at, moving beyond that is actually an expansion. And really, if you're going to say 18, that may be arbitrary as well. There's all kinds of ways to justify whatever number is picked, but in the end, it's going to be arbitrary. And so I'm saying let's eliminate the arbitrary nature and go back to the original underlying bill. And that's what I'm saying, which neither demonizes nor scares nor should put fear into anyone. All it should do is say, well, gee, that was the original deal, and we're trying to get back to the original deal. And with that, I yield back to Mr. Gomer.
Thank you. And when it comes to age, I have a question myself. The original premise for DACA was children that were brought here without any input whatsoever. Their parents drugged them into the United States, and they should not be punished for simply coming into the country with their parents. And, I just been sent a picture of a 6-year-old boy and 8-year-old girl who came unaccompanied to the border near McAllen yesterday, unaccompanied. And I'm curious, and I yield to the chair for an answer. How does the reasoning for DACA that children were brought in, sometimes against their will, they were brought in by an adult, how does that mesh up with children coming completely unaccompanied by themselves?
Is the gentleman yielding to me?
Yes.
I doubt that any 6-year-old made their way on their own by themselves from Honduras to El Paso. They were set on their way by adults and assisted every step of the way by other adults. A 6-year-old is not capable of making that journey by herself. nor making the decision to come by herself.
And
I would yield back.
I think you're right. 6-year-old can't make that trip on their own, but I just wondered how that fit in with the argument that their parents brought them, and therefore they shouldn't be responsible for the illegality of their parents. But my time's expired.
Gentleman's time has expired. Do other members, Mr. Cicilline?
Thank you, Madam Chair.
Moves to strike the last word?
Yes, I move to strike the last word. I think the reason it's difficult for members on this side of the aisle to understand amendments like the one before us, which attempt to restrict or impose limits on the individuals who would be eligible for DACA protection, is because we fundamentally disagree with our friends on the other side of the aisle about the value of the Dreamers and the contributions they have made to our communities. We saw firsthand this magnificent panel of extraordinary dreamers who we ought to be fighting to keep in America because they're making incredible contributions. And we all know from the experiences in our own communities, we have all had the tremendous honor of meeting dreamers who have overcome incredible challenges to come to America and develop their own abilities and to make contributions and be leaders in our community. And so for us, it's hard to understand why would anyone who understands the value and the dignity and the worth of young people who came here and know no other country than America, why would we try to limit that group? We ought to be trying to enlarge that group because they make incredible contributions. This is kind of a pre-screened group of people. They have to be law-abiding citizens, they have to be in school, there's a whole set of criteria, so we're sort of guaranteed these are the cream of the crop. And so I think that's why we struggle in trying to understand, and maybe it's just we begin from a different point. We understand and value the incredible contributions that Dreamers have made to our country, and our lives are enriched by their presence in our communities, and we're a better country. We're more American because of our willingness to welcome them. But what I really want to respond to is the suggestion that the gentleman made that DACA in some way contributed to the border crisis or caused it. None of us on this side of the aisle doubts that there's a humanitarian crisis unfolding on our southern border, but it was not caused by DACA. And nothing in the DREAM Act incentivizes migration.
Gentleman yield.
Sure.
Would the gentleman yield?
Thank you so much. Mr. Cicilline?
Oh, I'm sorry. Do you mind if I just finish one thing? I'll get right to it. To be eligible for DACA, you have to be in the United States since 2007. No one who entered the country while President Obama was president is even eligible for DACA. So there's just no way that DACA could have caused the additional migration of people who were ineligible for the program. Even though President Trump terminated DACA in 2017, and DHS has not accepted any new DACA applications in more than a year and a half, the increase in the arrival of unaccompanied children and families has continued. The DREAM Act also does nothing to incentivize illegal migration. The DREAM Act is only available to individuals who entered at least 4 years ago when they were children. The argument that the 4-year look-back encourages illegal migration is ridiculous. Absolutely no one is deciding to come to the United States because they knew about the 4-year look-back and are expecting the bill to take another 4 years to be enacted. If my Republican colleagues are really worried about this 4-year look-back, it's an enticement for people to come. They should help us pass this bill as quickly as possible. And that will prevent this from happening. So I'm going to yield the balance of my time to the gentlelady from Texas, Ms. Escobar.
Thank you, Mr. Cicilline. I, too, have been very concerned about the conflation that we've been witnessing as we're talking about DACA recipients and young migrants, this wanting to bring up what's happening at the southern border. My community, more than any other community, has been impacted by the increasing numbers of Central American families who are essentially running for their lives. And I have said this before, I will say this again. I am inviting every member of the Judiciary Committee to come to my community. Many members of this committee already have, who have visited not just with law enforcement, but have visited with advocates, and more importantly, have sat and spoken with families. It's so important that we understand everything that's occurring. With that understanding, we are able to be better legislators. So I just wanted to issue that invitation one more time. I yield back to my colleague.
I think, Mr. Johnson, do you want?
Yeah, I'd just say thank you for yielding. I would just say that I don't want to hurt the feelings of my colleagues on the other side of the aisle, but I feel so, in touch with the suffering that's going on with the people that we're trying to help who worry when D-Day approaches about whether or not they're going to be deported or not. And that's why I say the things that I do, because they feel the pain. So you all feel the pain, but they feel a different pain, and we want to try to ameliorate that pain.
The gentleman's time has expired. Let me see if there's someone on, the gentleman from Colorado is recognized.
I move to strike the last word.
And you're recognized for 5 minutes.
Thank you, Madam Chair. I want to respond to my friend from Rhode Island, and I appreciate your comments. I don't know that anybody on this side of the aisle disagrees with your statement that there are many, many DACA recipients who are great individuals. And we have, at least I can speak for myself, I have a lot of compassion for those individuals. In my district, I have met many of those young people. And they are, the ones that I have met are law-abiding, they are hardworking, they are people that I'm proud that they are part of the community. The problem that we have, or at least the problem that I have, is that I believe sincerely that when we make a move like this, we send a message to people and we give them false hope south of our border. And that's the problem that I'm having with this. If you combine this with border security and frankly other measures, we've got to look at foreign aid and try to build up communities. We've got to look at law enforcement help and try to deal with the gang problems south of our border. It is a complex issue, but this is one small part of a very complex issue that we need to solve. It's not that I object to this bill, it's that I object to this bill in isolation. And so it's not that I certainly have any problem with treating these young people with compassion. For the most part, I don't blame them for having entered this country without proper documentation. I don't blame them for being here. I don't blame them for the life that they have lived in this country. What I'm trying to do is make sure that we don't offer false hope to future generations of parents to bring young people here with the idea that this is going to happen again. We did this in 1986 with Simpson-Mazzoli. We promised the American people that we would have border security, and we failed. And as a result, we've created a humanitarian crisis throughout this country, not just on the southern border, but throughout this country. The resources in my district and in my home county are strained as a result of having primarily Spanish-speaking individuals in a school district that has to have a lower class size to try to help those individuals in our education system. It's strained in our healthcare system. It's strained in so many ways, and we can't continue to do that. And so I absolutely want to work with my friends and find a way to treat these individuals with compassion, many of them great individuals that will contribute to this country for years and frankly have families that will contribute to this country for generations. But we've got to find a way to deal with the issue at the border, or we are giving false hope, in my opinion. And so it's not just an empty argument that we have a crisis at the border and we're linking the two issues. It is a sincere effort to try to make sure that we don't pass on to our colleagues 20 years from now those that take over for us this problem. And so I recognize the gentleman's heartfelt compassion for these people. I agree with it. I just think folks on this side of the aisle are linking two issues that are very important. And with that, I yield back.
Gentlelady from Texas. Strike the last word.
Move to strike the last word.
Recognized for 5 minutes.
Let me, first of all, I'm going to ultimately, Madam Chair, put on the record number of roll call votes that I missed because I was serving as Speaker Pro Tem on the floor, and I do want to put them in the record. And so I may have missed the gentleman from Arizona's explanation, so I'm just going to take a moment to yield to the gentleman from Arizona, the author of this amendment. What is the purpose of this amendment? I missed hearing the initial discussion.
Yeah, thank you, and I appreciate you yielding to me and your sincere desire to know what I'm getting at. What I'm getting at is my amendment takes this back to the original DACA requirements. So the DACA requirements meant that you had to be in the U.S. on or before June 15, 2007, physically present from that day to June 15, 2012, no lawful immigration status on that day, and you were under 31 years of age as of June 15, 2012, which meant that where we are today and where you were then, you had to be under age 16. And that's what this amendment does. It takes you back, puts you right where DACA is. The underlying bill itself actually expands it in multiple ways, but certainly in this way, I'm trying to get back to that point. That is the objective.
Let me thank the gentleman for his explanation, and let me try to characterize or to offer. I'm sure there have been many explanations, and you might consider what you're doing in the strict letter of the law. What happens when one works on legislation? You move to protect the American people, but you also move to respect the definitive changes that warrant response. And so I have to oppose the gentleman's amendment because he wants to start where we are not. The bill that we have today doesn't undermine the gentleman's intent. It only recognizes the current structure or the current needs of the day that will not violate any more the security that we need for the nation. So, for example, I have a dreamer, an older dreamer, who is a paramedic, who was in jeopardy when the president precipitously dismissed dreamer status and put everyone in a panic. He's in a rural community. The community rallied around him, but he was in jeopardy of his status. And that rural community was going to lose his services, but lose him. And frankly, he was one of those important rescuers during Hurricane Harvey when no one asked for anyone's identification or documentation. So I'd say, Mr. Biggs, it looks as if it is okay to take us back to a framework that was utilized. You're absolutely right. But when we began to do our research, we determined that people were aging out. There were people that were older that had come in under that status, and that if you did not correct it, you were just passing something that would leave a problem still needing a fix. And so I would say to you that you will have a problem still needing to be fixed of people who legitimately warrant being in this country on the criteria that we have listed, all being people who would provide service, contribution, patriotic passion. And so I'd make the argument that your intentions may be for that era that we were in. And I was here long enough to know that era, but we're now at a place where it is crucial that we embrace the wholeness of the people that are here. And if we do not, I hope we can see in that focus, you will then have an added problem that I don't think Republicans or Democrats would welcome, because you'll have unstatused persons who will again be in the eye of the storm and be condemned because they're undocumented or they're unstatused. And I don't want that to be the results of the work in this committee, because we are the committee that fixes problems for this country. And so I yield back and sadly have to oppose the amendment.
Gentlelady's time has expired. Do other members wish to be heard? Gentlelady from Washington.
Thank you, Madam Chair, and I associate myself with the comments of the gentlelady from Texas. And, you know, I think that we are just in very different places. I oppose this amendment because both the age and the year would dramatically limit the number of people that would be eligible. It would be like fixing a tenth of the problem. It would be about 8 years difference. So 8 years of people, and I would argue that it's actually our fault. I've only been in Congress for a couple of years, but we have not been able to fix this, and Republicans have been opposing us on these bills around the Dreamers for years. And so this date actually matches what some Republicans introduced in the Senate. Lindsey Graham's bill has 4 years before the date of enactment. That is the same thing we are doing in this bill, 4 years before the date of the enactment. So we are matching to what even Republican colleagues in the Senate have introduced. And in the end, we want to make sure that our failures of passing legislation that benefit Dreamers and folks who have been waiting for us to give a real solution, that these young people should not have to pay the price for our failure to not pass legislation that protects them sooner, that gives them these so important papers sooner so that people don't have to live in the shadows. And I hope, I agree with Mr. Buck that we need to have a comprehensive solution for immigration reform. I know the chairwoman has been fighting for that for a very long time. I know I've been fighting for that for a very long time. We have been trying to say for a very long time that the immigration system is broken, it needs to be fixed, and that we are detaining too many people across this country. We are using inhumane enforcement laws. But ultimately, if we just allowed the country to recognize what we actually see every day when we eat our vegetables, when we stay in hotel rooms, when we do all of the things that immigrants provide services for, when we drink our milk and we think about the dairy farmers who are utilizing the labor of undocumented immigrants, somehow we're okay with taking that labor, but we don't want to actually provide a way for people to be here with the proper documentation so they don't have to live in the shadows. So I do hope that we can get to a comprehensive immigration reform solution, but because we have been opposed on that every step of the way, let us at least take care of the piece that we have had bipartisan support for in the past, not enough to get it through the Senate, to break that cloture vote, but this is a moment for us to serve the people that we know deserve to be served. And so I just think I appreciate the amendment from Mr. Biggs. He's in a different place, we're in a different place, but it takes away 8 years of people who would be eligible under our bill. This amendment would take away 8 years of that, plus on top of that, lower the age of eligibility. So I oppose it. It does not solve the Dreamer problem in the sense of the scope that the current bill does. And I look forward to the day when we can, as a committee, take on a real humane approach to immigration reform, not leave immigrants out there, take the labor, know that they're driving the economies in our states and cities and towns across the country, and then somehow say that we feel so, we feel so certain that they shouldn't be allowed legal status. Well, unless you don't stay in hotel rooms, unless you don't eat vegetables, unless you don't drink milk, unless you don't eat beef or chicken or all of the other things that, ways in which immigrants contribute, not to mention as doctors, as many other professions, it's hypocritical for us to continue to say that somehow these people are doing wrong when we are taking in their work and their labor. So anyway, I hope we get to that point, but in the meantime, I have to oppose.
Will the gentlelady yield for a question?
I will yield to my
Thank you.
colleague from Rhode Island.
I was just thinking as you were speaking that in some ways,
The gentlelady's time has expired. We ask unanimous consent for 1 additional minute for the gentleman.
Thank you. In some ways, where this amendment would actually punish Dreamers because of the inaction of Congress.
Exactly.
Which seems like a very unfair thing to do. And secondly, in many ways, you would still have to satisfy all the requirements that are contained in this legislation So we would actually have more evidence that this person has fully integrated into the community, is a law-abiding citizen, has deeper ties to the community. So it seems like it's actually a perverse incentive. We're punishing them because of our own inaction, and we're getting people who have deeper roots in the community and making them ineligible, which seems to be counterintuitive. Am I
Very,
understanding?
very well said. And I would just add that this isn't just a Democratic proposal. This is actually the same idea as what was introduced by Republicans and Democrats in the Senate 4 years before the date of enactment. That's the same thing we're proposing. Thank you, Madam Chair.
Madam Chair.
A gentleman from Ohio is
No
recognized.
strike last word.
Gentleman is recognized for 5 minutes.
Thank you, Madam Chair. In light of a lot of things that you said, I'm not going to use the full 5 minutes, I don't think, but I support the gentleman from Arizona's amendment. Thank him for offering it. Thank him for some of the incoming that he's taking by offering amendments, and a number of us have. That's part of the way it works, so I get it. I'm not worried about that too much, but just a couple of other points. President Trump down at the White House some time ago sort of offered to do something about the Dreamers in a bipartisan manner. That's the only way this is ever going to happen. It might pass this committee, it might even pass the House floor, but it's not going to happen unless it's done in a bipartisan manner. And the president offered to do that. Not every Republican, certainly not every Democrat supported that, but he said, let's get together. We'll give you DACA, but we want to actually control our borders. We've talked about it a lot. Let's do both. And the Democrats basically slapped them in the face and said, no, we're not going to do it. We're not going to offer it. We're not going to agree with it. And it just stopped. And I know some of my Democratic colleagues say, oh, no, it's the Republicans. That's not the way I remember it. It was the Democrats that rejected this. And you know, when you reward law-breaking with amnesty, you're going to get more law-breaking. I mean, it's just kind of common sense. When Obama announced his DACA policy, there was a surge of illegal immigrants at our border. You know, it used to be single men in general from Mexico coming here, and in recent years, it's been more and more families and children coming up here, sometimes unaccompanied, sometimes with their actual parents, sometimes not. But it's been mostly families from Central America, Guatemala, Honduras, El Salvador in particular. And no question, they're fleeing all kinds of horrific things down there, and we ought to work with those governments a lot more than we do. And I'm not for cutting off the aid down there, although I completely understand the president's frustration with those governments not really working with us, and oftentimes behind the scenes, or maybe even not behind the scenes, working to help to put these caravans together that are coming up to break our laws. But, you know, as far as President Obama having his DACA policy and then the surge at our borders, the same thing is going to be true here. If we change the law to allow people to bring their children here illegally, and then they can stay, I mean, it's just logical. More people are going to bring their children here and know that somewhere down the road, they're going to get to stay. There's just absolutely no question that that's going to happen. We're setting a precedent, although the precedent has really already been set. We're probably reaffirming a precedent that's already been set. And so if you really want to accomplish something on the DACA, folks, you know, many of us are willing to talk about it, willing to actually maybe do something about it, if we can actually control our border. That's what we want to do. We want to make sure that the border is controlled. The American people have a right to have the border controlled. The American taxpayers have the right to not have to pay the bill for a lot of people who are taking up education, taking up health care, housing, some in the criminal justice system, and haven't paid anything into it. The American taxpayer is footing the bill for these things. And that's why so many on our side feel so strongly about this, because we think that the border absolutely has to be controlled, and it's not being controlled. And when you look at the asylum laws right now, we've talked about doing something there in a bipartisan manner. When people can come up here and the cartels bring them up here and make tons of money, and then basically tell them the magic words that they're in some fear. They say that. We give them a court date a couple years down the road. We put them on a bus or now on a plane, send them all over the country, and very few people show up for those court hearings. That absolutely has to be repaired. If we don't get border control, we're not going to be a country in the near future. I think the president's right about that. And I guess finally, you know, a previous president, one of my heroes, probably a lot of us on this side, I think he was the first president I met, probably not here on the other side, Ronald Reagan, famously really got suckered on this issue. They sort of suckered him into a deal where we're going to allow amnesty this one time, then we're going to get control of our borders. The amnesty happened. The border control never happened. We had a couple of million people here illegally then. It's far more than that now. And I yield back.
The gentleman yields back. The gentleman from California.
Thank you. I move to strike the last word.
The word is duly struck, and the gentleman is recognized.
Thank you, Mr. Chair. I just wanted to follow up on from the gentleman from Ohio, some of his comments about the law breaking, and wanted to focus on what this is all about. You know, last year, my daughter came home from high school. She was a senior, and brought home with her two of her best friends, both DACA students, both very shy, very quiet, very nervous and scared because they had heard the news that DACA was being rescinded, had been rescinded by this president, and wanted to know what I could do for them. The more I asked them questions about their situations, the more I realized they really represented a typical family in my district in many areas of this country. Some of their siblings born in the U.S., some not. One of the parents, legal status, the other parent, no legal status. One leg in the U.S. and the other not. And I gave them some advice. I said, look, keep doing what you're doing. Study hard. Follow the laws. Pay your taxes. Be good. And let's work on your issue in Washington. And the more people find out in my district that I'm in Congress, the more I realize how many dreamers are gainfully employed in my district. Every time they find out I'm a U.S. congressman, they ask, what can we do? What's going on? And they're all gainfully employed. Good jobs. In my county, we have a 3% unemployment rate right now. These folks are working. They're adding to the wealth of this country, to the miracle of this economic growth. And guess what? They all pay property taxes. They all pay income taxes. They pay federal taxes, state taxes, sales tax. Many of them will also be paying Social Security tax and will never see that Social Security benefit from retirement. So when I hear my colleagues talk about a free ride, I don't see that. I see people talking about the cost, but not their contribution to our wealth and our economy, the best in the world. I don't get it. Southern California, still the capital of manufacturing in this country. And guess who the workers are? A lot of undocumented, a lot of immigrants. That is what America is all about. And again, my daughter, two dreamers, her best friends. I want to show you another picture of another dreamer, Katia. She also went to the same schools my daughter went to. She just graduated from UC Riverside, and she's going on to law school. She's trying to figure out how to pay her way through school. You know what? She doesn't get financial aid. You know what? She's working her way through school. That's what the American dream is about. Working hard, fulfilling your dreams. Mr. Chair,
Did the gentleman
I yield.
yield?
Yes. Yes.
From Texas. Thank you. I know it's late. Thank you so much, Mr. Correa and Mr. Chairman. I just want to say something very briefly. Here we are 9 hours in to a hearing for Dreamers. And I want to thank Mr. Shabbat for his statements, because I think they very transparently and clearly delineate the differences here. And that's why this whole exercise that we've been engaged in for 9 hours of amendments to a piece of legislation that is long overdue. But Mr. Shabbat very clearly laid out his views on immigrants. You did not hear a single positive remark or observation about immigrants. And we've been sitting here all day having to defend human beings who contribute to our economy, to our country, to our security, to our safety, to our future. But it's so important, and I would encourage everyone to go back and listen to those remarks once again so that you understand fundamentally what this is about. It's about the way that we see people. With that, I yield back.
Mr. Chairman. Mr. Chairman. Move to strike the last word. If I may, I'd like to yield to the gentleman from Ohio, Mr. Shabbat.
Thank you. I'll be brief. There's a big difference between, you said, you keep talking about immigrants. There's a difference between people that are here legally and illegally. There's legal immigrants, then there's illegal immigrants, and that's a huge difference. People come to this country all the time. They do it legally. They do it the right way. They don't break the law. They do great things for this country.
Will the gentleman
That's the
yield?
way it's supposed to happen. We got a lot of other people that do it illegally. And if we're going to do something, for example,
you
about
yield,
the
sir?
DACA folks, just wait, and then I'd be happy to. It's not my time, but I would encourage my colleague to do that down there in just a minute. But that's the big difference. We have folks that come here illegally, and I think that's hurtful to the country. That's the problem. People that come here legally, that's great. I would encourage. I would be one who thinks that we have some folks that think that we need to lower immigration in this country. I think immigration is very good for our country. But when it's legal, when it's illegal, I think it's harmful to our country. And if the gentleman would yield, I'd be happy to yield to the gentleman.
I'll yield.
Thank you. Just want to point out that you make a good point, except that those with and without documents all work equally hard, and they all equally pay taxes, sir. Thank you.
Would the gentleman yield?
Mr. Chairman, I yield.
I thank the gentleman for yielding. I just want to point out that whatever one says about the difference between illegal immigrants and legal immigrants, the fact is the bill before us is talking about people who did not break the law. We're talking about people who were brought here as children, had no choice in the matter. So we're not talking about rewarding people who broke the law. We're talking about people who were brought up in this country who may not have even found out they're not citizens until they applied to college. They may have been here at 1 year old. So it's very different. If you want to talk about legal versus illegal immigration, that's fine, but that's a debate that isn't on this bill. I yield back.
Reclaiming the gentleman's
Chairman,
time, if I can.
Well, let me
Go ahead.
just respond to that, and then I'll yield.
It's fine.
Mr. Chairman, I would respond by saying that this bill is broader than just the DACA population. As you know, any individual who entered the U.S. under the age of 18 and who is present for 4 years prior to the date of enactment is eligible for a green card under this bill. There is no age limit and no requirement that the alien have no lawful immigration status. So it's a lot broader, and I think my colleagues on the other side would agree that it is much broader than just for DACA. And with that, I would yield back to the gentleman from Ohio.
Thank you, reclaiming. Relative to the kids or whatever, now some of them aren't necessarily that young now, they're older now, but the parents did something illegal. And when somebody commits a crime, that's what the parents did by coming here illegally. If you let people benefit from it, essentially you're going to get more of that behavior, and that's what we've seen here. We saw it when Obama did DACA. We're going to see it after this when this passes. But that's the whole thing. This isn't good. It might pass this committee. It might even pass the floor, but it's not going to become law. At least not right now. What we ought to be doing is working together in a bipartisan manner. And let me just say this as well. You're focusing attention on these folks that came here from our southern border. It's a big world out there. There's a lot of countries out there. There are people that would love to come to this country, and they're determined to do it the right way, because that's what we're told to do. That's what most parents bring their kids up to not break the law. I really don't have the time to do it myself.
That's mine.
Well, let me finish, and then if there's time, I'd be happy to yield. People that want to come to this country, essentially you're letting these folks cut in front of the line of people that are trying to do it the right way. Is it fair to all those people that'll never get the opportunity to come to America, to experience the life that we had, because they've determined they're going to do it the right way? They've taught their kids that you get ahead, you do well in this country if you get a good education, you work hard, you follow the law, you do things right. That's the way they bring their kids up. And a lot of people around the world, to me, that would be much preferable to have folks coming in here that are going to respect the law than people that are going to just break the law and cut right in front of people. And then we reward the people that are the line cutters, and we punish the people that do it the right way. And if the gentleman will yield, I'll be happy to give him the time.
Mr. Chairman, you can have
Thank
the
you. I will
remaining
take
time.
about 30 seconds. I just want to point out the gentleman from Ohio talked about, in effect, punishing the children for the sins of the parents. The parents broke the law, etc. The Ten Commandments says that that the Lord visits the sins of the parents on the children unto the third and fourth generation, but only to those that hate me. Only to those that hate me. There has to be a fault in the
Reclaiming
kids.
whatever time isn't left, I'm not saying that we should punish anyone. I'm just saying that we should apply the laws to this country equally to everybody. That's what I'm saying.
Time of the gentleman has expired. The question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no? No. The noes have it. The amendment is not adopted, is not agreed to. Is there any further amendments? Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes. Ms. Jackson-Lee, you are not recorded. No. Ms. Jackson-Lee votes no.
Gentleman from Tennessee.
Mr. Cohen votes no.
Clerk will note it's no once again. Is there anyone else who hasn't voted who wishes to vote? Clerk will report.
Mr. Chairman, there are 10 ayes and 18 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? If there are no further amendments, the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor of the amendment in the nature of a substitute respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill. H.R. 2820 is amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. The ayes have it. The bill is ordered reported favorably. A roll call is requested. The clerk will call the roll.
Mr. Nadler?
Yes.
Mr. Nadler votes yes. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Aye. Mr. Cohen votes aye. Mr. Johnson of Georgia? Aye. Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
Yes.
Mr. Cicilline votes yes. Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye. Ms. Stemmings? Ms. Stemmings votes yes. Mr. Correa?
Absolutely yes.
Mr. Correa votes yes. Ms. Scanlon? Yes. Ms. Scanlon votes yes. Ms. Garcia?
Yes.
Ms. Garcia votes yes. Mr. Neguse?
Yes.
Mr. Neguse votes yes. Ms. McBath?
Yes.
Ms. McBath votes yes. Mr. Stanton?
Yes.
Mr. Stanton votes yes. Ms. Dean? Yes. Ms. Dean votes yes. Ms. Mucarsel-Powell?
Yes.
Ms. Mucarsel-Powell votes yes. Ms. Escobar?
Sí. Yes.
Ms. Escobar votes yes. Mr. Collins? No. Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby?
Before I say pursuing.
Mr. Gates?
We'll have 2 days to deliberate.
Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes no. Mr. Liu votes yes.
Are there any other members who wish to vote who haven't voted? While we're waiting for someone who is on his way, the gentlelady from Texas would like to insert into the record.
General Lee, my amendments missed, if I might, Mr. Chairman. I'll do it very quickly. As indicated, I had to serve as Speaker Pro Tem today, and I missed the following amendments. Gomert, I would have voted aye. Buck, amendment aye. Biggs, amendment aye. I'm sorry. That's why I was missing from the room. Withdrawn. Gomert, no. Buck, no. Biggs, no. McClintock, no. Lesko, no. Getz, no. Klein, no. Biggs, no. Steuben, no. Biggs, no. And I thank the gentleman. I ask unanimous consent to place that in the record because this bill is so important, and I wanted to make sure my presence was known on these vital amendments. I stand corrected.
Alice, no, without objection.
Thank you.
Where is he? The gentleman from Maryland, how does he vote on the bill?
Mr. Raskin votes aye.
Has everyone who wishes to vote cast his vote? The clerk will report.
Mr. Chairman, there are 19 ayes and 10 noes.
The ayes have it. The bill is amended as ordered, reported favorably to the House. The committee is still in session. We have two more bills to go. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and without objection, staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2821, the American Promise Act of 2019, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2821, to authorize the cancellation of removal and adjustment of status of certain nationals of certain countries designated for temporary protected status or deferred enforced departure and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2821, the Promise Act, establishes a pathway to permanent residence for individuals covered by programs known as Temporary Protected Status, TPS, and Deferred Enforcement Departure, DED. Unlike Dreamers, who have captured the attention of the American public, less is known or understood about TPS and DED, but the individuals who are currently covered by these programs are equally deserving of our protection and support. Broadly speaking, TPS is a form of humanitarian relief that may be provided to individuals from countries facing dangerous conditions. Our immigration laws authorize the Secretary of Homeland Security to designate a country for TPS in response to a variety of crises, including an armed conflict or civil war, a devastating natural disaster, or other extraordinary conditions. The Secretary can designate a country for TPS for up to 18 months and can extend the designation if the country continues.
Mr. Chairman, the committee is not in order.
The gentleman is correct. The committee is not in order. But I am merciful and will not start reading my statement from the beginning. The Secretary can designate a country. The Secretary can designate a country for TPS for up to 18 months and can extend the designation if the country continues to experience dire conditions. Individuals from designated countries who meet certain conditions and are granted TPS benefits are authorized to reside and work lawfully in the United States. Since the TPS provisions were enacted in 1990, a total of 21 countries or parts of countries have received a TPS designation. At present, 10 countries have such designations: El Salvador, Haiti, Honduras, Nepal, Nicaragua, Somalia, South Sudan, Sudan, Syria, and Yemen. Deferred enforced departure, or DED, is similar to TPS, but it is derived solely from the President's constitutional powers to conduct foreign relations. Unlike TPS, individuals who benefit from DED are not required to file any paperwork unless they seek work authorization. The President may grant DED when country conditions improve to such an extent that TPS is no longer warranted, but foreign policy interests are served by allowing affected individuals to remain. At present, Liberia is the only country designated for DED. Liberia was first designated for TPS in 1991 by President George H.W. Bush. Since then, the country has been designated for either TPS or DED under both Democratic and Republican administrations. Most of those currently covered by the legislation have been lawfully here for nearly 30 years, and it is estimated that they number no more than 750 to 4,000 people in total. Over the past couple of years, the Trump administration has announced the termination of TPS for 6 countries: El Salvador, Haiti, Nicaragua, Sudan, Nepal, and Honduras, representing 98% of all TPS recipients currently in the United States. And in March 2018, President Trump announced the termination of DED for Liberia. The president opted to terminate these protections despite continuing political instability and compelling evidence that social and environmental conditions in those countries remain dire. Federal lawsuits have been filed challenging all 6 TPS terminations, as well as the decision to end DED for Liberia. As a result of those lawsuits and related administrative decisions, the termination of the designations have all been placed on hold. But any reprieve for the estimated 300,000 individuals who would otherwise be impacted by the administration's actions is just temporary. Like Dreamers, TPS and DED recipients have become essential to our communities. TPS recipients have lived in the United States for an average of 19 years, while DED recipients have been here for almost 3 decades. And I should say that TPS is a temporary program, and when the catastrophe abates, if it's after a year or 2 or 3, then it is proper to end the TPS and people can go home. But once people have been here for 15 or 20 years, they've laid down roots here, they've raised families here, then to suddenly say they have to go home after 15 or 20 years, to go home to someplace they haven't seen in 15 or 20 years, when they may have American citizens, children or husbands or wives, and it'd be parts of their community, that becomes cruel. And that's what we have to deal with today. TPS and DED recipients are scholars and educators, business owners, and professionals. They make up a significant portion of the workforce in key industries, including construction and food service. They contribute to the U.S. economy not only through their work, but also through consumer spending and tax revenue. According to the Immigrant Legal Resource Center, removing TPS recipients would result in a $4.5 billion loss to our nation's gross domestic product per year. TPS and DED recipients are also the parents of nearly 275,000 U.S. citizen children. It would be cruel to remove their parents. They have lived, learned, worked, and raised families in America, and yet they are unable to become lawful permanent residents in the country that has become their home. And now they face the possibility of being removed to a country they have not known for decades. Failing to provide permanent protections for TPS and DED recipients at this critical juncture would be a travesty, not only for these men and women and their families, but also for us as a country. I congratulate my colleagues, Nydia Velasquez and Yvette Clark, for introducing this important legislation, and I urge my colleagues to support this vital measure. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. And again, as we have finished one bill, we're moving on to others, and I think we're still at the problem that I addressed in the first bill today, and that is the crisis is still happening at our southern border. And we've opted once again not to consider legislation that will do anything to help fix the problem. We've chose to move legislation that has no chance of becoming law, but will actually incentivize migrants to continue flooding our southern borders. We wanted to work together. That was not offered. H.R. 2821 encourages migrants to abuse our immigration system by creating a special path to citizenship for foreign nationals from countries that have been designated for temporary protected status or deferred enforced departure. The Immigration Nationality Act allows the DHS Secretary to designate a country for TPS if there are circumstances preventing the safe return of nationals to a country, or if a country is temporarily unable to adequately handle the return of its nationals. The effect of a TPS designation is nationals of a designated country who are inside the United States on the date of such designation, whether here legally or illegally, can apply to remain in the States and even receive employment authorization. According to DHS, there are nearly 418,000 TPS holders from 10 different countries currently residing in the United States. The Pew Research Center has noted all but a small number of the TPS holders were in the country illegally at the time of their country's designation. Usually, TPS is initially designated for a period of 18 months and then redesignated in 18-month increments after the DHS Secretary reviews the conditions in the country to determine whether the conditions for the initial TPS designation continue. If the Secretary determines the country no longer meets the conditions for TPS designation, the statute requires that the Secretary terminate the designation. Unfortunately, what Congress intended to be temporary protection has over time become a permanent status, as some countries have been automatically redesignated for decades. Nicaragua, for instance, was initially designated for TPS in 1999 due to Hurricane Mitch, and a series of earthquakes led El Salvador to be designated for TPS in March 2001. To its credit, the Trump administration has faithfully followed the law, which mandates the Secretary shall terminate a TPS designation if the conditions for which the initial designation occurred no longer exist. Accordingly, the Secretary announced the termination of TPS for Sudan, Nicaragua, Haiti, and El Salvador but gave those populations at least 12 months to prepare for departure. It comes as no surprise that advocates sued and the federal courts enjoined the terminations. Deferred enforced departure is purely discretionary grant that the president can grant based on his foreign policy powers to provide a deferral or of enforced departure for certain aliens. In 2007, President Bush provided DED for Liberians who have been in the country under a previously terminated TPS designation. President Obama subsequently extended the DED designation, and on March 30th, 2018, President Trump issued a directive stating foreign policy considerations do not warrant a further extension of the DED, and providing DED recipients 1 year to depart from the U.S. President Trump has since provided a 1-year extension. It's estimated that there are between 840 and 3,600 of these recipients currently residing in the U.S. With H.R. 2821, my Democratic colleagues continue this assault basically on the rule of law in our immigration system by converting temporary protective measures into a path to U.S. citizenship. And of course, this effort would deprioritize thousands of other immigrants patiently waiting to become citizens. Proponents of H.R. 2821 will say that the aliens covered by the bill have been in the United States for many years and have strong roots in this country. Of course, the devil's in the details of any legislation, and the text of the bill actually applies to TPS holders from some countries that have been designated for less than 4 years. And it provides green cards to nationals of countries who had their TPS designation terminated by President Obama and who have already left the country. What's more, the bill allows nationals of TPS-designated countries who have never even applied for TPS or DED or who have already left the United States to obtain green cards. If that wasn't bad enough, the bill creates a grant program so U.S. taxpayers have to pay NGOs to help these aliens get their green cards. My colleagues couldn't even bring themselves to temper the open borders ideology for long enough to realize the only solution with a chance of becoming law are bipartisan. Republicans are at the negotiating table alone. We must address the border crisis. President Obama recognized it when it was a fraction of as chaotic as it is now. Part of securing our borders means acknowledging statutory immigration protections Congress intended to be temporary when they were created should not be converted by administrative action or by statute into paths for foreign nationals to remain in the U.S. indefinitely. I oppose H.R. 2821 and urge my colleagues to do the same. With that, I yield back.
Thank you, Mr. Collins. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2821, offered by Mr. Nadler.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. Most of the changes in this amendment are of a technical nature and do not affect the substance of the bill. In addition, the amendment in the nature of a substitute makes two substantive, though modest, changes. The first clarifies that the bill's humanitarian waiver is not available if it relates to a criminal conviction that otherwise renders the applicant ineligible for relief under other provisions of the bill, including the requirement that the applicant not have a conviction for a felony or for any 2 misdemeanors. The second revises the bill's list specifying the types of evidence that may be submitted to prove earned income. As amended, the measure allows applicants to submit employer records in addition to records of earned income maintained by the federal government. These are modest but necessary revisions, and I urge my colleagues to support the amendment. I will now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment in the nature of a substitute.
No, we recognize the nature of substitute, and we're fine. We're good.
Okay. Are there any amendments to the amendment in the nature of a substitute? Gentleman from Virginia, for what purpose does the gentleman from Virginia seek recognition?
Mr. Chairman, I have an amendment at the desk.
I reserve
Gentleman
a
has
point
an
of
amendment
order.
at the desk. The clerk will report the amendment. The gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2821, offered by Mr. Klein. Page 2, line 25, strike
Without
2017.
objection, the amendment is considered as read. The gentleman from Virginia is recognized to explain his amendment.
Thank you, Mr. Chairman. This amendment is simple. It would simply strike 2017 and insert 2010. The TPS population includes both aliens who came to the United States many years ago and those who arrived only relatively recently. Some have lived in the United States for years, while others are present due to more recent TPS designations. For instance, Yemen and Nepal have only been designated for TPS for less than 4 years. This bill, H.R. 2821, as currently written, would legalize all TPS recipients regardless of how long they've resided in the United States. It would even give green cards to TPS countries that were terminated under the last administration. The temporary protected status population is not monolithic, yet this bill treats them as such. The bill also allows former TPS recipients from countries that have had their designations terminated and who have left the United States to get green cards. For instance, nationals of Sierra Leone, Guinea, and Liberia, which had their TPS designations terminated by President Obama when he determined that the Ebola crisis was over with, are now eligible for green cards under this bill. My amendment recognizes that those who were extended TPS only recently should not bypass our lawful immigration system to receive a green card. By setting the date at January 1st, 2010 instead of 2017, recently designated countries like Haiti, Nepal, South Sudan, Syria, and Yemen would not qualify for a green card under this bill, nor would the countries designated during the Ebola crisis, which were terminated under President Obama. At the same time, under my amendment, long-term TPS designated countries such as El Salvador, Somalia, and Honduras would still be included. I urge my colleagues to support the amendment, and I yield to the gentleman from Georgia.
Thank you. I just support the amendment. Again, it goes back to what appears to be is just we're trying to clear the TPS docket here. I get that. I know that this is going to have the votes to go forward. It's just, I believe, not a positive way to do this, especially when the actual status is temporary protected status and has been removed before. I think the amendment's a common sense amendment that would do so, that would protect what the chairman said earlier about those who have long-term, been here long-term roots in that part. But I think this goes back to really the differences that we have in how this is actually put together. And I support the gentleman's amendment and yield back.
I yield back my time, Mr. Chairman.
Seeks recognition. The gentlelady from California, for what purposes she seeks recognition?
First, I withdraw my reservation, and I would urge opposition to this amendment. The real impact of this amendment relates to several countries who would be stripped, or their country men would be stripped of protection, and I think it's important that we not do that. Let me just talk about some of them. First, Nepal. Nepal was designated as a TPS country, and President Obama extended it. It was a 7.8 magnitude earthquake that really devastated Nepal. The conditions in Nepal remain dire. For reasons I do not understand, President Trump terminated TPS for Nepal, even though that decision has now been put on hold by a federal court. Nepal has not recovered from this earthquake. Of the 2.8 million people originally displaced by the disaster, 2.6 remain in temporary shelters. The recovery efforts have been stalled by political conflicts that have blocked transportation of food and aid along the southern border. There are many at risk of starvation, including 3 million people, 3 million children under the age of 5. To add to their problems, during the summer and early fall of 2017, Nepal was further devastated by floods and landslides, which impacted about 1/3 of the country's population. So this is a country that has been hit by multiple disasters, and progress on recovery is limited, which has delayed the transportation of food, other resources to the country. It's destroyed dozens of schools and health centers. And the idea that this is a safe place, no problem in Nepal, people can be removed there, is just incorrect.
Would the gentlelady yield?
I'd like to finish, and then if I have time, I certainly will. I'd like to talk also about another country that would be excluded from protection, and that is Syria. We all know that Syria is not a safe place to be. We've seen the pictures of devastation, the barrel bombs that are falling on the population, the starvation that is occurring in Syria. TPS for Syria was first established in 2012 when the civil unrest unfolded into civil war. It was redesignated by the Obama administration in 2016. In January of 2018, for reasons, again, that I do not understand, the Trump administration announced its decision to extend but not redesignate TPS for Syria through September of this year. Former Secretary of Homeland Security Nielsen found it, quote, clear that the conditions upon which Syria's designation was based continue to exist. Syria is now in the 7th year of really a catastrophic civil war. More than 12 million people have been killed or displaced. And to think that, as a matter of fact, the State Department continues to urge U.S. citizens not to travel to Syria because of, and I quote, terrorism, civil unrest, kidnapping, and armed conflict. So they've also suggested, the State Department, that travelers who do go to Syria draft a will before going and arrange for their funerals before departing. So this is not a situation where people should be removed to Syria. They should be receive temporary protection. And I would like to also mention the situation of Yemen that would also be precluded from TPS. In Yemen, there is a famine that has attacked the children of Yemen. As a matter of fact, this body, the House and the Senate, took action that the president vetoed just a short while ago that recognized the catastrophe that is Yemen. To think that Yemenis who are here and have been in protected status should be returned to that country where there's no running water, there's no food, there's no healthcare system, there's no schools. It's just, it's not something that we should do. These temporary protected status should be extended to these countries. The amendment that's been offered would preclude protection for individuals from these countries. I realize my time has expired, but there will be an opportunity to give Mr. Klein an opportunity to respond to my comments, I'm sure. So at that, my time is over, and I yield back.
Mr. Chairman.
Gentlelady yields back. The gentleman, for what purpose is the gentleman from Georgia seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I yield to the gentleman from Virginia.
Thank you, Mr. Chairman, and I'll be brief. Just to make it clear, these countries, Nepal, Syria, Yemen, are in dire straits. I agree with the gentlelady completely, but they are currently under TPS status. In fact, the status was extended by President Trump for several of those countries. And so the difference and the question is whether these individuals currently under TPS status should now be eligible for green cards. And I would argue that they are not and should not be made eligible for green cards under this bill. Thank you.
Would the gentleman yield?
I yield.
I just want to note that the Syria designation was temporary. Nepal was, the only reason why the Nepalese are protected is by a federal court order. So I think the Trump administration did attempt to terminate that designation. I just wanted to clarify, and I thank the gentleman for yielding.
Reclaiming my time, I yield back.
Gentleman yields back. The question occurs on the gentlelady from Texas. For what purposes does the gentlelady from Texas seek recognition?
The last word.
Gentlelady is recognized.
Just 2 quick points. One, the children in Yemen are not only subjected to the harshness of what the gentlelady from California said, but they're also subjected to the indiscriminate bombing of school children, having lost 2 full buses of children by bombing from Saudi Arabia, and with no explanation of how that happened. But I do want to make mention of a country that unfortunately has suffered greatly and has not recovered. For those of us who visited Haiti during the magnitude of one of the most horrific earthquakes in the world, 7.0 magnitude, that resulted in widespread devastation, of which, frankly, they are still building or coming out of, not building, but coming out of the massive tents that existed, the lack of land, water, food, any opportunity to survive. President Obama redesignated TPS for Haiti in 2011 and extended the designation through his presidency, but President Trump announced the termination of TPS to Haiti in November 2017. And that decision to end the program had been placed on hold again through a federal court. So anyone that can look at the landscape of Haiti right now will know that there is no basis of ending their TPS status that has any sense of humanitarianism or any reality that there's any place for these individuals to go. I finished my remarks by saying, as I looked at the countries that would be part of this, part of immigration is the whole idea of national security and ensuring the homeland. And we complement that as members of the Judiciary Committee on the side that deals with the status of individuals. And in my recalling, I have not recalled, someone may want to correct me, terrorists from Nepal, Guinea, Sierra Leone, Liberia, and Haiti. I know that the people coming to Yemen are fleeing violence. So I just make the argument that I see Syria. Obviously, these people are here in the United States, and I have not seen any in the United States-based terrorism as it relates to Syria. And most of these people are refugees that are coming and fleeing violence. So I would just offer to the gentleman for his amendment is that I just cannot support it because I don't see the basis of denying these people TPS status, and I yield back.
The gentlelady yields back. The question occurs on the amendment. All those in favor of the amendment say aye. Aye. All opposed say no. No. In the opinion of the chair, the noes have it. A recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? No. Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? No. Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? No. Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? No. Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. McCarcel-Powell? No. Ms. McCarcel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomer? Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stube votes yes.
Has everyone voted who wishes to vote? The gentleman from Tennessee?
Mr. Cohen votes no.
Gentleman from Texas?
Mr. Gomert votes yes.
Anybody else? Has everyone voted who wishes to vote? The clerk will report.
Mr. Chairman, there are 9 ayes and 20 noes.
And the amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? Then the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor of the amendment in the nature of a substitute respond by saying aye. Aye. Those opposed, no. Nope. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. I ask unanimous consent to insert into the record statements made by the Latin America Working Group, the National TPS Alliance, 2 articles by the Center for American Progress, and 8 reports by the Catholic Legal Immigration Network on TPS countries. Without objection, they will be inserted into the record. A reporting quorum being present, the question is on the motion to report the bill H.R. 2821 as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. Nope. The ayes have it, and the bill is ordered reported favorably. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes yes. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes yes. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Buck? Mr. Buck votes no. Mr. Radcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Stube? Mr. Stube votes no.
Mr. Neguse.
Oh, has he voted?
Mr. Neguse is recorded as aye.
Oh, excuse me.
Pardon me.
Are there any other members who wish to vote who haven't voted yet? The clerk will report. okay. It's not the worst thing in the world.
Mr. Chairman, there are 20 ayes and 9 noes.
The ayes have it. The bill is amended, is ordered reported favorably to the House. Members will have... We have one more to go. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments. Without objection, staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 549, the Venezuela TPS Act of 2019, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 549, to designate Venezuela under Section 244 of the Immigration and Nationality Act to permit nationals of Venezuela to be eligible for temporary protected status under such sections and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. As we know from our consideration of the Promise Act, temporary protected status, TPS, provides relief from removal to persons in the United States who are unable to return to their country because of armed conflict, environmental disaster, or other extraordinary conditions. Venezuela, once one of Latin America's most prosperous countries, is now in the throes of a political crisis in which its people are being starved, beaten, and murdered. That makes it essential that we now designate Venezuela for TPS. This is not a partisan issue. It is uncontested that a political and humanitarian disaster is unfolding in Venezuela. Just last week, the Department of Homeland Security suspended all commercial passenger and cargo flights to Venezuela because the conditions there are so severe that the safety and security of passengers and crew cannot be guaranteed. This situation is exactly the type of humanitarian crisis that TPS was designed to address. For this reason alone, we should support this bill. Venezuela has experienced economic and political turmoil for years, largely due to mismanagement of the economy, plunging oil prices, and political instability. Unfortunately, the situation has recently worsened. Families live without regular access to food, medicine, and clean water. There is increasing violence and crippling economic insecurity, and the nation's leaders are currently locked in a power struggle over who is the legitimate president. As a result, the people of Venezuela are suffering immensely. Last month, I traveled to the Venezuela-Colombia border along with Ms. Lofgren, Ms. Jayapal, and a bipartisan group of members from the Foreign Affairs Committee. We visited a soup kitchen in Colombia where thousands of Venezuelan families receive meals. While there, I talked to a young father who lost his job at a Venezuelan oil company. Unable to find other work, he had no choice but to go to Colombia to find work as a day laborer. Every dollar he earns is put towards food for his wife and children back in Venezuela. That father is one of the more than 3 million people who have fled Venezuela since 2015. 3 million people have fled the country in the last 3.5 years, the vast majority finding refuge in South America. Others have come to the United States to find protection. The Trump administration could and should provide that protection by designating Venezuela for TPS. But because the President has failed to act, it is our duty to do so now. TPS was created in the Immigration Act of 1990, which was signed into law by President George H.W. Bush. Since then, both Democrats and Republicans have recognized our duty to provide relief and a temporary haven to individuals and families fleeing conflict and violence. I would like to commend my colleagues Darren Soto, Debbie Mucarsel-Powell, and Debbie Wasserman-Schultz for their work on this bipartisan measure and for their commitment to the Venezuelan community in the United States. Until political, economic, and food security are restored, Venezuelans need our protection. We have the capacity to offer that protection now with the Venezuela TPS Act of 2019. This is, as I said before, not a partisan issue. Everybody in all political parties recognizes the dire situation in Venezuela. Most people are united in understanding the nature of the political crisis down there that is causing the the economic and social crisis. We have the capacity to offer that protection now with the Venezuela TPS Act of 2019, and I urge all my colleagues to support this important legislation. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. H.R. 549 statutorily designates Venezuela for TPS, or Temporary Protected Status. Pursuant to the Immigration Nationality Act, and the DHS Secretary can designate a country for this TPS if the circumstances would prevent the safe return of aliens to that country, or if that country is temporarily unable to adequately handle that. We just got through dealing with this in a bigger form just in the last bill. And the effect of the TPS designation is these nationals in a designated country who are in the United States on the date of such designation, whether here legally or illegally, may apply, stay here, and receive employment authorization. An interesting fact, DHS has estimated there's 270,000 such Venezuelan nationals currently in the U.S. 123,000 of those are here illegally. It should be noted that the reason that they are here and the reason that we're having to deal with this is the very unstable country that has been done so by a socialist economy and socialist regime that has basically destroyed their own country. This is hopefully a temporary designation, and why I hope that in just a few moments, as the temporary protected status says, temporary should be the operative word, not long-term, that the chairman and others would support an amendment that I have here. Remember, there's no doubt the Venezuelan people are suffering. There's no doubt anybody here would say that. In fact, we want to see that happen. We want to see their change. We want to see their country back to the way it was. However, socialism has killed it, and that's what's denying personal freedom, destroying the society, and undermining the whole social fabric that we see. Consequently, I would hope that as we look at this, I believe we should consider statutory designation for Venezuela for TPS. However, it needs to be temporary. We want their country back the way it should be and people not having to come here. What we have just found out in just the last few minutes is we blanketly passed a bill granting green cards to those who are currently under this designation. I would just almost say that if we don't put a temporary in this, if we leave the T out of this, then we might as well just save ourselves some time, change the wording of this, offer an amendment just to give anyone from Venezuela a green card that wants to come, because that's exactly what's going to happen. If you want to do that, offer the amendment, because that's exactly what happened. Because 20 years from now, in this Judiciary Committee, maybe some of the members will be here, there'll be a bill that says the temporary protected status for Venezuela, we're trying to make it, as we just did in the previous bill, permanent. So, you know, if that's what we're going to do, we're going to jump in front of the line for all those who've tried to do it legally. We're going to jump the line because they have a situation in which socialism is destroying a country, and we're going to put temporary protected status on it. Either make sure we do the T, the temporary part, or let's just jump ahead. Let's go to the end result here and just offer green cards from anyone from Venezuela that wants to come, because that's where we're headed after especially the last bill and now with this one. So I just say H.R. 549 is currently drafted. I want to support those in Venezuela running from that regime. I want that regime to change, but I would hope that they would work with me to amend this bill and well-intentioned bill so that we can move forward this evening. With that, I yield back.
Thank you, Mr. Collins. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 549, offered by Mr. Nadler. Strike all that follows after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment simply strikes two sections of the underlying bill. Section 2, which consists solely of congressional findings, and Section 3, which contains only senses of Congress. Otherwise, the substantive provisions in Section 4 of the underlying bill remain unchanged, and I urge my colleagues to support the amendment. I want to add that no one doubts that there is a disaster unfolding in Venezuela. No one doubts it is to a large extent due to the incompetence of the current government. I would simply note that I disagree. We're not going to debate this now, but I disagree that it's particularly socialism that is destroying that country, but that's a different question. I urge my colleagues to support the amendment in the nature of a substitute. I will now recognize...
Would the gentleman yield?
I will...
We don't yield on openness.
We don't? What? I will now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have in the amendment.
No comments.
The gentleman, very well. Are there any amendments to the amendment?
Mr.
Mr. Chairman.
Mr. Chairman, I'd like to strike the last word.
Okay. I was going to say, are there any amendments in the amendment? Are there any amendments to the amendment in the nature of a substitute? For what purpose does the gentlelady from California seek recognition?
Well, I just want to say something. I to strike the last word.
Gentlelady is recognized.
This is an important, really, an essential, a life-saving bill. And obviously, the author is our colleague, Mr. Soto, and we have, several Floridians, Ms. Demings, Mr. Deutsch, but the person who deserves credit, and I don't know that she will be willing to speak up for herself, is Congressman Markup Powell, who has been an unbelievable advocate for this bill on the floor in this committee. Really, I think without her tremendous effort, I don't know that we would be as far along in this process as we are today. So I didn't want to, I didn't give an opening statement, but sometimes modest people don't claim the credit that they are due, but she deserves unbelievable amounts of credit. So I wanted to take the time to recognize that.
Would the gentlelady yield?
I would be happy to yield.
I simply want to second the remarks of the gentlelady from California. The advocacy for this bill by Ms. Markup Powell has been steady, persistent, and forceful, and informed, and we probably wouldn't have this bill before us right now if it weren't for that. So I want to acknowledge that. I yield back to the gentlelady.
Will the gentlelady yield?
I would be happy to yield.
I would, thank you. I thank my friend. I would just like to say, for the benefit of this committee, that in South Florida, the issue of Venezuela is a local issue as well as it is an international issue. And members of the Venezuelan community, so many of them in our own communities, wake every day worried about their family back home and go to bed every night worried about their family back home. And for those who are in our community who are there because of this horrific situation that Maduro has wrought, it is their good fortune, frankly, that they have a representative and we have a colleague like Ms. Markup Powell who has fought so hard for them that has allowed us to get to this point. And I appreciate the opportunity to say that, and I yield back.
And reclaiming my time, as the chairman said, we did go to the Colombian-Venezuela border, and we saw the very thin Venezuelans who were coming across the border to get something to eat, coming every day, waiting for hours before they went back home to Venezuela. This is a tragic situation. And the idea that we would even consider returning people to that basket case of a country is just inconceivable. So thank you, Mr. Chairman, for allowing me to speak briefly. And I don't know if Ms. Markup Powell will get her own time, but I'd be happy to yield the remainder of my time in addition to her.
Thank you. I am so touched. It is really an honor for me to be able to serve with the chairman, the ranking chair, who are committed to making sure that they're listening to all the members, including the freshman class, and the issues that are so important not only to us in our own personal districts, but all over the world. So I am really, without words, I really thank that recognition. And yes, I move to strike the last word.
Are there any, the gentlelady yields back? Oh, the gentlelady from California yields back.
Correct.
For what purpose does the gentlelady from Florida seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. H.R. 549, the Venezuelan TPS Act of 2019, is a vitally important bill that aims to provide help and support to those fleeing the crisis in Venezuela. There are millions of Venezuelans who have fled Venezuela to escape the catastrophe that the Maduro regime has caused. The poverty rate in Venezuela is soaring, and the nation's health system has collapsed. Nearly a third of Venezuelan physicians have fled the country, and an astounding 79% of hospitals are experiencing shortages in supplies to assist the country's mounting medical needs. This dire situation is only exacerbated by massive food and water shortages. Venezuelans do not have food to eat, especially children and women who are pregnant. Frequent nationwide blackouts contribute to the deterioration of already impoverished communities. This is one of the worst humanitarian crises that we have faced in the Western Hemisphere. The Temporary Protected Status Statute was created for this exact situation. It is designed for people from a country with an ongoing armed conflict, a country suffering from an environmental disaster, or in the case of Venezuela, extraordinary or temporary conditions that prevent its nationals from safely returning. My district has one of the largest Venezuelan populations in the nation, and I understand this crisis very well, having come from Ecuador at the age of 14, having seen firsthand the damage that authoritarian and corrupt leaders in South America have caused their countries. I still have very good friends that are living in Caracas, and I have some extended family that are living in Maracaibo, and I can tell you that I hear the desperation in their voices anytime they can update me on the crisis. One thing is clear: we have to help our Venezuelan brothers and sisters in the United States. This administration has been unwilling to do that. We have spoken to the administration, we have sent letters urging TPS for Venezuelans, but nothing has been done. We in Congress have exhausted the avenues with the executive branch. The administration's failure to act makes this bill necessary. We have heard from both sides about the need to assist Venezuelans, but we have the power to do so right now to help the Venezuelans that are living in this country. We must pass H.R. 549 to ensure that Venezuelans in the United States are safe from the disaster in their country. I strongly urge my colleagues to support this bill. I yield back.
The gentlelady for yielding, and before we get to an amendment, I'd like to recognize the gentlelady from Pennsylvania.
Thank you.
For what purpose do you?
I move to strike the last word.
The last word is duly struck. The gentlelady is recognized.
I just wanted to thank Emilio Buitrago, Fernando Torres, Diaba Melendez, and Rosana Ortega for traveling to D.C. today to represent the 10,000 to 12,000 members of the Venezuelan community who are in the greater Philadelphia region. I'm proud to represent this highly qualified, hardworking community who've been seeking safety from the disastrous conditions in their home country and contributing their many talents to our country. I wanted to note that Amelia, who is now a U.S. citizen, came here today after working 18 hours at the polls yesterday in Pennsylvania. He has a passionate belief in our democracy and a commitment to upholding the rule of law in this, his adopted country, so I thank them.
Are there any amendments to the amendment in the nature of a substitute? Oh, before we get to amendments, the gentleman from Maryland.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman is recognized.
But I wanted first to salute Congresswoman Debbie Mucaso-Powell for her magnificent leadership here. Her constituents in Florida are very well served by her passionate advocacy and commitment to improving the quality of life for all of her constituents. So we all salute you, and I'm delighted that we can rise to the occasion through this legislation to help deal with the crisis caused by what the Congresswoman correctly describes as the authoritarianism and the corruption in Venezuela. And I notice her language is different from that of our esteemed ranking member, who said that the people leaving are fleeing socialism. If that were the case, of course, you would have millions of people fleeing universal health care and paid maternity and family leave and 12-week vacations in Sweden, Denmark, and Norway, but we're not getting that. So I'm not someone who's a socialist, and I love to talk to my friend Congresswoman Ocasio-Cortez about why not, but in any event, I think we should be clearer in our use of political terminology. The people fleeing Venezuela are fleeing corruption and violence, and it would be just as wrong to say that the people who arrive here from Civil War-torn Salvador or Guatemala or Haiti were fleeing capitalism. They weren't fleeing an economic system, they were fleeing terrible conditions, social conditions there, and I think that's the same thing in Venezuela. There are very stable totalitarian regimes like the one President Trump loves in North Korea, the communist totalitarian government of Kim Jong-un, which he has praised, people can't even get out there. So the question of exodus and flight is different from the question of the character of economic systems. But in any event, America is rising to the occasion to stand up for people who are fleeing terrible conditions around the world, and I'm proud to support this legislation. I yield to my friend from Pennsylvania, Congresswoman Dean.
I thank my friend from Maryland, and I want to just associate myself with the good words of members of this committee who raise you up in terms of your advocacy for the people of Venezuela and for H.R. 549. You know, as I sit here today with this very long markup on 3 very important bills, I think that we as public servants, we as elected, are faced with a single question every single day. Will you do something for the good of others? Will you do something for the good of others? This is an extraordinary piece of legislation that does something for the good of others, that lifts up the vulnerable, those who are harmed. So I add my voice to this. Like my friend and colleague from Pennsylvania, I too was visited in my district office by now American citizens who told me of the plight of their families in Venezuela with lack of adequate food, lack of access to clean water, lack of access to energy, electricity, the stench from a local morgue that had no electricity. These people talked about their parents and their grandparents, their family members and their friends whose lives were in danger and whose public health was in danger. So I just add my voice that here we are, a chance to do something good. We must designate Venezuela for TPS, and not in any hurried way, but in a way that is meaningful and lasting and saves lives. Thank you. I yield back. I will yield. I yield to Mr. Neguse and then on.
I would just associate myself with the remarks of Representative Dean, and to again thank our colleague, Representative Musgrove-Powell, for her leadership in bringing this bill forward. And as Representative Dean said, I think the collection of these bills and the leadership of course, our chairwoman of the Immigration Subcommittee, Representative Lofgren, and Representative Jayapal, who has worked night and day tirelessly, not just in Congress, but long before she arrived in Congress on these issues. As most of my colleagues know, I'm the son of immigrants, of refugees who fled a war-torn country in East Africa many years ago. And so as I think about the countless lives that will be touched by each and every one of these bills, I think we can all look back on this evening, this long evening, with great pride as we worked through this markup in delivering the promise of the American dream to countless people across this great country. And with that, I would yield to the distinguished gentleman from Rhode Island.
Thank you. I, too, want to thank our colleague, Congresswoman Musgrove-Powell, for her extraordinary advocacy. It was really magnificent to watch over the last several weeks in particular how persistent she was, and this markup is a direct result of her love of her community and her hard work. And I hope we can send a strong bipartisan message by swiftly passing this bill and letting the Venezuelan people and the world know America remains true to its values. And with that, I yield back.
Gentleman yields back. Are there any amendments to the amendment in the nature of a substitute?
Mr. Chairman, I have an amendment.
Gentleman from Georgia is recognized for the purpose of offering an amendment. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 549, offered by Mr. Collins of Georgia.
Without objection, the amendment will be considered as read.
Chairman, I reserve a point of order.
The gentlelady reserves a point of order. The gentleman from Georgia is recognized for the purpose of explaining his amendment.
Thank you, Mr. Chairman. I won't take a long time on this, and I think this goes back to nothing. And I want to also add my, thanks to Ms. Markup Powell and others in the work on this. This is a difficult situation. Others have talked about this for a variety of reasons. I appreciate, her work on this and bringing it forward. I think what we have seen here, though, is the reason for my amendment, and I appreciate this work, is just to make the temporary back to temporary. Is make sure that we move this so that the temporary protected status goes back to temporary, and not, as the chairman said in his opening statement on the bill previously, that where roots and families are dug in after years of extension into where the temporary protected status is no longer temporary. It becomes just another pathway to a legalization as we go here. So simply all this says is the amendment would allow the executive to retain initial authority to designate a country for TPS, but then would require the secretary to report to Congress with a recommendation of whether or not to extend TPS. Congress, not the executive branch, would then decide whether to extend TPS, again, after the initial designation. Again, no change in the status quo. The executive still does that, but if there's a conversation that happens in this committee a lot is when does the temporary end, and we end up in problems that are difficult for both sides. Because after a while, there are areas where people have been here for a long amount of time after the temporary designation has even been lifted or they could have gone back. It just presents problems, and as long as we're going to have TPS as a program, I just believe the temporary ought to be part, and if it's not going to be temporary, this body ought to be the ones that extend it out. And so remember, it's very simple. It has nothing to do, and I appreciate the intent of what has been done as far as going along with this. I wish that I thought it would be temporary. I don't think it will be. That's why I'm offering this amendment. I would encourage my colleagues on both sides of the aisle to join me if we continue to have the temporary part as temporary. As long as T is part of the temporary protected status, I would encourage us to at least say, let us have a part in extending it and not just having an uncertainty that goes on in the administrations over and over and ending up putting a problem in our lap that administrations come and go and we're the ones that end up having to deal with it. And with that, I yield back.
The gentleman yields back.
Mr.
Does the
Chairman?
gentlelady insist on a point of order?
I do. I believe that this amendment expands the scope of the underlying bill by attempting to deal with individuals who are not covered by the HR 549 and amending the underlying Immigration and Nationality Act to do so, which is not before us. So I think it is not germane and it is beyond the scope of the underlying bill.
Does the gentleman seek to be heard on the point of order?
I do believe this is, well, I think this amendment actually does apply to this because we are dealing with the temporary protected status. I know it says an expansion of 244, but that, again, in this protected status, the temporary is part of this, and we're just simply taking a discretionary part away from the executive and having to bring it back to us for an approval. I think it is germane to the bill, and we just
Mr. Chairman?
The chair is.
I'm not done.
Oh, I'm so
Just follow,
sorry.
please.
Pardon me.
Mr. Chairman, if there continues to be the point of order, and the gentlelady, I appreciate, and it has been really good at this all day, bringing this up, I would be willing, and orally we could do this if agreed by unanimous consent, to narrowly tailor it to just this specific one. If there's a concern that it is too broad, I will then offer to say that we will word this to where it applies to this, that under this act, it applies to this act and this act only. If she, if the gentlelady continues to uphold her point of order.
Well, it's not germane. You could redraft it, but if you redrafted it, I would also oppose it.
Okay,
So-
opposing is not the problem, and I understand that we've done this many times. But the question is I will make an oral amendment, and if it's accepted,
I think the last time we did an oral
We did.
amendment
Well, let's
ended
put it
up
down.
with a problem. So I think if
we
you
will
want-
withdraw. We will
yeah.
withdraw at this time and amend.
The amendment is withdrawn. Are there any other amendments to the amendment in the nature of a substitute? Gentleman from
Pennsylvania.
Gentleman from Pennsylvania. For what purpose does gentleman from Pennsylvania seek recognition?
To offer an amendment.
Gentleman has an amendment at the desk. The clerk will report the
I
amendment.
reserve a point of order.
The gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 549, offered by Mr. Reschenthaler of Pennsylvania.
Does the gentleman, do I do the point of order first, or do I?
I think you hear from the author and then...
The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. I appreciate it. Mr. Chairman, this amendment adds a simple finding to this bill that puts the blame for Venezuela's economy, the humanitarian crisis, the security crisis, and the refugee crisis squarely where it belongs, and that is on socialism. It states that the crisis is the direct result of years of socialist policies implemented by the regimes of Hugo Chavez and Nicolas Maduro. Mr. Chairman, Venezuela should be the wealthiest country in the world. I'm sorry, in South America, the wealthiest country in South America.
Committee is not in order. Gentleman will proceed.
Thank you, Mr. Chairman. Venezuela used to be the wealthiest country in South America. It is gifted with vast oil reserves, and it should be thriving to this day. Yet it is currently experiencing, according to the New York Times, the worst economic collapse outside of war in the last half century. Venezuelans are experiencing shortages of food, medicine, and simple commodities. Inflation is set to reach 10 million% this year. Just think about that, 10 million% in inflation. A tenth of the population, again, 1/10 of the population, has fled the country due to the crisis and the collapse of the government. Just a few months ago, I was on the border of Venezuela and Colombia, and I was watching as Venezuelans crossed over into Colombia. It was heartbreaking, to say the least. I talked to many of the refugees who were talking about the conditions they fled from. I heard stories of physicians carrying out surgeries with smartphone lights because the power was going out during the middle of surgeries. I was talking to individuals who said there were folks dying because they couldn't get simple penicillin. And to this day, 5% of the Colombian population is actually Venezuelan refugees. It truly is a crisis on a scale that I think a lot of people do not recognize. And what has caused this? Well, according to the New York Times, economists attribute the collapse to poor government, corruption, and the misguided socialist policies of Nicolas Maduro and before him, Hugo Chavez. All was well in Venezuela until the United States started exporting natural gas, which dropped the price of the commodity crude oil and exposed flaws in the communist and socialist economy that Maduro had in place. So it's been proven over and over and over again that socialism leads to ruinous results. I urge my colleagues to call the Venezuelan crisis for what it is, the results of unfettered socialist policies. I would urge my colleagues to support this amendment. Thank you, Mr. Chairman.
Does the gentlelady insist on a point of order?
I do, Mr. Chairman. As you'll note, in the amendment in the nature of a substitute, there are no findings, and that's for a reason. We want to focus in on the actual needs of the Venezuelans who are stranded here, not get into a foreign policy debate. It's not germane. I would call the Maduro regime a thugocracy. They are clearly abusive. I don't know that they have any ideology except they want to stay in power. They're willing to kill people to keep that power, and they're thugs, and they should be removed. That's my view, but that's just a personal opinion. It's not part of this bill. This amendment is not germane, and I would insist on my point of order.
Mr. Chairman. Does the gentleman wish to be heard on the point of order? Sponsor of the amendment.
Thank you, Mr. Chairman. Mr. Chairman, the underlying measure would provide a temporary protective status for Venezuelan citizens. And the amendment makes a finding about the cause of the underlying emergency that has caused the need for this legislation. This is an expression of policy that is closely related to the underlying measure and safely within the scope. This is fully and specifically supported by the precedents of the House, specifically Dester's Volume 11, Chapter 28, Section 2.30. If the chairman would like, I would be happy to recite this precedent.
The chair is prepared to rule on the point of order.
Mr. Chairman, doesn't he get 5 minutes to speak on this?
I thought he had finished.
You already had.
Well, Mr. Chairman, I'd like to read the actual section.
think he had
The
5
gentleman
minutes.
is
Doesn't he have 5
recognized.
minutes to
The
speak?
gentleman is recognized.
Mr. Chairman, can I have more time since that?
He didn't speak for 5 minutes on this.
The gentleman,
Mr. Chairman.
on this? All right, the
I
gentleman is
just
recognized.
want to read the rule. So section 2.30, to substitute dealing with humanitarian and evacuation assistance to war victims in Vietnam, perfected by amendment to prohibit such assistance to specified groups, a further amendment stating that the necessity for the relief provided has been caused by the actions of the groups denied assistance was held germane as an expression of foreign policy not extending beyond the purposes of the perfected proposition. Now, I've been sitting here and I've been hearing from across the aisle about the humanitarian crisis. I think it is a humanitarian crisis. In fact, a lot of my colleagues on the other side of the aisle voted with me in foreign affairs on this very issue. We've been talking about the underlying crisis. There's precedent to discuss the underlying crisis, and I think in the rules, it's clear that I can offer this amendment. And I would yield the balance of my time to the gentleman from Ohio.
Thank you. I thank the gentleman for yielding. I would note in support of the gentleman's point of order that the chairman stated himself a little while ago that he did not think that socialism had anything to do with the disaster in Venezuela. When the gentleman offered this amendment, which basically states that socialism was at fault in the problems that Venezuela had, there were gasps of disbelief from our colleagues on the other side of the
Yes.
aisle. There are a couple of heads nodding just now, and it shows how far the party, the folks on the other side, have come in essentially becoming a party.
Will the gentleman yield?
It's not my time, but I'm speaking at this time. That they have basically embraced socialism, and it's unfortunate.
gentleman yield?
Because it's clear, not at this time. You know, it's clear, they don't want to acknowledge that socialism had anything to do with the humanitarian disaster in Venezuela. Yet corruption and mismanagement were the direct result. And the chair said, well, it might have been corruption, but not socialism. But
I wish to be
corruption
heard
and
on point of
mismanagement
order.
were the direct result of an increased, thank you, Mr. Chairman. Corruption and mismanagement were the direct result of increased government control of the economy. And that's what socialism is. So the gentleman from Pennsylvania is exactly right. And in reality, lower oil prices and U.S. sanctions and mismanagement and those other things that have been blamed weren't the cause of it. Instead, mass starvation and exodus faced by the Venezuelans are the natural consequences of the socialist policies implemented by a couple of dictators, Hugo Chavez and Nicolas Maduro. And they were out and out absolute socialists and in some cases communists. And the fact that the other side does not want to acknowledge that socialism had anything to do with the humanitarian disaster in Venezuela is pretty incomprehensible to a lot of folks on this side who didn't gasp when the gentleman offered this amendment.
Would the gentleman
The gentleman
yield?
is absolutely right. If the gentleman wants to yield, I'd be
Would
happy.
the gentleman yield?
No, I would just like to say again that when this issue was brought up in the past with Vietnam, this issue was ruled on. It was absolutely viewed as germane to talk about the underlying issue of why the TPS was being granted. I think that the crisis in Venezuela has been caused because for years it was propped up by a state-controlled economy that relied solely on petroleum. The price of petroleum has dropped largely because of U.S. exports of natural gas, and that has exposed flaws in a socialist country. And I think that we have the right to discuss the underlying cause of why we need to have this bill. So I don't know why my colleagues from across the aisle will not just call it what it is and say that this is due to socialist policies and a state-run economy.
Mr. Chairman.
Mr. Chairman, I yield back the balance of my time.
Mr.
Yes,
Chairman.
Gentlelady from Florida is recognized.
You know, thank you, Mr. Chairman. This is very dangerous, what you're doing here right now, and I would request that those words are stricken from the record. First of all, this amendment, yes. First of all, this amendment is not germane because your opinion doesn't constitute a finding, which is exactly what you've placed in this amendment, number one. Number two, the Maduro regime is an illegitimate regime. He held fraudulent elections. It is a narco regime, authoritarian regime. And let me tell you a few facts about Maduro that may sound a little familiar with the things that we're dealing here right now. Grab of power, circumventing other branches of government, violating the constitution of its country, arresting peaceful protesters, and enriching himself and his cronies because of failed economic policies. So I really, let's be very careful. You are talking about petroleum prices. That's one issue. But to make the determination that, first of all, that we don't recognize socialism, trying to label all of us as socialists, I denounce that firmly because it's your rhetoric to try to attack all Democrats, and it's false. So I do request, Mr. Chairman, that those words be stricken from the record.
Does the gentlewoman yield?
I yield.
And
The gentlelady will state the words.
Is there
The gentlelady will state the words she asked to be stricken from the record. And whether or not, the gentlelady will strike, will
His
describe-
opinion on the socialist policies implemented by the regimes of Chavez and
I'm
Maduro.
sorry, starting where?
Um,
That's true.
Well, the whole amendment.
The gentlelady will suspend. Gentlelady will suspend. Let me explain what's going on here. I am prepared to rule that this amendment is out of order as not germane. However, in the desire to be very accommodating to the minority, we are consulting with the parliamentarians, wherever they are, and we're killing time till we get an answer from them. But you cannot debate the nature of socialism or the merits of this on this bill. I mean, you can't debate it now.
And Chairman?
So we've
only
permitted.
debate the
I have been overly solicitous. I permitted debate by both sides. I really shouldn't have. So let's. The question before us is the germaneness of the amendment. As I said, I am prepared to rule that it is not germane, but we've asked for an opinion from the parliamentarians, and I will abide by that. But I'm not going to entertain a debate on foreign policy right now. So let's just suspend for a couple of minutes while we get an answer from the parliamentarians. Because this committee is not the proper place for foreign policy debate, period. We'll suspend for a few minutes.
Foreign policy. It's all about foreign policy today. Yeah, this whole amendment's about, the whole bill is about foreign policy.
Social organization.
Mr. Chairman, in an attempt to try to be helpful, I think what generally may be talking about is.
We're suspending.
All right. I'll be helpful by not being helpful.
We'll get a ruling in a few minutes. We'll proceed on that basis. I'm sure I do, but I want to.
No, I'm kidding.
Be fair.
Back in?
Yep,
Have they been told?
yeah.
They're doing it now. The committee will come back to order. Before we proceed, I want to remind everyone that it is not proper to impugn the motives of any member of the committee or any member of the House. And people should be very careful about that. We've had several complaints today on both sides of the aisle now. And I understand that it may not have been someone's intention, but people should be very careful in the heat of debate, in the heat of discussion, not to impugn the character or motive of any other member or anybody else for that matter. I'm prepared to rule on the point of order. The gentleman from Pennsylvania.
Well, Mr. Chairman, I'm clear that the ruling was that I did not impugn anybody's character, right? That is the ruling?
No.
No. I didn't say you had or anybody else had. I just reminded everybody that no one should. And you know whether you did or not. That's fine. Now, I'm prepared to rule on the point of order against the bill.
The amendment. Point of order against the
I'm sorry,
amendment.
point of order against the amendment.
Mr. Chairman, I'll withdraw the amendment.
The gentleman has withdrawn the amendment, and therefore, I need not rule on the germaneness or lack of germaneness of the amendment. The gentleman would like to be recognized to strike the last word.
Mr. Chairman, thank you. I did withdraw it, but I do just want to note that during the comment, I did not impugn anybody's character. In fact, I think the opposite was true, that my character was impugned. I think that words were put in my mouth. And as I read the case law to the committee, it's very clear that a very similar point was made in the past with Vietnam, and the ruling went the other way. And I think that a reading the black letter law and the case law on this would clearly indicate that the amendment was germane. We got to remember that for a temporary protective status, you have to consider what's going on in the country from which the person is applying the status. By definition, that would require discussions about what is going on in the home country. So again, I withdraw my amendment, but I still think that the discussion was above board, and I think the amendment was germane. I will say this, there were comments made about my amendment being dangerous. When it comes to Venezuela, I think the only thing that was dangerous was the vote that we took, not only in foreign affairs, but on the floor, to tie the administration's hands when it comes to assisting President Guaido. That is what's dangerous. And when I talk to
Point of order, Mr. Chairman. What has this got to do with, there's nothing pending before the committee. If you'd like to make a foreign policy speech, we finish our business.
I recognize the gentleman to withdraw and to make a short statement. It's not proper to debate foreign policy on this committee.
Well, Mr. Chairman, we're talking about immigration. The key to immigration is that
the gentleman withdrew his amendment? He's withdrawn the amendment. There is nothing. And
He struck the last word.
he struck the last word.
5 minutes.
Right. I just think when you're talking about immigration, key to immigration is talking about the country from which the immigrant is seeking TPS status. But I just will say this. I think it's somewhat misguided when we talk about Venezuela and we don't recognize the fact that in other committees on the floor, we voted to tie the hands of the administration dealing with Venezuela and voted to prevent the use of us assisting President Guaido and trying to overthrow Maduro. So I just think it's, I just want that noted.
Would the gentleman yield for just a quick comment, please?
Yes.
I just wanted to speak, the parliamentarians, and I know you're a relatively new member, the parliamentarians are completely apolitical. Sometimes they rule ways you don't like, sometimes they rule the way you do like. And we waited for them to make a ruling. I know that you didn't mean to impugn their character in any way, but it's important that the officers of the House, who are not partisans in any way, have our respect when they reach decisions, and I just wanted to comment on it, since you are a relatively new
Would the
member, may not
gentleman-
understand the role
Would the
that
gentleman
they
yield to me?
play.
I would yield to the gentleman from Ohio.
I thank the gentleman for yielding. I'll make a quick point here. The chair said that, we're not going to talk about foreign affairs here. You know, we've been talking about Venezuela. We've been talking about a whole bunch of other countries. We're talking about Mexico, which is not part of the United States. These are foreign entities that we're talking about. So if the gentleman in his 5 minutes wants to bring up Vietnam or he wants to bring up some other country, he's got every right to do that. You may not
Parliamentary
like-
inquiry,
You
Mr.
may not
Chairman.
like the point that he's making. You may not like the way he's getting there, but it's up to him. Members in this committee get to use their time basically the way they want to, unless they impugn another person, which you're not allowed to do. And generally, we don't, and we shouldn't. So I thank the gentleman for yielding. And
Does the gentleman yield back?
Mr. Chairman, I'd yield back the remainder of my time.
Gentleman yields back.
Point of order.
Gentleman will state his point of order.
Since the chair has ruled we can't discuss foreign matters, do you intend to strike foreign countries from the amendment in the nature of a substitute?
It is not a point of order, nor is it even a proper parliamentary inquiry. Without the question, are there any further amendments?
Mr. Chairman.
What was the ruling on the motion to strike the language? That's what we took.
There was
along.
no ruling on a motion to strike the language. The gentlelady is recognized. For what purpose is gentlelady?
Strike the last
Oh, he ignored the motion to strike.
Gentlelady is recognized.
First of all, let me thank the gentleman for withdrawing his amendment. I think it is important to recognize that we have people who are desperately in need, and that the different views that may be held are not to be conflicted with what we're doing. I wanted to take the time to thank Ms. Michelle Powell for her great leadership, excuse my voice, and also Congressman Soto, I thought was in the audience, and I know that he has worked so very hard on this legislation, and you have a wonderful partner in our colleague from Florida, and I wanted to make note of that. I just wanted to say that Venezuela did have some good days, and that's why I think it is important to focus on the needs of the people now, and to attribute any particular political view does not affirm or improve the devastation that Venezuelans are now experiencing. And so I just wanted to take note of a particular point of the turmoil that Venezuela is in, and that the need for this legislation to move as quickly as possible because of the many people here needing relief. I visited Venezuela in whatever political leadership it had, that it was a prosperous nation. I think now we have an oppression of both the life and the survival of people in Venezuela, and I ask my colleagues to support the underlying legislation. Thank the gentlelady from Florida for her leadership. I know she's getting a lot of applause, and thank the gentleman from Florida, Mr. Soto. I yield back.
The question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote and final passage of the bill. All those in favor of the amendment in the nature of a substitute respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 549 is amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes yes. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye.
What?
Mr. Correa? Mr. Correa votes aye.
Where?
Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Yes.
Ms. Garcia votes yes. Mr. Neguse? Mr. Neguse votes yes. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Mucarsel-Powell?
Yes.
Ms. Mucarsel-Powell votes yes. Ms. Escobar?
Yes.
Ms. Escobar votes yes. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes no. Ms. Jackson Lee, you are recorded as aye. Mr. Chairman, there are 20 ayes and 9 noes.
The ayes have it. The bill is amended as ordered reported.
Mr. Chairman.
Favor-
Mr. Chairman.
Bill is amended as ordered
Chairman,
reported
parliamentary
favorably
inquiry.
to the House.
Parliamentary
Members will
inquiry.
have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and without objection, staff is authorized to make technical and conforming changes.
Parliamentary inquiry, Mr. Chairman.
Gentleman will state his committee will come to order in order to hear the gentleman's parliamentary inquiry.
Mr. Chairman, is it the practice of this committee to allow demonstrations either for or against legislation as is passed in the committee?
No, and I have not done that. I banged the gavel. We have maintained control as much as possible.
Could the chairman tell the audience before a hearing what they're allowed and not allowed to do? And
When
that's-
it seems indicated, we will do so.
All right, we
I think in
appreciate
general,
Well,
things
this
went
is the
very
third
good.
time today, and it's not been noticed, and the chair's done
This
nothing about it.
conclude- I would remind people that demonstrations are not in order.
That's it?
I will also state that as far as I know, Mr. Reschenthaler didn't impugn anybody's motives. This concludes our business for today. Thanks to all of our members for attending. The markup is adjourned.